Hansard ready? Okay. I declare open this meeting of the Education and Employment Legislation Committee on Wednesday 6th of April 2022. The Senate has referred to the committee the particulars of proposed expenditure for 2022-23 and certain other documents for education and employment and industrial relations matters within the Attorney General's portfolio and the education, skills and employment portfolio. The committee may also examine the annual reports of departments and agencies appearing before it. The committee has decided that answers to questions on notice will be required to be returned by close of business on Friday, 27th of May. The committee has resolved that written questions on notice should be received from senators by close of business on Thursday, 14th April. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected from parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at Senate estimates. Any questions going to the operations of financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purposes of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has resolved also that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked the officer to superior officers or to a minister. The resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I draw the attention of witnesses to an order of the Senate of 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. An officer called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones. Mobile phones should be switched to silent. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure the budget estimates 2022-23 hearings are conducted in a safe environment. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. Today, the committee's focus will be on education, skills and employment, including industrial relation matters, under the responsibility of the Attorney General's Department. I welcome the Assistant Minister for Industrial Relations, Senator the Honourable Amanda Stoker. I would also like to welcome representatives from the Attorney General's Department. Minister Stoker, do you wish to make an opening statement?
No, thank you, Chair.
Thank you. So we will begin with questioning of the representatives from the Australian Building and Construction Commission. Mr McBurney, would you like to make an opening statement?
No, thank you, Chair.
Thank you, Chair. Well, we'll go straight to questions then, and I'll go to Senator Pratt.
Good morning. Commissioner McBurney, my questions today are in relation to the recent court case involving Lendlease taking action against you. Justice Snedden has recently handed down his decision in the Lendlease Building Contractors versus the ABCC. As you'd be aware, in that decision, the Justice referred to the clause of the building code in question as being poorly drafted and unclear, and the drafting as unfortunate. Justice Snedden upheld the ABCC's position that all union logos, mottos and indicia should be banned from clothing, property or equipment supplied by employers, irrespective of context and whether or not the material refers to freedom of association. This means, as I understand it, that every single instance of a union logo or phrases such as join your union or union proud or the presence of a Eureka flag is a contravention of the building code. I understand the CFMEU intends to appeal this. So can I now ask, if the CFMEU does appeal, does the ABCC intend to enforce its interpretation of clause 13(2)(j) of the Building Code, which is a blanket ban on union materials on sites?
Stephen McBurney, Commissioner, ABCC. Senator, the short answer to your question is yes.
Does the ABCC take this position because it knows that a ban will prevent the union from communicating with its members on political matters in the lead up to the election?
No.
Does the ABCC intend to force the removal of posters directed to safety matters if they have a union logo, motto or indicia on them pending appeal?
So on the question of the specific question you've asked is the application of 13(2)(j) to a specific example. I'll just ask my National Manager Building Code, Janine Drennan, to address you on that question, Senator.
Janine Drennan, National Manager Building Code. Can I ask you to repeat the question, please?
Does the ABCC intend to enforce the removal of posters directed to safety matters if they have a union logo, motto or indicia on them pending appeal?
Sure. So I might just explain. The code doesn't provide a blanket ban of posters. The code applies to code-covered contractors on building sites where the code applies to them, and only in relation to clothing, property or equipment that they supply or provide on site. So it doesn't apply to employees, for example. They're free to apply union logos, mottos or indicia to their own clothing, property or equipment. Equally on sites where the code doesn't apply, union logos are still...
Okay, so let me... If you've got a union and employer poster that has both the union and the employer's logo on it, that reminds people that sexual harassment is banned in a workplace, what is the status of material like that?
Sure. So the code regulates industrial relations, so it doesn't specifically talk about sexual harassment, for example. However, code-covered contractors are free to put up posters about sexual harassment, provided that they don't include logos, mottos or indicia, because in that case, the logo, motto or indicia, if it was applied to their equipment, would be a breach. But they're free...
No, so just if I put up a poster in a crib room, is that... will that be taken down or not, that has both the employer and a union logo on it that's promoting mental health or preventing sexual harassment? Is or is that not to be taken down?
So the ABCC doesn't direct contractors to take down material. If we find, or if we do an audit or an inspection, we put alleged breaches to the contractor.
Would it be an alleged breach that you would put to the contractor?
If there was a poster, for example, that contained a logo, motto or indicia, and it was applied...
The example I'm giving does have a logo on it of both the employer and the union.
Yes. So if the poster has a logo, motto or indicia and it's applied to the property of the code-covered contractor, the ABCC, if it found evidence of those posters during its audits, we'd put that evidence to the contractor. They'd then have an opportunity to rectify.
So you would ask them to take it down. Why would you ask them to take it down? What's the purpose of taking down a union? Is it just the regulation? Or is it because it's against the regulation, or is there... I would have thought having material that has broad buy-in from the employer, from the workforce through the union, that calls out sexual harassment or talks about how to reach out to your mate. For example, if you routinely see mates in construction that would have employer and union logos on it, why would you take that down?
The poster can stay up, the logo can't, Senator, is the short answer. And if the poster has the logo of the union or the logo of the MBA, an employer association, 13(2)(j) applies equally to both, and that's the way we have interpreted it. You've asked about the Lend-Lease decision. What the Lend-Lease decision does is maintain the status quo. It maintains the guidance we've provided to industry since 2018, and the decision of Justice Snowden makes clear that the guidance we've previously published applies to the display of union logos, mottos and indicia on property or equipment supplied by the employer.
What if it's a charity drive organised and sponsored by the CFMEU?
The charity poster can go up. The union logo, or indeed an employer association logo, cannot if it's to be applied to equipment provided by the employer, as Ms Drennan's explained.
Yes, I'm quite capable of understanding that. What I find somewhat confusing, you know, people often give to charities because it's organised by an organisation like the CFMMEU that they support, and clearly the logo may well be on the poster itself. So you're saying, yes, of course they would need to come, would be in breach. Is it the union that has to rectify that, or the employer, if they've given permission for a charity poster to go up?
So the union can do whatever they like with charity posters and charity publication on their own accord, on their own social media channels, to their own members. The code only applies to building contractors seeking to tender for Commonwealth work. There is no capacity for us to compel the union to remove logos, mottos or indicia. There is no capacity, contrary to some submissions that have been put out by the ACTU since this decision was put down, there is no capacity for the ABCC to fine unions or to fine workers or to indeed fine contractors for any breach of the code. Ms Drennan will explain in further detail if you need clarification of that, Ms Senator.
But nevertheless, it's a breach of the code and you will pursue them, but people won't be fined.
Sorry, just when you say you will pursue them, we cannot pursue the union for a breach of the code.
No, I'm saying you'll pursue the
employer. We
employer.
cannot pursue workers for a breach of the code. We can pursue a code-covered entity for any breach of the code, and that's the example which Justice Snowden has considered in the context of the Lend-Lease litigation.
Why has the ABCC sought costs orders against the CFMMEU who intervened in the case, but not against Lend-Lease who bought the case?
Yeah, I'll just step back and allow Deputy Commissioner Kelleher to come to the table and he can answer your question, Senator.
Senator Matt Kelleher, Deputy Commissioner Legal. Costs are sought as against the CFMMEU arising from its intervention in the proceeding. It was not an original party to the action commenced by Lend-Lease against the ABCC. It filed a constitutional notice of which it has been agreed and court orders have been made that 100% of those costs taxable on a party-party basis will be paid by the CFMMEU and 50% of the ABCC's costs on the construction argument from a particular point in time following its intervention.
Okay, so for a government that supports free speech, what do you think of this, Senator Stoker?
Well, you're absolutely right, Senator Pratt, that I do very much support free speech. I also support the workplace relations laws that exist in this country, and the laws that are in place and have been ruled on in this decision have been in place for some time. They haven't changed, and indeed it is the ongoing refusal to comply with what was a plain requirement of the workplace relations framework that has necessitated this action. Of course, any individual is entitled to raise any matter of public discussion anywhere they like, really, in their own time, but when they're at work, when they are using property that is not theirs, there are limits.
Clearly, even if the issues that they raise are health and safety, mental health, you know, anti-sexual harassment.
Well, quite frankly, Senator Pratt, given even in today's paper, we have indications of the CFMMEU's appalling treatment of women in construction, I am reluctant to take lectures about the great things that the CFMMEU is doing to keep women safe at work.
I'll move on to another topic because I know we have limited time this morning. Since 2016, the ABCC has sought to prosecute only 22 employers but 233 individual workers. Is that correct? Why is that?
Senator, I'll ask again Mr Kelleher to address you on this question.
Senator, in the midst of the reshuffle, I might need you to re-put the question, but I picked up the majority of it.
I'll just put it again. Why is it that since 2016 the ABCC has sought to prosecute only 22 employers but 233 individual workers?
Senator, in respect of the prosecution of individual workers, the agency, since its re-establishment, has prosecuted 0.03% of all construction workers in Australia. 0.03%. That is reflective.
0.03%. What percentage of employers have you prosecuted?
I would have to take that on notice, Senator.
Well, you came prepared with the other statistic. Can you?
We know how many workers are within our jurisdiction, approximately 1.15 million. We don't have reliable figures on the number of employers within our jurisdiction.
How is it possible that the ABCC has focused its attention 10 times more on average workers than it has on employers in a high-risk industry which is also renowned for significant and rampant wage theft?
I don't accept the characterisation, Senator, that it's 10 times more. When you look at the number of cases brought against employers and employees, they're roughly comparable. I have 231 employees that have been put before the court by the ABCC since 2 December 2016. Senator, the relevant figures I look at is what's our attention to employees, both in terms of litigation and wage recoveries. While we've put 231 employees before the court, and Mr Kelleher is right, it's less than 0.03%, we have recovered wages for 8,444 employees. So our attention to wage recoveries from employees is much higher than the small number of cases we've put before the court relating to employees. What our litigation stats show, 8,444 employees have had wages recovered and recovered in full since 2 December 2016.
Can the ABCC break down for us the penalty imposed on the 233 individual workers and the nature of the contravention?
Yes, we can. I'll ask Mr Kelleher to address you on that.
Senator, just to clarify some of the numbers that were put to us, as at the 25th of March this year, since the agency's re-establishment, there has been 8 cases against employees, 14 against employers, 82 against the CFMMEU, which has led to 1,663 contraventions, far disproportionate to the number of contraventions found against either employees, for that matter, or employers. And of the $16.4 million in penalties that have been imposed in cases taken by the agency, only $635,000 of those are in relation to employees. We have not sought PPOs, personal payment orders, against individual workers. Our understanding would be that The majority, perhaps not all of those, would have been paid for by the union, and many of those cases have involved unlawful action organised by the union, where the union itself has also been a party to the proceedings.
Nevertheless, the fine itself is on the worker in some of those instances, and
Yes,
the union
so
organises
just to
itself
answer
pay
your
them.
question, the total penalties against employees has been 635,800. In 8 cases. For employers, it's 521,255 in 14 separate cases. In addition, employers have been subject of a further $638,359 in compensation to be paid to victims of unlawful conduct, and that arises in 4 cases. There have been no compensation orders made against employees.
Can you remind me how many court cases the ABCC has run for breaches of sham contracting laws since it was re-established in 2016?
Senator, there has been 0 cases run by the ABCC for contraventions of sham contracting laws.
Why
which
is that?
Well, Senator, it's reflective of the number of complaints made to the agency arising from sham contracting inquiries. The number of inquiries this financial year received by the agency relating to sham contracting is 3. There has been 0 complaints and 0 investigations relating to sham contracting. And on our inquiries, Senator, there has been just 1 sham contracting decision handed down in which the CFMMEU itself was an applicant. And under the Fair Work Act, the CFMMEU as an industrial association has standing to commence such action. There has been 0 referrals from the CFMMEU to the agency in respect of sham contracting.
Yes, but those of us that were around when this was put back together, sham contracting was one of the reasons the government identified to want to reignite the ABCC. What's the status of sham contracting in the building industry? Is it a problem?
Well, Senator, it has been reported that it is an issue that is rife. What I would say is that it is not reflected in the complaints brought to us, the investigations that we have, or for that matter, the cases brought by the relevant industrial association in this area.
Okay. Do you always go off complaints? How do you go about looking for sham contracting?
Senator, that would be by way of inquiries made, complaints made, as with any,
Only
for
by
example,
complaints?
as for any underpayment, similar to any underpayment related complaint brought to the agency. The ABCC will prosecute underpayment matters that come to it to the fullest extent, like we have done for a vulnerable tiler in the open tiling matter, where $86,000 in compensation was ordered to be paid to it. When a complaint was made to the relevant union by that worker, $25,000 was paid to the union and $21,500 passed on to the employee. On our request of the union as to why $3,500 wasn't passed on, we received no response. What the agency will do is put before the court a claim for the full repayment of any underpayment to a particular worker.
Okay, we're talking about sham contracting now.
Sorry, just to answer your question, Senator, on whether it's only complaints. No, we don't only act on complaints. We act on any referrals from any building industry participant. So if a worker wants to refer a matter, or the union wants to refer a matter, or an employer wants to seek advice or assistance, we can commence an investigation on any of those. In the last 5 years, we've received 0 referrals from trade unions about sham contracting. We can also act on sham contracting on referrals from other agencies.
Agency to refer things to, I guess that's true enough. Do you do any proactive work other than wait for a referral or a complaint in? Do you research it?
That's not the evidence that's been given by those at the table. The evidence given at the table is that they make inquiries, they follow those inquiries, as well as deal with complaints and referrals.
And so-
that's exactly what I'm trying to understand. What do you do that looks for sham contracting?
So-
Do you monitor contracts? Do you you see a company do you follow particular names? Do you follow director business numbers? Do you follow ABNs that disappear? Do you talk to the tax office? What do you do?
So we can receive referrals from any other Commonwealth agency. They have similar information sharing powers to mine. If we receive a referral relating to sham contracting, we would act on that. As far as I'm aware, we've not received any referrals from other agencies on sham contracting in the last 5 years.
Which government agency?
And just to finish my question, finish answering your question or
Yes.
provide you a complete answer. We do a lot of proactive work, not just reactive. And in the wages space, approximately 80% of our recoveries come from our proactive work, which is audits instigated by the agency of contractors and employees, and 80% of the $5 million we've recovered to date comes from those proactive audits.
Okay, so can I ask, do you have a proactive equivalent for sham contracting?
I might just ask my Executive Director Wages, who's also responsible for sham contracting complaints and investigations, to address you on that, Senator.
Good morning, my name's Madeline Jones, I'm the Executive Director of Wages. In your response to your question, in every wage proactive activity that we undertake, when we seek records from employers, we also ask to seek any documentation regarding contracting arrangements they have, and we make assessments as to those contracting arrangements. Of the $2,065,874,000 that the ABCC has recovered to date financial year, that amount will actually factor in arrangements where we found that the relationship has been mischaracterised as a contract of services as opposed to an employee-employer relationship. And where we identify that that's the case, we work with the employer to rectify any underpayments. They're not separately categorised as sham contracting. Sham contracting has a defence available in that the employer did not know or was not reckless. When that bar is available to the employer, it becomes an issue of being a breach of the modern award, a breach of the enterprise agreement, or a breach of the national employment standards.
So why won't you pursue that as sham contracting then?
Because
at the last estimates you did say, Ms Jones, just to assist, you'll appreciate that the bar to prove sham contracting is very high, because not only do we have to prove that the person was engaged as a contractor and that they should have been an employee, we have to get over the hurdle that the employer did not know and that they weren't reckless as to the engagement. That's what, and I think you're essentially restating that now.
that's correct.
So can I ask you, Mr McBurney, is it not concerning that Ms Jones believes the bar to proving sham contracting in an industry that is alleged to be absolutely rife with sham contracting is too high? Do you agree?
Senator, I might intervene there. So, my apologies, Mr McBurney, but the bar is set within the legislation. It's the same bar that we have within the Fair Work Act, and it's a bar that's been in place for a very long time under successive governments. So really where the bar is set is a matter for the government and the parliament, and it has been in place for quite some time now and was reset in the 2009 Fair Work Act as the bar for sham contracting broadly.
It's a pretty different bar to a union, the bar on union logos, that's for sure. Is it just easier to go after unions, or is it, I guess technically it is easier to go after unions because the law is very clear. You can order for a union logo and a poster to be taken down, but your hands are tied behind your back on sham contracting because the government hasn't written laws that set the bar in a way that enables you to be proactive about it.
So, Senator, just to be clear, the Fair Work Act was a 2009 Act. It's been in place for nearly 13 years. it's this issue and the level of and the defence allowed for sham contracting has been in place under successive governments.
No, look, but the
And
Labor
in
Party hasn't been
relation-
in power for, sadly some time, and we'll have a chance to campaign and hopefully rectify that. But
So...
why hasn't the government done anything to address a change in the law?
Sorry, Senator, I think that might be asking the official for a
No, I
opinion.
can. Senator Stoker
Okay,
might
sorry,
like
you
to
were.
respond.
I thought you were addressing it
Well,
to
I don't
Mr.
accept the
Hill.
premise of your question, Senator Pratt. We have taken considerable steps to ensure that regulators have the tools that they need to be able to do their job, and we do that in an even-handed fashion.
Commissioner, have you or Ms Jones or any of your other officers ever proposed to the Minister that the laws aren't working well enough for you to prosecute sham contracting, and that perhaps that should be amended?
No, Senator.
Is there a reason why not?
I don't believe there's a requirement or a need for me to make the submission you're suggesting.
But Ms Jones' comments are a fairly damning indictment on the adequacy of laws to prosecute sham contracting. Indeed, Mr Hare and your own words as Commissioner paint quite a contrast around union logos versus sham contracting.
Well, I don't accept that, Senator.
And they're completely different issues. I mean, if you want to compare apples and apples, that's fair, but right now you're asking those at the table to compare apples and oranges, and that's not a reasonable thing to do, Senator Pratt.
Why are they apples and oranges, Senator Stoker?
They're different provisions, they're different laws. They target different kinds of misbehaviour, and you're not comparing like for like.
I understand that, but
So,
we're
Senator-
trying to deal with sham contracting, which is indeed far more complex and therefore should have more of the government's attention, surely.
So, Senator, if I might, I don't think that was a fair characterisation of Ms Jones's evidence. Ms Jones' evidence was that they were able to recover, that they did recover, where there was a mischaracterisation of the employment relationship. So it's not that there's no power whatsoever. It's quite clear that the ABCC and the Fair Work Ombudsman have the power to recover, have the power to take employers to court where there's a mischaracterisation of the employment relationship.
But that's not a permanent solution to saying, here we've got a finding of sham contracting.
Well, I disagree entirely, and if you want to keep comparing apples and oranges, then let's compare this. We've had the Commissioner say that ultimately there are no steps that can be taken against an employee or a union for the displaying of insignia and messages that are inappropriate in workplace property. And yet, when it comes to sham contracting, there are quite substantive measures available to tangibly ensure that wrong is righted. So we need to put these things in perspective, and I would concur with what's been put forward by Mr Hare to say that the way that you have characterised her commentary does not accurately reflect the evidence that was provided.
Okay.
Senator Pratt, I might just ask, is there a break you can insert here so I could rotate the call?
Yeah, thank you, Chair. I will, in order to close off on this issue of sham contracting, I've got just two more questions.
Okay, I'll give you that. And we'll go to
I note your response to questions on notice regarding the breakdown of wage recoveries for each financial year for sham contracting. In the 5 years of operation, the ABCC has recovered
Which
what
question
looks
notice, sorry,
like...
Senator Pratt? Which one are you talking about?
I have written it very badly and I haven't made a note of the actual question, but perhaps the ABCC can help me.
Is it 083?
I've got a total of 15, I think, yeah. Okay. What was the total recovery?
Sorry, is it 026, the breakdown of wage recoveries for each financial year?
Yes, that's the one. What's the amount that's been recovered in total? It's $16,000, is that not correct?
Yes, that's correct, Senator.
Okay. And what's the overall amount of money recovered for underpayment of wages?
Okay.
Look, I don't need to... I guess my concern is that the ABCC has said we embed our investigations in sham contracting into our recovery of underpaid and incorrect payment of wages, and yet it's only $16,000 that comes under the sham contracting recoveries. It's not very much, is it?
Well, Senator, of the more than $5 million the ABCC has recovered, part of those recoveries do involve relationships where the character of the relationship was incorrectly classified, and where that's occurred, we've asked the employer to rectify any alleged underpayments.
And so it's
So
done
is that
directly.
in or outside
Sorry,
this
just for clarity, Senator
$15,000?
Pratt, sorry, just for clarity, just so that we make it very clear for those listening at home, that means that the direction to rectify goes direct from employer to the person to whom monies are owed, rather than going through a recovery process that increases the administrative burden of doing so. It means that the numbers you have before you are, in a sense, artificially low.
Oh, so it covers up sham, the recovery of wages covers up sham contracting. Is that what you're explaining, Senator Stoker?
Senator Pratt, please. The effect of the orders is that it requires the monies to be paid directly. And that means it is done faster. It means it is done in a way that reduces the cost of doing so, because it isn't being handled by more people. And it means that you're actually seeing Australians served by greater recovery than has necessarily gone through an administrative bank account for its own sake.
Okay, can I just be clear? Are there elements of sham contracting in recoveries outside that $16,000?
Not sham contracting, Senator, but there are where the relationship was mischaracterised.
Is that not sham contracting?
No, Senator.
Well, I know there's different versions of it. What is the threshold that you would have to meet to demonstrate that it's sham contracting?
The sham contracting, you would have to meet the definition provided in Section 357 of the Fair Work Act, that there has been a misrepresentation and the employer did not know and was not reckless.
It's a pretty high bar to have to meet. Thank you, Chair.
Thank you, Senator Pratt. I'll go to Senator Davey.
Thank you very much, Chair. I was very interested to hear one of the examples Senator Pratt used when asking about posters was the potential of a sexual harassment poster being taken down, given the headlines that we read today about the treatment of women in the construction industry. I'd like to ask you about this article that was in the Daily Telegraph today, and I'm happy to table it. The headline is "Unions Women Woes a Worry for the ALP." This article
I'll just check this, Senator Davey. The committee happy for it to be tabled? It's so tabled. I've got a copy here. You can get yours.
The article raises some concerning matters that involve the CFMMEU's poor treatment of women on site. Can you tell us about these matters?
Yeah, I'll ask Deputy Commissioner Kelleher to address you on two matters, recent filings by my agency.
Thank you.
Thank you, Senator. The two recent filings that have been referred to relate to a matter in Victoria from the Mordialloc Freeway matter and also the Flinders University site in South Australia. In relation to the Mordialloc Freeway matter, the ABCC is taking court action against the union and its official, Gerard McCrudden, for allegedly disrupting a concrete pour, repeated verbal abuse and for twice making physical contact with a female health and safety manager at the project. It is alleged that while exercising right of entry, Mr McCrudden walked directly into and pushed past a female health and safety manager, which caused him to make physical contact with her. After the female manager followed Mr McCrudden onto the side, it's alleged that he cocked his elbow and hit her in the side with his elbow and shoulder. And then when the female manager, accused Mr McCrudden of putting words in her mouth, he responded by saying, "I would never put anything in your mouth, you're disgusting." That physical contact by Mr McCrudden caused the female worker to feel shocked, extremely annoyed, frustrated and disrespected at work. Conduct followed on the following day where Mr McCrudden disrupted a concrete pour when he was told that work was time critical to ensure the integrity of the bridge deck. In the other case in South Australia, the ABCC is taking court action against the CFMMEU and its official Travis Brook after the official allegedly asked a female worker on that site about her sex life on 2 occasions while exercising his right of entry. During his inspection on the site, it is alleged that Mr Brook allegedly asked a female labourer who was known to him about her Christmas and asked, quote, "Were you and your husband humping like rabbits the whole time?" And on a separate occasion, Mr Brook allegedly asked whether the female labourer and her husband were humping like rabbits. It is alleged that those comments made by the official were sexualised, demeaning, disrespectful and or humiliating and caused the female labourer to feel uncomfortable and distressed. And that is a pattern of conduct that we see.
Point of order.
Yes, Senator McCarthy.
Chair, could I just question, is this a matter before the court?
Both of these are matters before the court, Senator.
Senator McCarthy, that's not a point of order.
Well, it is from the point of view of whether the information should be...
No, sorry, I'm happy to rule on that. On that point, I presume you're referring to protections for public interest immunity, which are protections to witnesses, not to senators. It's up to the discretion of the officials and the government ultimately to decide on whether to use a public interest immunity.
No, well,
I think it would be quite unusual for the Senate to to inhibit the amount of information we're provided from public officials.
These are serious allegations.
So there's no point of order.
but
there's no point of order. That's a matter for the officials to decide, not for us.
I think I'm getting information about the court filings that is already on the public record. We're not asking for anything that is other than what has been alleged to the court, and that's what we're hearing about. But I'm happy to move on.
And I have made the point, Senator, in relation to both of those, that they are allegations. What are not allegations but are findings, are conduct in other cases against females, including in Sydney, the Botany Cranes matter, where a female operations manager there was subjected to abuse and intimidation at a CFMMEU organised picket for simply trying to go to work. She was unable to work for fear of being distressed. Justice Raries in that case ordered $2,500 to be paid to that female worker. That case is under appeal. The union has not paid that amount to the worker. Quite a serious picket on that site for somebody simply trying to go to work.
Thank you. This article also talks about, so that's conduct against female labourers, but this article also makes the point that some of the harassment directed by the CFMMEU to females is also against female ABCC inspectors. Is that the case? Are there any claims that you're aware of about that?
Senator, a case has been filed in Victoria alleging that 2 ABCC female inspectors were hindered and obstructed from conducting an audit of the Australian Catholic University project on the 5th of May 2021.
So this issue is something that is clearly being seen. It's not an isolated incident, it's not a one-off. There are repeat incidences of claims against the FMMEU officials against the way they treat women. Can you also just tell us, because we've had much said about the Kate Jenkins Respect at Work report, what is the ABCC doing within your workplace and in how you go about your business in response to that report?
So I was invited and appointed to the Respect at Work Council by our responsible minister, and I've participated in the council meetings. The most important priority for us arising from the Respect at Work report was education of all building industry participants and ensuring they understood their rights and obligations, both from the point of view of anyone working on a building site, but also any victim, my agency being available to support victims of sexual harassment. The law was changed by the government last year, and we used our communication channels to communicate that change to industry through our industry update. And critically, since the middle of November last year, there is the ability to apply to the Fair Work Commission for a Stop Sexual Harassment order. We've trained our first responders, people who man our phones, on how to respond to victims who come to the agency. One of these cases is an example of that occurring. We want to be available and provide advice and assistance to anyone, and our door is open to anyone in the industry, including unions, including union members, including union representatives, and including workers. We want construction sites to be a respectful workplace, and we want the Fair Work Act to be applied on those workplaces, and where it is contravened, we will not hesitate to put those matters into court.
Thank you very much. Thank you, Chair.
Thank you, Senator Davey. I'll go to Senator McCarthy.
Thank you, Chair. And well done, Commissioner McBurney, on your implementing the Respect at Work. It's too bad Scott Morrison and the Cabinet have not bothered to implement any of those recommendations.
Well, actually, point of order, that's actually false, Senator McCarthy. There's been implementation.
Minister, have you implemented all of the Respect at Work?
Okay, we'll just have a second. Senator McCarthy, just have a second. That's not a point of order, Senator Stoker, but Senator McCarthy, it would be helpful if, on your first question, you didn't engage in unnecessary political commentary.
It's just false.
But Senator
It's
McCarthy,
just
if you wanted to
false,
ask a
Mr.
question
Chair.
about those issues, you're free to do
from Senator Davey, Chair?
I missed
I
that.
was
but
asking legitimate
Commissioner
questions
McBurney.
about cases before the ABCC.
Senator McCarthy, you have the call.
Commissioner McBurney, are you aware of the political advertising campaign the Master Builders Association is currently running in relation to policies in the upcoming federal election?
I am now aware of it, yes, Senator.
And what's your response to that, Mr. Commissioner?
Well, it's entirely a matter for the MBA, and it's not my position to comment on their advertising campaign.
So just like it's a matter for the unions that want to
So how
advertise
often
for
do you
Labor.
communicate, Commissioner, or meet with representatives of the Master Builders Association?
I meet with representatives of the Master Builders Association on a regular basis. I attended the function put on by the Master Builders last month for International Women's Day and met with the Rebecca Casson and was a participant at that function. I am available to meet any building industry participant. I put the invitation out there to all key stakeholders in our industry, including the union. I do have engagement with the MBA and the ACTU on the Security of Payments Working Group. I met with both of them last month at the Security of Payment Working Group meeting convened under the Act. And Senator, I'm happy to meet with anyone who seeks to engage with our agency.
So you meet them in a formal capacity then, Commissioner? Is that pretty much what you do, given those examples you provided?
Yes, I do, Senator.
And are they one-on-one, or is it officials from the Commission?
The one I referred to, there were over 400 in attendance. It was a corporate breakfast for International Women's Day.
But you gave other examples. You said you meet regularly.
Yeah, the Security of Payments Working Group is a forum convened under the Act. It is for the specific purpose of industry providing advice and guidance to the ABCC on our security of payment recoveries. The MBA has a representative appointed by the Minister who attends those meetings. Those meetings are held with all industry participants present who are appointed to that working group. And that working group's been instrumental in providing guidance to us, which has enabled us to recover in excess of $10 million owed to subcontractors.
So in your regular meetings with the MBA, have you had any discussions around the current political campaign to retain the ABCC following the federal election?
Senator, the first I became aware of the political ads that are to be run was when they first aired.
So when did you see that?
It was shown to me last Friday by another member of staff on their phone.
And that was the first time you even knew that that was going to happen? Is that
was
correct, Commissioner?
well, Senator, that was the first time I saw the TV ad. I was not made aware by the MBA formally of any advertising schedule or campaign. We are aware they ran a similar campaign last election, and I was aware that a survey was being conducted by the MBA. We had received feedback from stakeholders that a survey was being conducted of both people in the industry and more broadly about the operations of the ABCC. We did not participate. We did not participate in the survey, and we did not contribute to the formulation of that survey.
Okay, I'll come back to the survey, but you said that you did not formally, or you were not formally told by the MBA about the advertising. Were you told informally?
I was aware that the MBA was doing a survey and that might play into whatever they were going to do prior to the election campaign.
And how were you aware if it wasn't formal?
I was told by our manager in Brisbane, Mr. Jenkinson passed on to me that a stakeholder had said that the MBA were conducting a survey which related to the ABCC.
Can I ask?
Do you know what?
Sorry, Senator McCarthy. I just wanted to know how you got a copy of the ad before it was released.
We didn't get a copy of the ad. It was shown on phone. The ad was shown to me on a phone as has been played. So when it was publicly available.
But I didn't believe it was, the ad started until Monday.
The ad I was shown was the ad that had been published at that point.
Okay, where was it initially published, as far as you know?
I don't know, I saw it on the phone of a colleague.
Senator, it was published on the MBA's social media channel. It was publicly available. We had no advance provision. We had no advance provision of this.
Thank you.
I look forward to this committee
So coming
conducting a
back to
similarly
the
in-depth
Commissioner.
examination of the degree to which union election campaigns are on the radar of agencies and the degrees to which they have been informed of their course.
So coming back to the survey, Commissioner.
Yes.
Coming back to the survey, what was your understanding of what the survey was about?
I don't know what the survey was about other than it involved questions about the ABCC. That's what the
Okay, and I
stakeholder
just
told
want to
us.
clarify. I really want to clarify this timeline, as Senator Pratt has picked up on. So you looked at the ad on one of your staffers' phones last Friday.
Yeah, I believe it was last Friday. Or was it Monday?
It was whenever the ad was publicly available on the MBA's social media channel, Senator. It was publicly available.
Deputy Commissioner, with the greatest respect...
Well, it was the Deputy Commissioner's phone. Senator, it was Deputy Commissioner's phone that I saw it on.
There is nothing to see here, Senator. It was publicly available. We had no advance provision of the ad.
That's all very well for you, Deputy Commissioner, but we're trying to understand a timeline here. So it was last Friday that the Commissioner looked at your phone to see the ad when the ad was released publicly Monday.
We'll take the question on notice as to the exact time it was shown. We'll just compare when we were both in the office. But
In fact, it was Monday. I wasn't. It was Monday.
Okay. Well, that
It was Monday.
clarifies it.
Oh,
Sorry.
Oh, okay. So you're
Thank you.
changing the days now, is it, to suit when the ad came
Well,
out?
it had to be when I was with Mr Kelleher. If he says that was Monday, I accept that was Monday, Senator.
Are you sure? Are you sure you want to go back and have a good look at this? Because you were very confident it was last Friday, Commissioner.
Senator, it was not, because I was not with Mr McBurney last Friday. It was Monday.
Very interesting.
Okay.
Senator
Well,
McCarthy, if it would assist you, my recollection of the evidence provided was never that it was quite that firm, that it was around about. But if you would like the Commissioner and the Deputy Commissioner to check their diaries, I'm sure that they could take that on notice.
So let's have a look at the Hansard, because the Hansard's first response by the Commissioner was that he looked at it on Friday.
He said
So I
he
don't
believes,
think
he
confusion as to what
believed
he
it was
said.
next Friday.
Said it was Friday.
Senator
Senator,
McCarthy, I'm happy to go to the
That's the
Hansard.
Hansard.
But the evidence was that it was what he believed, and I don't think you've got yourself a big old smoking gun here. The consistent evidence has been that the information was seen from a public social media account after the information had been released to the general public.
Yes.
So I don't know what you're getting all hot and bothered about.
Minister, I
We're not
don't
hot
know
and
why you
bothered.
jumped in, because the Commissioner said in his first response to me, it was Friday, go and have a look at Hansard. Don't jump in and say, this is what I think he said, because that's not correct.
Well, respectfully,
He said he saw it
Senator
last Friday.
McCarthy,
Go and have a look
you
at the
should go and have a
Hansard.
look at the Hansard.
No, you're the one who's saying the wrong
Just
thing.
get on with it,
Okay,
Senator
Commissioner,
McCarthy.
I'm sure you'd be aware of extraordinary allegations made against your predecessor back in 2017 by a senior executive of a construction firm who said your predecessor had launched a propaganda campaign with the support of the Master Builders Association that sought to portray the construction industry in an extremely negative way. Are you not concerned, Commissioner, that you will be seen in the same way as your predecessor?
No, I'm not concerned, Senator.
For looking at something on a public social media account. What a load of utter rubbish.
There'll be time for you later, Minister. So you're unaware of this previous history, or you are aware of that previous history in 2017?
I'm not aware of what you're now putting to me, Senator.
Okay.
I was in
Thank
a
you very
different
much.
job.
Mr.
I was working for
McBurney,
the state at the
I would-
time. I don't know what you're referring to.
Mr. Surely you're aware
I've got a question
that
now for the Assistant Commissioner. Sorry. Senator?
I just want to take you back, Mr. McBurney. The former Commissioner, Nigel Hadkiss, broke his own laws and had to resign. Surely that's something you're aware
That's a
of.
different question, Senator. The Senator didn't ask me about that. What you're now asking me about,
Okay.
I've been asked and answered questions at
Okay,
several
but you-
previous estimates appearances before this committee.
So just to be clear, there is a previous history that we're aware of collusion between the MBA and former Commissioner Nigel Hadkiss. I'm glad you've now been able to clarify the date on which you received that information regarding the campaign, but you can see why it was important to us and the Senate, as senators asking these questions, to satisfy ourselves that you didn't have prior warning an advance notice of those particular ads?
Senator, as the person who showed Mr McBurney the ad, it was when it was publicly available.
That's
There is
fine.
nothing to see here.
We can now take that at face value, but you can understand from our point of view that the earlier evidence she gave contradicted when it was publicly available, because you had said it was available Friday when we knew it wasn't publicly available until the Monday. So thank you for resolving that for us.
You're welcome.
Thank you for your indulgence, Senator McCarthy and Chair. I'm happy to hand the call back to my colleague.
Sure. Can I put a question to the Minister at the table, please? Just in your capacity in this area, when was the last time you or your office met with any representatives of the NBA?
I can check my diary, but I can assure you it hasn't been in the last 6 months at least.
And what about the Minister?
So,
I can't speak for her diary, but I can take that on notice.
could you also specifically tell us how often you meet, you and or the Minister as well, with the CEO, Danita, and when was the last time you met with her and what the meeting was about?
I can take it on notice in relation to the Minister. My answer would be the same for my diary, and that is to say, I would have to check, but it certainly hasn't been in the 6 months just gone at least.
Thank you, Minister. Commissioner, can you tell us why the ABCC appears to file more cases against the CFMMEU when a federal election is just about to be called?
I'm not sure what your allegation is there.
It's just a fact.
Well, I'm not sure that it is, but Commissioner?
We have 41 matters currently before the court, and the CFMMEU or its representatives are respondents in 36 of those 41 matters. We've consistently filed cases against the CFMMEU for much of the last 5 years. The timing of the filings, I'll just ask Mr Kelleher to address you on that.
Senator, and what I would say in respect of that is we don't choose when this conduct happens. We don't choose when alleged unlawful conduct is engaged in, which we have seen on the Flinders University site on the 13th of January this year, in respect of the Norwood Mall matter involving Mr Brook, the 15th of December last year, in respect of alleged death threats on the Fremantle Port during a prolonged picket, August 2021 last year, in respect of the Mordialloc Freeway matter, July 2021 last year. There is a spread of dates upon which this alleged conduct to which you are referring occurs, and it just so happens that they were in shape to file. There is a unfortunate increase in the level of unlawful conduct that we are seeing across Australia's building and construction sites, and serious alleged conduct in respect of females that must be called out.
Senator McCarthy, it is...
And can I just,
Senator McCarthy,
Senator
let me
McCarthy,
answer the question, please.
I'll still give the call to the Minister.
The Commissioner and the Deputy Commissioner have made it very clear that the rate at which these matters occur is conduct-driven. It is not driven by any other matter, although it is quite possible, although it's something you probably know better than me, Senator McCarthy, that the CFMMEU's misbehaviour might change according to the approach of an election, but it certainly doesn't change the approach of the ABCC. What we do know, however, is that there is a long and clear history of members of the court in this country calling out the CFMMEU's behaviour as being in utter contempt of the law on a regular basis. That is the issue here, and if the CFMMEU cleans up its act, it will find the number of proceedings it faces rapidly drop off.
And Senator, in respect...
Minister and Commissioner and Deputy Commissioner, may I remind you that there are 41 matters before the court. They are all allegations, and I would caution you in the way that you're replying to this committee as though there is a case of guilt. That is not the case. Any matters before
Senator
the court...
McCarthy, there is a long history of findings of guilt.
Commissioner,
There is a
of how you're
long history
responding
of
to this
findings of
Senate
guilt that
committee.
more than support the evidence I have put before this committee.
And I would add to the answer that I just gave, Senator, one of those cases recently filed is against a company, Ozcare Constructions, for allegedly failing to comply with a compliance notice requiring it to provide a report into its security of payment obligations. That case was filed on the 23rd of March. And as the Senator Stoker has remarked, in the most recently decided case in Queensland, a judge there noted or said of the CFMEU having an unenviable record before this court, described by other members of the court as a rogue union and a repeat offender, and he had previously described it as the greatest recidivist offender in Australian corporate history. This conduct has happened over a long period of time and continues to happen and has been increasing in volume in the months before now, leading to the filing, regrettably, we would say, of a number of cases involving seriously unlawful conduct being alleged.
Quite frankly, Senator McCarthy, Labor senators should hang their head in shame for running a protection racket for this kind of behaviour. You're on mute, Senator McCarthy.
The fact that you haven't implemented so many recommendations of the Respect at Work, I think you need to have a good look at your
Well,
side
I'm
of the
glad you
party as
raised
well.
it, Senator McCarthy,
Chair,
because I've
back
got
to
some
you.
information here that I think, in light of your allegations, we should put on the record. The Australian government has fully implemented or fully funded 43 of the 55 recommendations of the Respect at Work report. Now, of those 55 recommendations, 12 have been fully implemented, 31 are fully funded with work underway. The further 8 recommendations have work underway for their full implementation, and 4 recommendations were directed at the private sector. So I won't have you spout the Labor talking points not grounded in reality in an attempt to try and tear down this government's excellent record of acting decisively and fully on the Respect at Work report.
And how long did it take? You call that decisively. Back to you, Chair.
Well, Minister, did you want to? I don't think we have rhetorical questions in this place, but I'll give you the opportunity, but otherwise we'll move on.
Look, I think we just move on because
thank you. We'll take it as a comment.
the allegation's already been shown to be one that's utterly false.
Thank you. Senator, are there any other senators with questions for the ABCC?
No, thank you,
Well,
Chair, we're done.
Thank you very much for that. I thank the officials from the Australian Building and Construction Commission, and I will call to the table officials from the Registered Organisations Commission. Are they in the room? Or they are? Great. So we hopefully won't need to suspend. Louise, Eric needs to come here from chair and you'll have to just give me 15 minutes at the start. Sure. So we'll give you a set of time. And then that'll obviously go back to you. I think we're all in place by the look of it. Well, I welcome officials from the Registered Organisations Commission. Mr Bilecki or others, do you have an opening statement?
No, thank you, Chair.
Thank you very much. I'll go to Senator Pratt.
Mr Bilecki, can you remind us when the Minister asked you, as in the ROC Commission, to investigate a decade-old donation the Australian Workers' Union made to GETA?
My recollection, Senator, is that the Minister sent to us a letter including some press clippings that related to those matters. We didn't receive a request as far as I recall, but I'll ask Mr Enright to correct me if I'm wrong, to do anything on behalf of the Minister.
The Commission is quite correct. The Senator sent two letters, in fact, in August of 2017, bringing these matters to the attention of the Registered Organisations Commission, but there was no request to conduct an investigation.
Okay, so the letter, but there was a letter
There were 2 letters, Senator, that have been tabled in the Senate, both of them, and
Yeah.
produced by the Registered Organisations Commission in the civil litigation brought by the AWU.
And that letter was from the Minister herself, wasn't it?
There were 2 letters, Senator, and both were from the Minister, yes.
Were you compelled to follow up this request because it came from the Minister, or could you have declined to investigate?
I'm sorry, Senator, I missed that question. I apologise.
Were you compelled to follow up this request because it came from the Minister? Or let's not even call it a request, let's just call it a letter. It had attachments to it that made certain allegations. Were you obliged to follow it up, or could you have decided not to act on that correspondence?
Well, we didn't act on the correspondence, Senator. There were 3 reasons that the investigation was conducted, and I'm happy to tell you what those reasons are.
Given everything that's happened since then, do you regret agreeing to this request from the Minister? It's cost a lot of money and occupied a lot of your time as an organisation, has it not?
Well, Senator, it has cost a lot of money in response to in the ROC defending proceedings brought by the AWU, but it was necessary to conduct the investigation, Senator. Firstly, because we understood senior AWU sources wanted to know whether significant amounts of their members' money had or had not been donated in accordance with the rules. And the AWU wouldn't provide them with clarity about that. And then thirdly, Senator, when we look at these matters, we often look at compliance trends and patterns, and we did that in this case while we were considering whether or not to conduct an investigation. And it was very clear, Senator, at the time that for the previous decade, the AWU had a culture of systemic, ongoing and serious governance failures. So for all those reasons, it was necessary to conduct this investigation, Senator.
Okay, so in terms of it being a good use of taxpayer funding, the investigation lasted more than 4 years. It dragged the AWU through the courts, tying them up in red tape. A lot of resources of the union were put to this. There was the disastrous raid on the AWU offices, in which the Minister's office tipped off the media. There was a resulting scandal that resulted in the sacking or resignations of several of the Minister's own staff, and ultimately it fell over and there were no prosecutions. Is that really a good use of taxpayer funding, time and effort?
Well, respectfully, Senator Pratt, the ROC's investigation concluded that the AWU National Executive did not approve any of the 20 donations that were the subject of the investigation, and that they had contravened the Registered Organisations Act or its predecessor on at least 9 occasions. So that's, I would suggest, pretty significant, and as I understand it, and perhaps Mr Bielecki can clarify for me, but the Registered Organisations Commission has accepted the investigation's finding and recommendations. So I would suggest that the characterisation you put before this committee is at best blinkered, at worst misleading.
Okay.
Senator, if I may also assist, there's a fundamental flaw in your question. The ROC did not drag any party into court, full stop. We was dragged into court by the AWU. They issued proceedings and occupied a trial of 10 days, and we then had to deal with an appeal, and the majority of the money spent in relation to the expenses associated with this matter were to deal with defending ourselves in the court. The defence was spectacularly successful and the case was a colossal failure. Every ground advanced by the AWU was rejected by the court. Every argument made by the AWU was rejected by the court. So if you're interested in the cost of the investigation, it was something like $95,000. The rest of the money that was spent, that's been very topical in this committee, was spent in defending ourselves and our jurisdiction in the court. It was alleged by the AWU that the ROC could not investigate matters before its formation. That was rejected by the court. there were other jurisdictional issues raised that we had to deal with.
When you ended...
Sorry, before I let you go on,
Sorry,
Senator Pratt,
I've even lost track of my initial question now.
Well,
So
I think so that we can tie this off completely and allow you to move on to, wherever you'd like to go. I think it's important to observe that the ROC has been on the record saying, had the AWU cooperated in August 2017 in the ways that it had been requested to, it's likely the entire matter would have been resolved in 2 to 4 weeks with a similar outcome and very little cost.
Oh, well, perhaps Senator Cash could have cooperated with the AFP too.
Well, that's a different matter entirely and not relevant at all to the matters that were being investigated by the ROC.
With respect to the $1.3 million in legal costs, can you provide the final tally of all legal costs incurred by Minister Cash and the ROC in relation to this case since the matter commenced in August 2017 until now?
Senator, the department will need to take on notice any of the costs for Senator Cash, Minister Cash. That would not have been a matter for the ROC, but we'll have to take that on notice.
Can you give us a ballpark now, Mr Hare?
No, I don't have any figures in front of me, Senator.
Does anyone else have figures in front of them?
I don't think so. I
Can
can check at the break.
I would be grateful if you're able to let us know. I understand that when this was concluded, there was insufficient documentary evidence in relation to specific infractions. Can I ask the ROC what you estimate the cost to the taxpayer was, including your own resources?
Firstly, Senator, it's not accurate to say there wasn't sufficient evidence. There was sufficient evidence. In fact, the AWU admitted to 9 contraventions, and there was sufficient evidence. I made a recommendation to the Commissioner, Senator, that whilst those contraventions could have been, and the AWU is likely to have admitted them if we had brought proceedings, I made a recommendation to the Commissioner that we ought not to bring proceedings in relation to those matters for a range of matters or a range of reasons
if they've been admitted and they're not.
That I set out. Well, the reasons that we didn't proceed include, Senator, that firstly they were historical, and the AWU had submitted that the Commissioner ought not to bring proceedings because they said that they'd improved their compliance. They'd done things like in 2019 appointed a compliance officer. They'd changed their systems and they had automated reminders and various things that I took into account in making a recommendation, despite the fact, Senator, they said that they'd improved their compliance. But I took into account that also, and very recently, made admissions into 25,000 contraventions of the Act in relation to another matter. But in any event, Senator, I took into account a range of matters and recommended to the Commissioner that it was not in the public interest, despite the fact that the allegations or the contraventions could have been easily proven. It was not in the public interest to bring those proceedings.
Do you have any estimate on how many work hours were dedicated to the case and what the cost was?
Senator, we were asked the questions in relation to cost very recently by Senator Farrell, questions on notice, and question on notice EEC AE 22-052, and we responded to those details in relation to the costs of the investigation and in relation to the civil proceedings, and the response in relation to the time hours, Senator, was that we do not track time hours on individuals in relation to the matter, so we were not able to assist in that regard.
So, given you don't track it, how do you know if this was ultimately a good use of taxpayers' money?
Well, it was an essential use of taxpayers' money for the reasons that I've talked about, Senator. The AWU, members of the AWU wanted to know whether very, very significant amount of their money, their membership money, had or had not been spent in accordance with the rules. The AWU wouldn't tell their members the reality, and because the AWU over the previous decade, I might say, Senator, in each of the previous decade from 2017, in each and every year, the AWU has admitted to contravening either the Act or its rules in each of the years between 2006 and 2017 in what was an exceptionally deficient and ongoing governance failure, Senator. So it was absolutely necessary for us to conduct the investigation.
Okay.
And these are just matters, I've got to say, Senator, the recent admissions to the 25 or nearly 25,000 contraventions of the Act by the AWU, these are just the admissions that are made by the AWU. So I'm just telling you what they are admitting to.
Mr Bilecki, on Friday the 25th of March, you were reappointed as the head of ROC. How long's the new appointment?
2 years, Senator.
How long was your current appointment?
5 years, Senator.
Why have you only been appointed for 2 years? Is that what you asked for or what you were offered?
It's a question for government, Senator.
So, can you... Yes, it's a question for government. What... Did the government reappointed you for 2 years instead of 5? Why did they just arbitrarily give you make an offer of 2 years?
That's a matter for the government.
I understand
They'll be asking
that.
the witness to speculate, Senator.
But I'm happy to address the question if you like, Senator Pratt. I regard the reappointment of the Commissioner as an endorsement, not an insult, as a reflection of the government's great confidence in Mr Bilecki. Of course, he is a senior lawyer experienced in regulation and compliance. He, as you know, has served in this role for the past 5 years. And before his appointment, he was the principal at Norman B. Partners Lawyers.
So what's the basis for the shorter term is simply my question.
Well, I don't see it as a negative.
I'm not saying whether it's negative or positive. I want to know what the basis is for the shorter terms.
It reflected the confidence that that government has in the Commissioner. I don't see it as a shorter term. It is quite a regular thing for subsequent terms to be in the order of that length, and there's no inference that should be drawn from it other than that government is both pleased and content to see the leadership that is given by Mr Bilecki continue into the future.
Senator Stoker, thank you for that answer. That answer would be relevant to 5 years or 2 years. Can you come to something specific to the length of the term and why the government has come to the view that it wanted to offer a 2-year contract instead of a 5-year contract?
Look, it's just been a common practice across the portfolio and indeed across government in all areas. One could look at the extension of the Commonwealth Director of Public Prosecutions for 2 years, or the CEO of Safe Work Australia for 2 years. It's a relatively common global approach, and as I say, it's a reflection of great confidence.
You can't have much confidence in anyone if you go from 5 years to 2 years, and you say that's common practice across government.
Well, quite frankly, the idea that one would have a large initial appointment and then subsequent shorter extensions is indeed very common. Whether you look at, a lease that has an option for shorter extensions, whether it's employment that or appointments that have extensions, this is not something unusual, and I think the inference you're trying to draw, Senator Pratt, is rather thin. It happens to governors. It happens across the board.
And they get an extension of 1 or 2 years.
Quite right, Senator Abetz.
Not that Mr Bilecki would make a very good governor, I'm sure.
I'm sure he would succeed at whatever he turned his hand to.
Mr Bilecki, did you advise the Minister prior to withdrawing the case against the AWU? And if so, when did you advise the Minister?
There's a clarification required, Senator. There was no case against the AWU. This has been misunderstood in the hearing on Friday and today. There was an investigation into the AWU. The investigation was not withdrawn. The investigation was concluded. The investigation found 9 breaches of the Registered Organisations Act and 20 breaches of the specific rules of the AWU requiring approval by its executive body of donations.
When did you advise the Minister that you're concluding the investigation?
We concluded, I think it was the 24th of February, and on that day we issued a media release, we let the department know, and we put the release on our website.
And that's the same day you advised the Minister?
We didn't advise the minister, we advised the department.
Okay, so did the minister have any prior advice to your own decision, any prior communication in relation to the winding up of the case? Did the minister support or oppose, or is that not relevant?
It's not a case, Senator, it's an investigation.
Yes.
There were no...
I'm not a lawyer, you may well be, I'm just... Yes.
I'm just trying to help clarify the position, Senator.
Pratt, I might just ask, do you mind if we did agree to
I've
rotate
really
the
got
call?
3 very short questions.
Is that okay, Senator? You're all right?
I can come back after the morning.
No, let's
No,
keep
I'll
to
be
it. So
very
we're trying to run a
The
tight
short
ship,
answer,
so-
sorry, the short answer to your other question is there's no communications with the minister or the minister's office about the progress of the investigation or it ending.
Okay, did you ask the minister to be reappointed?
No.
So why do you think you were reappointed? Because you
Ex-
faithfully pursued this matter referred to you by the minister all these years ago?
Senator Pratt, that is...
well, okay,
that
you tell
is
me why you
quite
were
an
reappointed.
appalling slur, and I think that...
Why is it a slur when Mr Bilecki has...
You're suggesting
argued
something
faith-
improper in the discharge of his duties, and
Independent statutory authority.
that's right.
Give him some respect.
I think we should give the Commissioner a chance to respond to that
Yeah.
uninterrupted, given the unfairness of it.
Well, he
Senator,
doesn't have to take it as a slur, that's... he's...
Okay, let's let...
Thank you very much, I'm
question's
done
been asked.
on
Well, was there
the
any-
registered
Mr. Bilecki, would
organisations
you-
well, I was
commission.
just going to say,
Happy to
Senator,
provide you the call, Mr. Bilecki.
the work of the ROC is very transparent. We have done, in my view, and I attribute the credit to my team, excellent work in the education space. The education tools available to organisations are completely unprecedented. We have a national education strategy which organisations and umbrella associations use to coordinate their own training. We have raised compliance rates over the period of the 5 years that I've been in the seat, and we've met all of our KPIs all of the time. And in relation to the court cases we have brought, we've been successful in every case that we have brought. There's a lot more I can say, but modesty prevents me from continuing. Thank you.
Thank you, Chair.
Senator Pratt. We'll go to Senator Abetz.
Thank you, Chair. So, by the sounds of it, Commissioner, you've been reappointed for a period of time. Is that correct?
Yes, Senator.
Yep. Congratulations, and undoubtedly it's an indication of the job that you have previously done. So, thank you.
Perhaps we can take the earlier questions as a reference being given by Senator Pratt for you to get an even further extension into the future.
Thank you, Senator.
I will be placing quite a number of questions on notice, but just want to ask a few here. What was the total value of the unlawful political donations? Was, as I understood it, there were 17 that were to my knowledge, and then with a, what do we call it, findings of the investigation, there were in fact 20.
There were 20 breaches of the rules of the AWU and 9 contraventions of Section 237, subsection 1 of the RO Act.
And those 20 breaches, did each one of those involve a donation somewhere?
Yes, Senator, there were 20 breaches of the rule requiring approval, each of which related to donations, yes.
Right.
Not all political donations, including the donations to GetUp.
Yes. I won't get into an argument there, but can I tell you, a donation to GetUp is hugely political, but we won't go there, but understand your comment as to that. As I understood it previously, on the public record, there had been 17 such donations spoken of. Is that correct, or...?
I've found a list, Senator. One donation of $50,000 was made by to GetUp Limited by the Victorian branch. A second donation of $50,000 was made to GetUp by the National Office. There was a donation of $3,000 for delivery of website for Bill's campaign, APT Social Change Online. There was a donation to ALP Latrobe FC comprising 2 payments totalling $5,000. There was a donation to ALP Queensland comprising 2 payments totalling $25,000. The $25,000 was also donated to ALP Petrie, $20,000 to ALP Sterling, $2,000 to ALP Casey FEA, $5,000 to ALP Gippsland, and the same amount to ALP Higgins, $10,000 to ALP Kalgoorlie, $25,000 to ALP Maribyrnong, $10,000 to ALP North Sydney, $5,000 to ALP Wakefield, $2,500 to ALP Dawson, $2,000 to Janelle Saffin Page to ALP Port Pirie and Districts $1,000, ALP Justine Elliott for Richmond $8,000, donation dash Shorten for Rudd Dinner to ALP $5,000, and number 20 is a donation of $5,000 to Corio to ALP.
If I could just assist the Commissioner and clarify, 3 of those, Senator, were never declared. 3 of those that the Commissioner just read out in 2007
were never declared.
Have never been declared to this day, in accordance with the Act, Senator.
Are still not declared?
No, Senator.
Right. So the fact that I was thinking there were 17 declared, that is sort of correct? Or that is correct?
Declared, but in contravention of the Act,
yes. In contravention, and then there were 3 that still remain undeclared.
Yes, Senator.
Do we know how much money those 3 amount to that
about
remain?
$32,000,
Yes.
$33,000.
Yes.
Senator
I can tell you
Rhodes,
which...
did you give Mr Bilecki prior warning about these questions? He's very prepared.
They are highly professional, and on the oath of the Senate, I can answer, no, I did not. And that gives you another indication as to why the Commissioner should be reappointed.
I also indicate that's out of order with the questions that have been directed to the Minister and the officials. Thank you.
So, look, thank you for that. And in that, Chair, I was very disappointed there wasn't one to Tasmanian Liberal Senate team, but one can live in hope. Can I then move on to your decision not to prosecute and accept that, but you said in the statement of the 24th of February 2022, the deficient record-keeping practices, the effluxion of time and its inability to produce relevant documents. Now, all this started because there was a whistleblower suggesting that documents might be shredded, and hence the police raid, etc. The inability to produce relevant documents, is there any view in the Commission that that was as a result of the destruction of documents?
Senator, I will defer in a moment to Mr Enright, but we don't know enough to know. We served a number of compulsory notices for production of documents, covering a number of categories of documents, and there was an obligation on the organisation to respond to those fully and frankly, and the information that we received was insufficient for us to actually attribute to a particular officer or officers who might have been responsible for the conduct in relation to not getting approvals for the donations or not lodging the loan grants and donation statements, which is an obligation of the organisation itself. So in the absence of sufficient records, we couldn't form a concluded view as to who might be involved in that, and it was not possible. It was not possible to take the matter further.
Right, understand that, but was there or is there a view that the fact that inability to produce relevant documents, was that as a result of the destruction of documents?
Senator, the problem is we've certainly got enough evidence to prove contraventions of the Act, but because the record-keeping practices of the AWU were so poor, we could not find sufficient evidence to prove individual contraventions against individual officers of the Act. That was principally because of the poor record keeping. But in relation to the shredding that you've referred to, the ROC engaged an expert on the potential reconstruction of the shredded material that we collected. And the expert conducted a microscopic and macroscopic examination of both those records and torn records. So, in summary, Senator, their expert assessed that it was possible to reconstruct the majority of documents, which seemed to be, on estimate, about 340 pages worth of material. But for a range of reasons, Senator, I made a recommendation, or I decided that that was not in the public interest to do that for a range of reasons. I spelt out those reasons in my investigation report to the Commissioner, and we made a decision not to proceed down that path.
Sorry, Senator, we did have the torn pages reassembled, but not the shredded material.
Are we able to see some of those torn pages, or is that...
I can tell you, Senator, that the expert reconstructed pieces of torn paper into 6 legible pieces of printed material and photographed them. 5 of those 6 pages appear to be copies of meeting minutes directly related to matters relevant to this investigation. So on the day of the searches, Senator, which was some 10 or more years later, whatever it was, after the AWU and GetUp matter, we did find torn material in the AWU offices, which was subsequently reconstructed. But I will say, Senator, that they appeared to be copies of other material that were available in the material that we subsequently collected. So the 6 pages did not appear to be evidence of destruction of original documents sufficient to warrant referral to the AFP on the suspicion that a federal offence might have occurred. So they were not of that character.
So you found the original documents?
Yes, Senator. We found in the material we found the original. So these were just copies.
All right. Did you receive any representations on behalf of any individual officers of the Australian Workers' Union at any stage as to whether or not the matter should proceed to a prosecution?
We didn't receive any individual. We received submissions by lawyers on behalf of the AWU.
Only on behalf of the AWU,
yes.
Not individual officers of it or previous individual officers of it?
That's correct, Senator. We did not receive those submissions.
All right. And with whom does the buck stop in relation to record keeping in these national organisations? Is it the National President, National Treasurer?
Well, there are rules, Senator, and each organisation often has different rules, but the responsibility for record keeping lies with the organisation. And in the rules in each organisation will set out the roles and responsibilities of officers, including important officers such as the Secretary, either the National Secretary or State Secretary.
All right, with the AWU, National Executive, with whom did the buck stop?
Well, certainly
in their rules.
Certainly the National Secretary has powers, the full-time National Secretary has powers to cause and keep a correct amount of monies and relevant records. Senator, I can't take you to the specific rules, but the National Secretary certainly has those obligations. The National Secretary is effectively the CEO of the organisation. So it's reasonably expected that the CEO has the responsibility for ensuring that the rules of the organisation are complied with and appropriate, and the Act requires certain records are kept, and so the responsibility lies with the CEO and its officers. Which is the National Secretary, and can you remind me who was the National Secretary of the AWU at the time? During the contraventions of the rules that we've found to have occurred, Senator, Mr Shorten was then the National Secretary of the AWU.
Thank you. And these documents that you said were being shredded, the 6 of them that were reconstructed, did you believe that how many documents or pages had been shredded or deconstructed, if that's a appropriate terminology. Was it 320 that you mentioned?
I think Mr Enright said
The,
340.
the expert assessed or estimated that on the basis of the shredded material before that we had and produced, that there were approximately 340 pages.
340 pages, of which we only know about 6.
No, well, the 6 is in addition to those.
Oh,
so there's the 6 pages that were reconstructed that were simply torn up.
They were torn, not shredded.
That's exactly right.
Right. Sorry, thank you for that clarification, and you did say that. I just didn't tweak to that, so thank you. I suppose it's speculative, but one assumes that if pages were torn, albeit copies of something where you ultimately found the originals in any event, but do you have any idea at all as to what provenance or whatever the terminology is of those 340 pages that went through the shredder? Were they just telephone notes and other things of no consequence? All officers have shredders, including mine, but I don't think anything of great moment passes through my shredder. But given that there was a whistleblower in the Australian Workers' Union that necessitated or convinced a magistrate to issue a search warrant, one assumes that this was not just done on a whim, but on the basis of substantial evidence. Are we able to get an insight as to those 340 shredded documents?
Unfortunately, Senator, because of the nature of the shredding process, our forensic expert was not able to provide, other than to say they appeared to be A4 size. In the expert's view, assessed them as being about 340 pages of A4 size paper. So they weren't paper receipts or those sorts of things, within the bounds of the expert's ability to estimate that on the basis of shredded material, Senator.
So it was more in the form of actual documentation that was shredded as opposed to the odd handwritten note or something of that nature.
That was the very broad assessment by the expert, Senator. Yes.
Yeah, very, very, very serious indeed. Are you in a position to provide those 6 reconstructed documents? Take it on notice.
I'll take it on notice.
Yeah, see if legally, etc., it's appropriate or not. Yep.
Thank you, Senator.
I understand that the registered organisation wrote to the AWU in relation to its failings and admitted contraventions as identified in the investigation. Once again, possibly take on notice, but are you able to provide us a copy of that correspondence?
Our letters to the AWU?
Yes.
Yes.
Yeah.
I think we
and
will
their admissions?
Yes. The letters, yes. The admissions, I'd have to take that on notice.
Yes, of course. Understand that because there may be sensitivities around that.
In fact, I think we've recently provided the letters that I sent to the AWU. They've been tabled in response to a question on notice.
Oh, they have been?
Haven't yet. We've been asked about them recently in a question on notice, and they have not been tabled.
Right.
Yes.
Right. Well, did those questions emanate from a particular senator or not? Because I think I've got a fair few on notice.
Yes, Senator.
Yes,
they were
right.
your questions on notice, yes.
Right. All right, we will await those answers then. The conclusion of the investigation, what matters exercised your mind as to when you're released? The
As to when it was released?
Yes.
Well, the investigation came to me on the 21st of December, so immediately before Christmas. And it actually coincided with a funeral of a close family member. I went through the report and the recommendations after having had a short period of leave over Christmas, and I finished my consideration on the 24th of February. So the day I finished was the day, as I mentioned to Senator Pratt, that we issued a media statement and we notified the AWU of the outcome of the investigation, and the date was related to when the work was finished.
And you are an independent statutory agency?
Yes, definitely so.
And you did not in any way communicate with a government or a minister in relation to an appropriate date for you to issue your press release?
No, not at all.
Because, can I read to you, after a 5-year-long political witch hunt that has cost taxpayers millions of dollars, this government has used the cover of the Russian invasion of Ukraine story to quietly just drop everything because of the absence of sufficient evidence. That does not represent the truth, does it?
No, not at all, Senator. It's
Do you know who said that?
Someone who should get a book deal for creative writing.
Oh, well, Mr. Shorten would be the winner of that, because that is what he... Now, if I've got this right, I think this was a tweet that he sent out.
There are a number of errors in it, apart from the main premise.
Yeah.
The reference to spending millions of dollars on an investigation is completely incorrect.
But we do know that the Australian Workers' Union spent $1 million on trying to stop your investigation in all their
yes, they tried to
ill-considered legal proceedings. Have you been able to recover any costs from the Australian Workers' Union in relation to their failed proceedings?
Yes, we recovered the sum of $10,000. Just bear with me, Senator. $10,365.46, and that was for costs thrown away as a result of the AWU amending its case theory at the trial, which the judge would only permit if they'd agree to pay the costs, because normally this is a no-cost jurisdiction. And from memory, it was on maybe the second or third day of the trial that they revamped their case theory. I can't remember exactly, but
right.
I don't believe it was the first day.
Right.
So the costs we incurred were in relation to defending a very broad brush attack on the Rock. And as you know, we were found to have run a valid and lawful investigation by the full court of the Federal Court of Australia, and there have been no grounds advanced by the AWU that were upheld by the court.
So this has continually been labelled by the former National Secretary and the current National Secretary as a witch hunt, but as I understand it, the Australian Workers' Union have admitted now that they were in breach of their own rules. Is that correct?
Yes, Senator. And of that 4-year period that was referred to by someone, over 3 years was involved in the litigation. So that litigation was brought several days after we commenced our investigation. When the litigation was brought, we quite properly suspended the investigation, and we didn't resume it until we had the decision of the full court of the Federal Court confirming that the investigation was valid and lawful. And from there, again going from memory, I can correct it on notice if need be, but the investigation then I think took about a year or thereabouts, maybe slightly over, and that involved a lot of serving of notices to produce and getting documentation, and also I think we allowed some extensions on account of COVID. Right. So the investigation itself was not really the set piece when it comes to the expenses, but it was one that as we pointed out, could have been concluded quite quickly.
Senator, I need to assist you as well as that. I've heard this reference to witch hunt, but the facts in this matter demonstrate that this investigation had nothing to do with any particular individual in the AWU, because the problem wasn't with any particular individual in the AWU. The problem, Senator, was that over more, over more than a decade, there had been a culture of systemic, ongoing and serious governance failures in the AWU. That had been going on at least in what we now know between 2006 and 2017. The AWU has recently admitted to just under 25,000 contraventions of the Act in a separate investigation, Senator. In 2017, when we were deciding whether or not to conduct this investigation, we were actually looking into 3 separate matters. One of the branches of the AWU had been claiming for a number of years that it had no financial affairs and was claiming exemptions from financial reporting, until we discovered that the branch actually was or had financial affairs and had a credit card and was spending money. At that time, we were also looking into the
which branch was that?
The Queensland branch of the AWU, Senator, and they have since admitted that they had financial affairs. But this is what we were looking into at the time of this investigation. At the same time, Senator, you might recall we were investigating the Victorian branch of the AWU and Mr Mellom in relation to dishonestly using company-paid memberships and registering people who had no idea they were members. That was ongoing at the time. And the third issue we were looking at, Senator, at the time of this investigation, or when this matter arose, was the membership issue. And as I've just said, as recently as the last couple of weeks, Senator, the AWU have admitted to just under 25,000 contraventions of the Act over a period of a number of years.
25,000 contraventions.
Yeah. So
that
Senator,
doesn't happen by accident, does it?
No, Senator. So that's why I'm saying there's this culture of breaches and a culture of governance failures. So in every year, Senator, between 2007 and 2017, in each consecutive year, the AWU has now admitted that it was either breaching its rules or breaching the Act, or both, in every consecutive year between 2006 and 2017. And that's why, Senator, I can assure this committee that the investigation had nothing to do with any particular individual in the AWU. It was because of that compliance of governance failures over more than a decade.
Well, that's very interesting, because so whilst you say that it was a culture and you didn't finger any individual, there is one individual that has been protesting far, far too loudly over the period of time, and I think he has fingered and identified himself. But let's deconstruct what Mr Shorten told us. After a 5-year-long political witch hunt that has cost taxpayers millions of dollars, it did not cost millions of dollars, so that's incorrect?
The cost of the investigation, external legal costs, were just over $95,000.
Right, thank you. Then this government used the cover of the Russian invasion. Well, the government had nothing to do with the issue of the press release, so that is false as well.
Correct, Senator.
And then to drop everything because of the absence of sufficient evidence. And can you just quickly remind us as to why there was not sufficient evidence? That was because documents were either missing, not existing, or very, very bad record keeping, so they became the beneficiaries of the absence of sufficient evidence, which they themselves were the architects of.
So that was insufficient evidence to bring actions for breaches of officers' duties, but there was sufficient evidence in relation to the missing and late loans, grants and donation statements. But because the organisation had improved its compliance very significantly since the period of the investigation, we elected not to take action.
But in many ways the beneficiary of their own destruction of documents.
Yes, yeah. They were the beneficiaries.
And just to make sure it is crystal clear, something that Senator Pratt raised earlier, the only legal action in terms of the courts taken in relation to the AWU in any way was instigated by the AWU.
With members' money and each and every claim. How many of them were in the original statement of claim and each and every one of those claims failed?
I'll correct myself on notice if need be, but I think there might have been 10 separate grounds. A lot were related to suggestions that we were unduly influenced by the minister. The trial judge at first instance rejected that completely.
When you've got Justice Bromberg denying or finding that there's no evidence for that, I think we can all be very satisfied that there was not a single shred of evidence.
It speaks volumes.
And that was upheld by the full federal court.
Yeah. All right. Look,
Senator, I've mentioned I just want to make it. I think it's got to be fair to the AWU. I've mentioned the compliance failures, the governance failures over a period of time. I need to say, Senator, that most of the people in the AWU, most of its officials and members, are working very hard and doing a terrific job for their union, representing their union. So and we know that. We know that almost every registered organisation, unions and employer associations, are just interested in compliance and doing the best that they can, and that applies to most members in the AWU as well, Senator. So the compliance culture is undoubtedly there over a decade, more than a decade. But I just need to say, in my experience with the members of the AWU and officers, the vast majority want to do the right thing.
Yeah. All right, Chair. Thank you very much, and
thank you very much, Senator
Registered
Betts.
Organisations Commission.
Thank you, and I believe no senators have questions left for Registered Organisations Commission, so thank you very much, Mr Bilecki. Congratulations again on your reappointment. We'll break for morning tea, and we'll come back at 11:15. Right. We commence the hearing and formally welcome officials from Safe Work Australia. Thanks for joining us this morning. Do you have an opening statement?
Thank you, Chair. Michelle Baxter, Chief Executive Officer. No, I do not.
Thank you, Ms Baxter. I will go straight to questions and to Senator Pratt.
Thank you very much. Good morning, Ms Baxter. So I'm going to ask at the outset about some questions on the Boland review. We've talked about this many times. Wouldn't be estimates, I don't think, without these questions. The Labor Party's concerned about all the necessary actions being taken to ensure the implementation of the Boland review of the model of work, health and safety laws. They're pretty critical, aren't they? Wouldn't you agree?
Yes, certainly, Senator. Very important work that we're undertaking.
Ms Baxter, we've had 3 separate independent government commissioned reports, that is Boland, Respect at Work and the Productivity Commission, who all urge the Commonwealth Government to take action on strengthening and improving model work health and safety laws with respect to psychological injuries, because there's a need to ensure that duty holders are required to notify or report psychological incidents, injuries and illnesses to regulators. And that includes sexual harassment, bullying and harassment and occupational violence. As you would understand, the kind of action recommended includes regulations and codes of practice, but it's my understanding nothing has happened yet. What's your agency doing?
Senator, thank you for that question. I think you are referring to recommendation 20 of the Boland review in relation to the review of incident notification processes. I might just let you know that there is a meeting of Safe Work Australia members tomorrow at which members will consider a range of options in relation to amendments to incident notification provisions in the model laws.
Amanda Johnston, Deputy CEO. I'd like to add, Senator, as well, that it's not the case that we've done nothing in relation to sexual harassment. The model code of practice has been agreed by members and will be provided to ministers for decision as soon as the psychological health and safety regs also are finalised, and they're also with members for consideration at the moment. So the agency has finalised the regulations with the Office of Parliamentary Counsel, and we've also finalised a model code of practice. So we have actually done undertaken a significant body of work.
What proposals has the agency led by you, Ms Baxter, made to Safe Work Australia members and the federal government to change incident notification provisions of the Work Health and Safety Act to ensure the visibility of sex harassment and work-related psychological injuries?
I'll ask Ms Johnston to take that one.
So as Ms Baxter spoke about, we've provided a discussion paper and an options paper to members, and that will be considered tomorrow at our meeting. It's already been considered by our SIG WHS group twice. Again, a significant body of work that has been progressed and has been progressed since November last year. So now it's being considered by members.
Why is it taking so long? Is this, do you consider that there'll be a final outcome tomorrow, or are we going through yet another iteration of proposals?
Senator, it's not another iteration of proposals. Our governance arrangements ensure that the SIG Work Health and Safety Group consider proposals first. That's something that's agreed by all our members that has to occur, and then it goes to members. It's a significant body of work changing notification provisions, so it can't just be done overnight. It has to have complex policy thinking, and that's what we've been doing.
Okay, but we were given solutions in the Boland Review, most certainly by Commissioner Jenkins, in terms of preventing sexual harassment. We've had government time and time again say, yes, there's a positive duty, and yet these changes have not yet been made.
So I think, Senator, we're conflating a number of issues there. So we already have a positive duty for work and safety, and we have codes and guidance that are going to be published. The incident notification review is a separate piece of work, and as we spoke about at last Senate estimates, the Respect at Work data recommendations is a separate piece of work again. That's not being led by us, that's being led by the AHRC.
I understand
so that's
that.
Not work that we're
I understand that, but the government has relied on your work as an excuse for not acting more directly on the decisions that Commissioner Jenkins made in the Respect at Work report.
The government hasn't made anything of the sort. The government has accurately observed the position at law and has lent into the existing duty to ensure that we properly protect everybody from all kinds of unsafe behaviour at work. And we have done so to ensure that we aren't putting duties or responsibilities of employers in obscure places. We want to put it where it's front and centre, where it's visible, when people know what it is.
So why
I don't accept the characterisation of the government's action that you load into your questions.
The Boland Review is 3 years old. Why are we still waiting?
Senator, I might start with that. So there has been a range of factors, and in Minister Cash's evidence last week, she did point out that it was one of her highest priorities and her first priorities when she was made minister. She convened a meeting of the responsible work health and safety ministers to consider the Boland Review. Every recommendation was considered and dealt with at that meeting. And the Safe Work Australia was tasked with quite a significant load of policy work following from that. You've had evidence given that the Code of Practice has been finalised. In terms of sequencing, that now has to await the regulations. You've been advised the regulations are with the members for their consideration, and in addition, you've been advised that the notification requirements are also about to be with members for their consideration. I presume they're with members for the meeting tomorrow for discussion. So, in actual fact, what we've seen in a relatively short space of time in terms of a highly complex policy area is 3 very significant pieces of work progressed to advice to members level. Noting that Safe Work Australia is a body that's governed by its members.
But as you point out, Senator Cash has taken action. So the Boland report's 3 years old. Safe Work Australia, the Human Rights Commission's report, I think that was
Senator,
beginning of 2020. Senator Cash has been minister for, as I understand, a little over a year, is it? 2 years?
I need to check my dates, but so as I said, it is important to note that the Work Health and Safety jurisdiction and officials from all jurisdictions have been under a significant workload in relation to dealing with the pandemic, providing advice out to workplaces and working very hard. So while I think it is understandable that the immediate priority of COVID did actually take priority.
Over sexual harassment.
When Minister Cash came on board, she was very quick to convene a meeting of Work Health and Safety Ministers, and that meeting agreed the vast majority of recommendations and dealt with every single recommendation, and then has tasked Safe Work Australia to do the work. And the evidence provided by Safe Work Australia is that the Code of Practice is finalised, that the regulations are with members for their agreement, and at the next meeting, which is tomorrow, the notification requirements will also be discussed in terms of whether they can be finalised. So I think that's actually a significant amount of work.
Well, was that all done as quick as it could have been?
Certainly from my view is from when Safe Work Australia was tasked with the work.
When was that?
So that was subsequent to the meeting of the ministers. I need to get the date, but
was it one Senator Cash, when Senator Cash was minister?
That's correct. She was the minister at that time.
And we know that Minister Porter sat on both the Boland Review and the Safe Work, Respect at Work report for some time. So, yes, perhaps a lot of work has been done in the last 12 months. But so how close are we to getting this finalised? What if the election's called? What will it mean, more delay?
It depends on which aspect you're talking about. So
Well, perhaps you can tell me which aspects will be delayed and which parts won't.
So the members are appointed. The normal requirement is that it's the majority of members I think it has to be 6 members agree to the changes, and then it's able to be progressed to the model laws. It then becomes a matter for the jurisdictions to whether they take up those changes within their own laws. But I might pass back to Ms Baxter to provide further advice.
Thanks, Mr Hare. Yes, the work of Safe Work Australia will continue once a federal election is called. As Mr Hare noted, it is then the members may approve changes to the model laws. That would then go to ministers, and then it would be up to each jurisdiction to determine how and when they would implement those amendments. And so, yes, we will continue working through the caretaker period.
How is it a positive duty that the Commonwealth is taking action on if the states are still choosing whether they will put them in, implement those practices?
Sorry, Senator. So as we've spoken about at previous estimates, we already have a positive duty, so that's not a decision.
Yes,
being
but you
considered.
said you were going. Yes, I understand that, and let's not squibble over it. You said that this was being beefed up and it was going through the process, through the Safe Work Commission's processes with the states in order to implement and firm up those psychological hazards. You yourself referred to that.
So further guidance, I think, was the phrasing used. So the the regulations will provide further guidance, and the Code of Practice will again provide even more detailed advice. But I'll pass to Ms Baxter.
Yes, thanks, Mr. Hare. Senator, just to be very clear, the proposed amendments to the regulations in relation to psychosocial matters will not add any further duty or impose any further obligations on PCBUs and workers. What the regulations will do, though, is provide some clarity, and of course that will then be supported by a suite of material that will be directed at businesses and employers and workers of different sizes in different businesses in different industries. So I just want to be very clear, the obligation of positive duty already exists. The regulations will simply seek to provide more information, more assistance to PCBUs.
Have you talked to the Australian Human Rights Commission and Commissioner Jenkins about how comparable those new provisions and guidance will be with what Commissioner Jenkins had herself recommended in relation to sexual harassment as a psychosocial hazard?
Senator, I'm a member of the Respect at Work Council, so I have regular interactions with the members of that council, including Ms Jenkins. And I'm also aware, and Mr Hare can probably speak to this in more detail than I am aware that the Commonwealth member of Safe Work Australia has consulted with the Australian Human Rights Commission in relation to these proposed amendments.
Okay, so does that mean they do or don't meet the standard's probably the wrong word? Do they meet the threshold of protection that Commissioner Jenkins was looking for in her report?
So, in relation to the consultation process, and I can't recall whether this was dealt with in the other committee hearing for the other parts of the department, there has been, as the government identified, a consultation process.
So was that the question I asked?
I think so, yes. I'm trying.
No, so does the consultation process tell you whether the threshold has been met or not?
So the consultation process includes consultation with the Human Rights Commission and other agencies around actually what the recommendations from Commissioner Jenkins' report and the interaction with the existing work health and safety laws and their positive duties. So yes, that consultation goes directly to that.
Okay, but what's the finding of that consultation?
So that consultation is still being finalised. So there's no written up report yet.
So we don't know whether what the government has pointed to as being its way of resolving Commissioner Jenkins' recommendations as yet meets the threshold for protection that she called for.
So, Senator, I don't think that's a correct characterisation of the government's position. The government's position was there is an existing positive duty within work health and safety laws, and that further work needed to be undertaken, particularly consultative work in terms of understanding the potential interplay or interactions between the recommendations from Commissioner Jenkins and the existing work health and safety obligations, and that's the work that's being undertaken.
Ms Baxter, I note that the WA government has recognised insecure work in its new code of practice on psychosocial hazards in the workplace under the State's Occupational Health and Safety Act. As a member of Safe Work Australia, do you support this move? Do you agree that insecure work is a psychosocial hazard?
Senator, I think any work where there could be uncertainty could possibly create a psychosocial hazard, but it would be very much dependent upon the circumstances of the particular issue. So I'm unable to say categorically whether it would or would not be.
Okay. Under what circumstances does insecure work have an impact on workplace safety in your view?
Senator, I'm not sure if our individual views are really relevant. It's our members' views. And
Okay,
so
well,
our members, when doing their psychosocial guides, have looked at insecure work as a psychosocial risk. Members decided not to include it specifically, but they have included a number of psychosocial risks for consideration. And so, yeah, that's the decision that's been made. We're aware of the approach taken in Western Australia. That hasn't been the approach that's been decided by our members.
Okay, so what impact does insecure work have? I'm just going to go back to, well, WA obviously thinks that insecure work is a psychosocial hazard, or could be. Ms. Baxter, you have said that it can be under some circumstances. What would those circumstances, according to the views of some of your members, be in relation to the circumstances under which it could have an impact on health and safety?
Senator, this is, sorry, I'm just reiterating Ms Johnston's evidence in terms of the issue of insecure work and addressing it through Safe Work Australia materials has been considered by our members, and the majority of our members did not wish to include reference to insecure work as a psychosocial hazard. So I rather think that my personal views are, not relevant. It is a decision of the members' body, Safe Work Australia. So I don't think I can take this any further.
And look, if I could just say here, I think these questions are varying to asking the official for an opinion on policy, but I'll let the witness answer these questions in the way she sees fit.
Thank you. Ms Baxter, when will changes be made to the Model Work Health Safety Act by Safe Work Australia on your website to remove outdated provisions in section 117? The version on your website is dated December 2019. Is there a reason for this?
There is a reason for that. That's the most recent compilation of the Model Work Health and Safety Act. So that the publication of the Model Work Health and Safety Act is actually owned by Parliamentary Councils Committee, and that's the most recent compilation. So it will be updated when the most recent amendments are finalised, and as I said, they're with members currently.
What leadership is your agency providing to ensure that agreed changes to Model Work Health and Safety Act are implemented as soon as possible?
Senator, we work very closely with our jurisdiction members to provide them all that they need in order to progress the implementation of any amendments to the model laws. We make ourselves available to answer any questions they may have. As Ms Johnston has said, our latest set of amendments are with members at the moment. We're just waiting for their feedback, and we have been available throughout that process to assist them should they have any issues in relation to reconciling what's in the draft amendments to what the policy is that members have determined, and ensuring that that lines up with what was determined by Work Health and Safety Ministers in May of last year.
Okay, so the majority decision, can you just, I did ask the question and I'm just seeking to clarify, in relation to the version on the website is dated December 2019. Can you tell me what 117 covers. I think it's right of entry. Which states objected to agreement on that provision?
Senator, 117 is being amended. It will be amended, but it hasn't been amended yet. It is the right of entry provision, but it hasn't been amended yet, which is why the Model Act still reflects the provision as it is. The amendment hasn't been made yet.
Okay, what's the delay?
There is no delay. It has been drafted and it's with members now to do the final sign off on it. It's a whole raft of amendments. So the ones that I spoke to about before, psychological health and safety, they're part of this whole suite of amendments that are being progressed as part of the Boland review. So once members agree that they reflect the policy decision of WHS ministers, the Act will be republished with a 2022 version.
2022 version to implement the changes to the Act. Okay. What leadership is your agency providing to ensure that agreed changes to the Model Work Health and Safety Act are implemented as soon as possible? So 117 would be one of those, and Section 72, which are minor amendments in relation to the training of health and safety reps, but still have not been made.
Senator, I think you already asked that question.
So I'm just trying to clarify the actual question, Senator. So Safe Work Australia is tasked by the Work Health and Safety Ministers to implement their agreements around the Boland Review. They prepare that. As Ms Johnson identified, there's a substantial bulk of those recommendations are currently before members. Once they're agreed, they will be added to the model laws. It's then up to the jurisdictions as to whether they then implement those changes in their own Work Health and Safety Acts. So I'm not quite sure in terms of the leadership. So the role of Safe Work Australia is to implement the decisions of the ministers and to work with the members to ensure that happens. They've identified that they're working through, they've got a substantial amount of those ministerial decisions before members at the moment, and as soon as they're agreed, they will go to the parliamentary councils for amendments to the model laws, and then it becomes up to each individual jurisdiction about whether they implement those those changes.
What's the number of votes? It's the majority of members, as in the states and the Commonwealth.
My recollection is it's 6, but
And then once a majority of members has decided, then the states can go away and decide whether to implement what the majority has asked for.
that's the way the model laws work, yes.
Yep, that's what and so I do understand that it can, that is the process. But in that context, which areas of model law did the Commonwealth, for example, support changes to Section 117 on right of entry or not?
I'd need to take that on notice. I can't remember the specifics of that one. I would need to go back and check.
And what about industrial manslaughter?
I think the Minister was clear at the time that was not supported by the Commonwealth.
And what about insecure work being a psychosocial provision?
I'd need to take that on notice, Senator. I would note that in relation to, there was 2 recommendations in relation to the industrial manslaughter. What ministers agreed was to change the defence to lower the defence available to allow both. So it's no longer a requirement to prove recklessness. You can also prove the lower order of negligence, gross negligence. which is the same test that's actually applied in most manslaughter laws. So the test is the same. The difference is that the industrial relations laws the work health and safety model laws don't actually require a death. They are able to be applied when people are put at risk of serious injury and or death. And it was a view taken by the majority of ministers, in fact I think nearly all ministers, that strengthening those laws by adding in the gross negligence term was an appropriate measure to do, and was consistent with the keeping of the principle within the Safe Work legislation of being preventative rather than post action.
Ms Baxter, has the Commonwealth ever used a casting vote in decisions that are within that council, or
Senator, there's no casting vote. It's the Commonwealth would be either on the side that's the majority or on the side that's minority. There's no casting vote concept.
No, they have one vote like every other state, is that correct?
That's correct.
So casting vote is of course, well, I guess it's kind of seen as the presiding vote in that the Commonwealth is represents the whole country, and
certainly not in the work health and safety context, Minister.
It's just not how it operates.
No, I understand. I understand that. The
Unless,
issue
of course,
is,
you'd like the Commonwealth to have, say, 8 votes on things like this, the National Cabinet for 6 states and 2 territories. I'm sure we could arrange that.
The issue is that the Commonwealth has used its vote to be less proactive in changes to work health and safety than some states would like, and the Commonwealth has time and time again pointed the finger at the states for slow progress on these issues. Anyway, Ms Baxter, can I ask for your characterisation?
I think Mr Hare was going to answer that question, you can't just sledge and then not allow him a chance to respond.
I certainly don't think we're pointing the finger at the states on the slow progress. I think my evidence was that these are complex policy matters, that there was a substantial body of work, and that Safe Work Australia has been working within its team and with its members as it's required to do to reach a position. The fact that those members have views is completely consistent with how those discussions should proceed. Ultimately, the view is that with extensive discussion and debate, we will have a better product.
Okay. Can I ask when we expect the changes to psychological injury, bullying and harassment, what issues are on the table tomorrow, and when do we expect that to be implemented?
Senator, if you're talking about the regulation amendments,
yes,
those are not, they're not on the agenda for tomorrow's Safe Work Australia members meeting. As Ms Johnston has said, those amendments as drafted by Parliamentary Councils Committee are now with Safe Work Australia members for them to consider and confirm that the amendments as drafted give effect to the policy as determined by Work Health and Safety Ministers in May.
Which has already been determined. And when do you expect that work to be complete?
Senator, we are in the hands of our members in relation to that. As soon as we hear back from all our members, we will be in a position to notify Parliamentary Councils Committee one way or the other. And if there is support for those amendments in the sense of they do give effect to the policy decision of ministers, then we will ask the Parliamentary Councils Committee to incorporate them into a revised version of the model laws, which we will then post on our website, and those provisions are then made available to jurisdictions to consider for implementation in each jurisdiction.
Okay, so when are you expecting all of that work back? Is there a timeline? Is it in the hands of consultants?
No, so Senator, it's with members. The timeline for responding has passed. We'll be reminding members tomorrow if they could please respond to us as soon as possible.
Okay.
So
The timeline has passed.
well, the time for responses has lapsed.
How
and we're
many
just
states
waiting
have
on-
responded according to the timeline?
So it's not just states, it's all of our members, including our social partners.
Yes.
And at the moment, I think we're awaiting 3 members' responses, but I would have to take that on notice to be sure.
Do you have consultants doing what would otherwise be standard public service work in relation to these issues?
No, we undertook all of the work in relation to these issues.
Thank you. I'm now going to move on to some questions about silica. The budget papers estimate 250 Australians are diagnosed. Sorry, Chair, are you okay for me to continue?
I'm just checking. No, you're absolutely fine. We don't.
Silicosis each year, and the National Dust Diseases Task Force records that 1 in 4 engineered stoneworkers have contracted silicosis. That appears to
Senator,
me...
I think this first statistic may be incorrect. I think that's a total of 250, not 250 each year.
Okay, if you can clarify for us, over what timeline was that diagnosis of 250?
I might throw to Ms Bryant if she has that statistic with her, but if not, we can take that on notice and provide it to the committee.
Meredith Bryant, Branch Manager, Evidence and Strategic Policy Branch. Senator, I'm able to provide data that we compile from the National Dataset for Compensation-Based Statistics. They're the dataset for which we collate information about silicosis. So I can confirm that over the past 5 years, that's 2015-16 to 2019-20, there were 965 accepted workers' compensation claims for silicosis lodged in the NDS. Of those claims, 62% were lodged in the 2019-20 financial year following significant awareness campaigns relating to silicosis. Over this period, a further 170 claims were reported through the New South Wales Eye Care Scheme, 63% of which were in the 2019-20 financial year. I would note there are limitations to using these data to estimate the total number of silicosis cases, however, because it is collated from a range of different sources and does follow that significant investment in detecting cases. So they just need to be interpreted in the context of them being administrative statistics rather than incidence or prevalence figures.
Okay, how many stone workers working with materials that create a risk of causing silicosis are there in Australia?
Senator, Safe Work Australia doesn't compile those types of data, but I understand there are figures that have been reported by some of the peak bodies, but I don't like to comment on those as they're not sourced from our national collection. So yeah, you'd need to refer to the literature, I'm sorry.
How do we know that they're all getting the right information if we don't know where there are and how many there are? Is this a correct estimate,
Senator,
that 960? How do we know that it's... How big is this problem going to get in your estimation, Ms Baxter?
Senator, we're currently conducting a regulatory impact assessment in relation to both regulatory and non-regulatory options to manage the risks of respirable crystalline silica from a broad range of silica-containing products, including we will be examining a licensing scheme for engineered stone. Consultation on the draft regulation impact statement is expected to commence in April 2022, at which we anticipate and hope to receive broad public input, including evidence from those who may have evidence of these issues and how big the issues are. So we're eagerly anticipating that public consultation to inform us in terms of then what we would progress to our members in relation to whether there need to be regulatory or non-regulatory options in relation to respirable crystalline silica and its potential for causing silicosis or accelerated silicosis.
What's the ongoing prognosis for people who have silicosis, as far as you're aware?
Senator, I do not have any medical qualifications. I think you would be better directed to put those to a person who does have medical qualifications.
Okay,
I wouldn't wish to misrepresent the situation.
No, okay, but we've discussed silicosis over a number of years now, and 960 people already is a pretty alarming number. When we've discussed it in the past, it's appeared that everything's in hand, that yes, regulations are in place, that it's all being worked on. Where's the urgency here if we don't even know how big the epidemic of silicosis is?
Senator, we've had an occupational lung disease work plan in place for several years now at Safe Work Australia, and we've undertaken a number of initiatives, including the development and promulgation of guidance, including an education and awareness campaign, a Clean Lungs, Clean Air campaign. And Senator, in fact, we are taking tomorrow to members a proposal for an updated refreshed work plan in relation to occupational lung disease or occupational respiratory disease. So there is a great deal of work being done, not only by Safe Work Australia, but also by individual jurisdictions and also by the social partners with whom we work. These issues are being treated with the utmost seriousness and urgency. I'm aware that a number of jurisdictions have proactively initiated screening services of workers who work in the engineered stone benchtop industry. I'm aware that a number of jurisdictions have initiated proactive audits, site audits and inspections of workplaces where engineered stone benchtops are being worked on. So there is a great deal of work that's being done in relation to these issues, and as highlighted by the Dust Disease Task Force, and I believe it was 2 days ago that all Australian governments published a response to the Dust Disease Task Force recommendations. Okay, so are you able to tell us, noting that silicosis is entirely preventable, in terms of stonework that's going on in Australia across the jurisdictions, how much is occurring in a safe way and how much is occurring in an unsafe way?
Senator, that's not really...
Senator,
Sorry, Ms Baxter. That's not really the role of Safe Work Australia. That's the role of the individual work health and safety authorities.
I understand that, but we need a national picture of the problem. Is that not a fair question to put that picture together? How can it be urgent if we don't know how bad the problem is?
So, as I was saying, the state-based regulators are the people who go out and do the inspections. Ms Baxter may have information that they've provided her, I'm not sure, but it's actually at the workplace level, it's actually up to the work health and safety regulator within each jurisdiction. I'd also point you to the fact that we now have agreed positions on the National Dust Disease Task Force, which was released just recently, where on the 4th of April, where the responses were endorsed by all jurisdictions. So there is certainly a significant amount of work. That consultation process, the work that Safe Work Australia and the work that individual jurisdictions are doing does show that there is a national focus on dust diseases. But I'm not sure whether Ms Baxter does have any information from the regulators, but just recognising it's the role of the regulators to go out and do the inspections in workplaces.
Ms Baxter, what does that picture look like as far as you're aware?
Senator, I would need to take that on notice, as I'm not certain that we have all of the information from all jurisdictions that could possibly assist you. So yes, I'll take that on notice and we will provide that information.
Okay. Asbestos was first recognised as a risk in the 1930s, but it took until 2003 with big campaigns against companies like James Hardie Industries over decades for compensation, etc., before it was banned in 2003. Silicosis was first identified in 2016. 6 years have passed. We know it's directly attributable. Are we looking at the banning of these stone products, or are you confident that they can be safely managed without the need to ban them?
Senator, with respect, silicosis has been a disease, I understand, that's been around for many hundreds of years. Yes,
so
it's
engineered
not
stone
just been,
really is what I should have been clear in my question.
Yes. So, Senator, we at Safe Work Australia have not been asked to look into the issue of whether the product should be banned or should not be banned. So we're not doing work in relation to that issue.
Senator Stoker, what will the government do? Is the government confident that this can be safely managed, particularly if we're unclear about who's at risk and how at risk they actually are? Is Safe Work Australia the only way we've got of managing and resolving this issue?
I'd suggest that Safe Work Australia is well equipped to manage the issue, in the sense that they are specialists in ensuring that systems of work are safe for Australians. I don't accept the proposition that we don't know how serious the problem is. You've already had statistics provided to you in this session about the number of people who have come forward with claims arising from this.
But we don't know how many people are being exposed on a daily basis.
It looks like Mr Hare's got something to add here.
So, in relation to the National Dust Diseases Task Force recommendations, there was a recommendation which was commence the processes required to implement a full ban on the importation of some or all engineered stone products if by July 2024 there is no measurable and acceptable improvement in regulatory compliance rates for the engineered stone sector as reported by jurisdictions, and evidence indicates preventative measures are not effectively protecting those working with engineered stone from silicosis and silica-associated diseases. The agreed response from all jurisdictions is a ban will only be considered if there are no measurable improvements in compliance and or preventative measures prove to be ineffective. This will require governments to work together to develop a comprehensive framework to evaluate the effectiveness of compliance with work health and safety duties and the effectiveness of measures to protect workers, including any further measures implemented following Safe Work Australia's RIA process. Notes that more time than that proposed by the task force may be required to make this assessment. So there was a qualification, but I think broadly the recommendation, the agreed position is consistent with the recommendation from the National Dust Diseases Task Force that if there isn't any measurable improvement in compliance and or the preventive measures are ineffective, then a ban will be considered.
Okay. Can I ask Ms Baxter, what resources, money, activities are focused on demonstrating that it can be prevented through good occupational health and safety? Is it inevitably going to be banned because the work hasn't been done, or more time? Is the industry going to ask for more time because enough work hasn't been done? What's happening in relation to the prevention of silicosis?
So, Senator, a lot of work has been done. So, immediately after Safe Work Australia started its occupational lung disease program of work, the WES level for silica was reduced, and that has been implemented in all jurisdictions. That was done urgently by members in jurisdictions. Then we published guidance, national guidance on working with engineered stone, and we now have a model code of practice on working with engineered stone. We're also drafting amendments to the work health and safety regulations to prohibit dry cutting of engineered stone. So it's not the case that we haven't done anything. We've done a significant body of work, and now we're taking that work further by doing the RAA for all occupational, for all silica industries, to ensure that it's not just about protecting people in engineered stone industry, it's about making sure we understand how big the problem is for all of those people who work with silica-containing products.
So the work on the regulations is there. How do you know if that's hitting the ground in terms of funding for prevention activities which utilise the hierarchy of control approach? That is, the regulations are fine, that's all well and good, but actually we've got to make sure they're being implemented, and that when people are working with this material, that it's done in the safest way possible.
Yes, so I think that's a matter of compliance and enforcement and funding for those activities, which is a matter for states and territories.
Okay, so compliance and funding in terms of whether we're going to come to that point in time is all a matter for the states and territories.
So, I'll just add to that, if I may. So the National Dust Diseases Task Force agreed recommendations did acknowledge that, and it said this will require governments to work together to develop a comprehensive framework to evaluate the effectiveness of compliance with work health and safety duties and the effectiveness of measures to protect workers, including any further measures implemented by the Safe Work Australia's regulatory impact assessment process. So there is an acknowledgement in the national response that this will require governments to work together and regulators to work together.
Okay, but the budget announced 11 million over 4 years, but regulation tells people how to prevent something, but it's not prevention itself, is it? Where's the implementation of prevention in terms of the government's commitment? Is it just a matter of for the states?
So the National Dust Diseases Task Force is an agreement, it is an agreed position from all the jurisdictions, is my understanding. So sorry, it's a bit awkward. So you do actually have to have the regulations and the processes and the in place, and then you also need to make sure that they're enforced. So Safe Work Australia has been working with its members in terms of what do those processes look like, and then it does go to the regulatory bodies to make sure that they are actually practiced. So it's not just an either or, it requires both.
Unless this is done urgently, then the timeline government has set, that has been set, means that
Senator, so
the prevention isn't actually going to be taking place. We're still looking at options for a licensing scheme for engineered stonework.
Yes, Senator. So there, as the evidence provided by Ms Baxter and Ms Johnson, is that a number of jurisdictions, so all jurisdictions have been looking at this. Safe Work Australia has been looking at this and has provided advice. There's also work underway within individual jurisdictions, so there is a significant focus on this. but I'd pass you back to the evidence of Safe Work Australia that this is not just commencing now. It's been underway for some time.
Okay. Lessons from the Clean Air, Clean Lungs campaign, is that being used to inform future prevention activities? I understand it was terminated in December 2021. Have you evaluated the program?
So the Clean Air, Clear Lungs was a communication campaign to raise awareness of the risks of working with silica-containing products. So it wasn't terminated. It was a campaign that ran for a certain period of time, and we are looking at this. We're evaluating the impact of that awareness raising campaign, but I'm not sure I understand your question necessarily about how we're using it to inform the work.
Well, you're evaluating it. Well, clearly a regulation isn't going to help anyone if people don't know to implement them, or if individual workers don't know their own risks. Regulations coordinated by the states and the Commonwealth don't mean anything. So what role does a health promotion type framework for these kind of prevention activities, what onus are you placing on that? What's the outcome of your analysis of that campaign?
So, Senator, we don't do health promotion. We promote work health and safety matters. And as Ms Johnson has said, we are currently in the process of evaluating that campaign with a view to whether our members are seeing any changes in any of their statistics that they provide, their data that they provide to us. And we will also consider whether a further campaign is warranted, particularly as we progress further developments. I might just note that the laws already provide for workers to be protected from the potential hazards and risks of respirable crystalline silica. So there is already a legal framework in place that provides that protection, and jurisdiction regulators around Australia are performing enforcement and compliance work in relation to that framework, which already exists.
Will a miserable 4% for prevention from the government that's been allocated in the budget be enough to stop this scourge of disease?
I might. So the 11 million that you're referring to, I think, is actually within the health portfolio, not provided to Safe Work Australia. So it might be better to direct the effort to those questions to them. I think the evidence is that there is already existing preventative measures, that there's further work being undertaken, and that jurisdictions are all engaged in trying to address this problem. I think in reality, you have to look at the entire effort, not just one aspect of it.
And given that, Senator Pratt, you've asked a question about whether these measures are sufficient.
I have.
And that indicates that you don't know whether those matters are sufficient. I'd suggest you're not really in a position to say whether or not it's miserable. If it's effective, then it's the right allocation.
You're telling me, Senator Stoker, that no one's at work today exposing themselves to contracting silicosis at work because it's effective?
That's what you have just said. That is not what I have said. What I have said is that Mr Hare is right, that the approach that's been taken brings together a health response, a workplace safety response, measurement efforts, and holds open the prospect of restricting the ability of certain substances being used in the event that that doesn't come together.
Okay. Can you step us through what happens next on the National Dust Diseases Task Force with respect to next steps from the point of view of Safe Work Australia? Sorry, perhaps you didn't hear me. Please step us through. Yeah. What happens next?
Sorry, Senator. Yes, Senator. My understanding is the National Dust Disease Task Force has concluded its work, and all governments around Australia have responded to the recommendations coming from that task force. There is a recommendation relating to work that is already underway in Safe Work Australia, and that's the regulatory impact assessment process that I noted earlier. As I said, we are expecting to commence public consultation in April, so this month, and that public consultation period will be open for approximately 6 weeks. It could be longer, depending on the amount of interest that we get, because we do want to ensure that we hear from all of those who are interested to be heard, and also who may have evidence and information that would greatly assist us in then determining what options we propose move forward in the regulatory impact assessment process. So once we have the public consultation period, we consider those submissions that we've received. We will then work to finalise a regulatory impact assessment, which will then be considered by the Office of Best Practice Regulation in terms of whether the process is in accordance with the COAG guidelines in respect of such processes. And if it's assessed as being so, we would then take forward proposals to our members in terms of what has been shown or has evolved through the regulatory impact assessment process.
Thank you.
It would then be up to our members to determine what further action they wish to take, or wish us in the agency to take to progress the matters.
Thank you. And just before moving on from Safe Work Australia, I wanted to circle back. I did ask a question in relation to consultants pertaining to implementation of reviews and the work health and psychological injuries and the Boland Review, etc. And you said there were none. Can I ask separately, in terms of an overall picture within Safe Work Australia at a national level, how much Safe Work Australia is spending on consultants? And in what areas, please?
Senator, we only engage consultants where we do not have the expertise to perform the work ourselves.
Yeah.
Predominantly that is in the area of undertaking economic assessments and cost-benefit analyses, particularly when we engage in the regulatory impact assessment process, as we do on a whole range of issues pertaining to our work. I do not seem to have that figure before me, Ms Johnston. We have 28 contracts for procurements that have been entered into and reported on AusTender, totalling $1.992 million.
And is there a reason you haven't sought to build up that economic cost-benefit analysis modelling expertise in-house, as it is a skill we would expect the public service to have?
Yes, Senator. The economic analysis work that we do is quite varied in terms of dealing with a number of topics in relation to work health and safety. My decision, my judgment in relation to the matter is I don't consider it a good investment to have people permanently employed to undertake that work when it can be irregular in nature and it can be quite varied. So often it's a team of people at a consultancy who undertake that analysis for us because of the requirement or the demands for, you know, multifaceted analysis and things like that.
Thank you. I think we're happy to move on. Labor's happy to move on to Comcare now.
Okay, thank you very much, Senator Pratt. If there are no further questions, I will let officials from Safe Work Australia go. And thank you very much for your evidence, and we will move to Comcare. So if we're going to ask officials from Comcare to come to the table. They don't appear to be in the room, so we'll have a short suspension while we arrange that. Resume the hearing, and I welcome to the table representatives from Comcare. Ms Weston, do you have an opening statement? Thank you.
May I, before we go to questions, pop something on the record, please, Chair?
Yes,
can I take the opportunity, please, to inform the committee that this will be Ms Weston's last appearance at Senate Estimates. To my sadness, Ms Weston is retiring on the 30th of April. She has, of course, made a strong contribution as the CEO of Comcare, and the government recognises her efforts in preventing harm and assisting ill and injured workers. Of course, her appointment as Comcare CEO built on a long-serving career in the public service, and prior to her appointment, she was a Deputy Secretary of the Department of Industry, Innovation and Science since 2009. She received the Public Service Medal for outstanding public service in advancing the national innovation and science agenda. And of course, as Comcare CEO, she has continued to improve Comcare's role as a workplace health and safety regulator and to deliver rehabilitation and compensation for injured workers. So she's done a huge body of work during her time in this leadership role, and while I could go for a long time about her many accomplishments in doing so, can I simply extend my thanks to Ms Weston for her work and her commitment to public service in Australia more generally, and wish you the very best for the future. I hope retirement treats you well.
Thanks so much, Minister.
Thank you, Minister, and on behalf of the committee, can I too extend my congratulations to Ms Weston on a very successful and productive career, and wish you all the best in retirement. I do know you've had a lengthy contribution to public service this nation. I, having worked with you before on issues of regulation and red tape, saw that firsthand, and from all reports you've done an excellent job as CEO of Comcare. So very much all the best in retirement from the committee. I'm sure you won't miss us, but we'll miss you. So thank you very much, Ms Weston. Senator Pratt.
Thank you, and congratulations on your retirement, and thank you for your public service over a long time. The CCARE scheme, Comcare's got some oversight of that I'm correct?
Senator Sue Weston, Chief Executive Officer of Comcare. Yes, Comcare is required to provide secretariat and advisory services to the CCARE Authority.
Okay, advisory services. So have you been involved in any discussion about the viability of CCARE into the future?
So that is a topic of conversation. In my role, I have been the Deputy Chair of the CCARE Authority, and it's a topic of conversation that has been going for some time.
How would you characterise the viability of the CCARE scheme currently?
So the CCARE hasn't been called, obviously, to the committee, but I might note that there is a very difficult situation with the insurance. The scheme hasn't been able to gain insurance from the 31st of March this year, and indeed the employers in the scheme, some of them have, in fact a large number, have not been able to get insurance either. It's an issue around the insurance market. And so yes, I understand now, and Mr Hare might be able to go into that. The Minister has instigated a review, and that will help resolve or at least highlight the, I don't have the terms of reference with me, sorry, Senator, but there's a terms of reference for that.
Is there, if insurance can't be bought as of March, when do the current insurance policies all expire?
It has expired, Senator.
So who is uninsured and what are the circumstances
So
that workers are in currently, if and when there's a need for workers' compensation for seafarers, which relies on the Seacare scheme?
So, Senator, it's a default scheme. It's for situations where an employer can't be found for a variety of reasons. So it's not like there's a set of employees covered. There is a coverage able to be obtained through state schemes, and some companies, employers have asked to be exempt from the Seacare scheme and move to the state scheme. So that has happened. There's one thing you said at the beginning, Senator, that I missed out on responding to you on. So the other thing is that there is, the fund does have reserves, and of course we have an actuarial assessment of the liability, and so, you know, it's not like that there isn't funding to support the scheme at this point.
Okay, how long have we got, do we think?
So I might ask my colleague. I have my colleagues here who've all come to Canberra today, just to let you know, committee, that some of them have been on the screen before, but they've come today, so it's very good.
No, that's fine, thank you.
Mr Duke gets a chance to answer in person.
Thanks. Michael Duke, General Manager of Scheme Management. Just to clarify on the insurance issue, the fund is required to take out reinsurance policy for over $1 million. The fund currently sits at over $1 million at the moment. So in terms of the fund itself, it has sufficient resources to meet, should a claim arise, it has sufficient resources. I'd probably need to take on notice how long, you know, it kind of depends on whether a claim, so there's numerous steps that need to be met for a claim to be made against the fund, and what I'd need to sort of highlight is that, you know, depending on what that type of claim is, it could be a low cost claim, but if it's a more expensive claim, the point is probably that the payments on claims are iterative, so they're not lump sum, they're as you go kind of payments. So certainly I would suggest a number of years in terms of the fund.
We don't have many claims at the moment. There was one significant one a little while ago, and maybe another smaller one, but it's not something like a compensation scheme where you get a lot of claims coming in all the time. It's a default fund, as I said.
But if we don't have many, why are commercial insurers indicating they're not going to offer insurance?
Senator, I might just give you some further background. So Ms Weston referred to the fact there's a review underway. So the department's engaged Finity Consulting to conduct the review, and it will look at a broad range of matters. And we expect that report to be provided in the second half of this year. It is a complex matter, particularly given that there are multiple jurisdictions. There is insurance available through the states and territories, and it's always difficult to fully understand the commercial basis for why a reinsurer offers reinsurance or not. That's really up to their own modelling.
Well, okay. Will ComCover step in? Has the government considered whether ComCover will step in as our own self-managed insurance fund?
I might take that one. So my understanding is if there is a payment that goes beyond what's available within the fund, the Commonwealth will need to consider where that payment came from. It's not necessarily going to come from ComCare, but it would come. Sorry, ComCover. It would need to come from the Australian government if there is a successful claim in excess of that.
Okay. But how do we know which jurisdiction a particular seafarer is in if they're covered under a state scheme? And what does it mean if different injured seafarers are treated and compensated differently depending on where they live, or as opposed to even what ship they're on?
So I understand that's managed already through the state schemes, Senator. So it's not something that is novel for the.
I know, but is it levelled out? The state schemes, do they rely on SeaCare to level that out?
So, Senator, the scheme itself is quite small. There's a small number of employers in the scheme. I think in 2020, 2021 reporting years, about 25 employers operating in the scheme. Some employers operate more than one vessel, obviously.
Okay.
Those are the employers who are required to take out seafarers' insurance under the Act. So they have their arrangements in place. They'll have insurance arrangements. They report those insurance arrangements to the SeaCare Authority. The authority itself is probably, as I say, they're deemed an employer under the scheme for that fund, for the purposes of that fund, for where an employee whose previous employer can no longer be found and they can make a claim against that fund. But in terms of the employers who operate in the scheme, they're required to have the insurance that gives that certainty and that coverage.
Okay, so, and are they required under the state scheme or SeaCare to have that?
Yeah, under SeaCare they're required, but they may have other obligations for other ships that they operate under state schemes as well.
Okay, so does or doesn't SeaCare have a role in levelling out? You're telling me it's already possible that injured seafarers may be treated and compensated differently depending on where they live?
It's probably more to do with depending on who they're employed by and the vessels that they operate on.
So SeaCare has no role in levelling that out?
I'm not sure what you mean by levelling out, Senator.
Well, I was concerned that SeaCare's problems would mean that different injured seafarers may be treated and compensated differently depending on what ship they're on and what state they're in, but you're telling me that's already the case?
It has the potential already because employers can operate. It's about the vessels that they're operating on, and so those vessels kind of hinge as to whether it's under the Seafarers Act or whether it might come under a state jurisdiction or not. If they're under the Seafarers Act, though, the requirement is that they have that seafarers insurance to cover those employees on those vessels.
Okay. And will the benchmarking of that insurance that's consistent across states be affected by the problems in the SeaCare scheme, even though SeaCare wasn't ultimately designed to cover them?
I might just tackle some of that, if that's all right. So I'm not sure that we've heard evidence that the insurance arrangements within the jurisdictions are consistent. My knowledge of the broader workers' compensation schemes is that they're rarely consistent. They vary from jurisdiction to jurisdiction. I'm not sure of the detail here, but I haven't heard.
Yeah, I know. Look, I can understand why that's the case, but here we're talking about people who work on boats who might be travelling between ports, between states, etc., and that does really raise the prospect of whether someone's going to jurisdiction shop or all of those kinds of issues.
So that wouldn't be dissimilar to road transport or a number of other things where you actually see people crossing jurisdictions.
Indeed.
I think the advice is that it depends on where the company's registered and operate from. It depends on the insurance. It is entirely possible right now that you've got seafarers subject to different insurance arrangements because of the jurisdiction that their company operates from, and I'm not sure that the role of
is or
SeaCare
is not
was...
SeaCare relevant to that problem and the way it's sorted out?
I wouldn't have thought it was relevant to that problem. It was originally designed, as I understand it, to try and address a gap. More, the individual jurisdictions are actually picking up more of the coverage over time, which is actually dealing with the fact, well, reducing the gap, if you like. So I'm not sure it was intended to provide a common base across the board for everybody. It was there to deal with the gap.
Okay, but it's my understanding that the C-Care scheme is designed to provide coverage to people who are engaged in interstate or international trade or commerce and fall outside the state and territory specific schemes, right? Is that correct?
So that's right. It was there to deal with the gap, but as I said, the states and territories have been changing their schemes to broaden the coverage, is my understanding.
Okay.
I will check that, but that's my understanding.
What can the Commonwealth legislate or regulate to ensure that the gap's filled? You're talking here about seafarers where you can't find their employer. So who's going to fill that gap?
So just to be clear, that the fund is what covers those employers. Employers in the scheme, and there's a range. As I said, there's a small number of employers who operate in the scheme. Those employers meet those requirements of coverage through their insurance arrangements. That's how the Act is set up. So while that is in play, those employers are covering those employees through their insurance arrangements.
Okay, so has the insurance for the workers that no longer have access to C-Care, has that 100% all been diverted to other insurers? How much of it still rests with the contingency fund?
So just to clarify, so that there are employers who have moved out of the C-Care scheme into those state jurisdictions, and they would have their insurance within those state jurisdictions. In terms of, again, the fund is a default fund. Certain events have to occur for that, for a claim to be able to be made against that fund. Includes things like, does the employer no longer exist? Has it been wound up? A whole range of, a couple of tests which I can provide on notice in relation to what those are. It's at that point that a claim can be made against the fund, and then it would go through the process of whether it would be accepted or not under the Act.
Okay. Are you aware of any contingency plans that are in place to cover injured workers who fall outside the other state schemes if the remaining funds are exhausted and there is not an alternative insurance policy in place?
So I think that goes to my one of my earlier answers. If someone is found to be eligible and they are awarded through the court process a claim, then the responsibility, and they're not covered by another jurisdiction and they are covered by the C-Care framing, then the Commonwealth would be responsible.
The Commonwealth is responsible. Are you aware as to whether that liability would ensure that workers have the same level of coverage that they're entitled to under the Seafarers Rehabilitation Compensation Act? Does it have to go to court, or because the liability rests with the Commonwealth? Or
It's not always contested. It is able to be agreed. So if it's agreed that the coverage is there and that they're eligible, then the determination would be whatever the payment requirement was, then that would be made. So
the Commonwealth would make the payment to match what is required under the Seafarers Act.
Okay. And who would make that decision?
Well, if we get into the point of the fund being exhausted, we would be talking to our portfolio agency to work with the government to make funds available.
Okay, and is it Comcare that makes that decision in your advisory and guidance role?
So the decision is prima facie what it is. If the person is eligible for compensation, they'll be eligible for
Well,
it.
who do they go to ask for compensation? Who do they go to
So
ask
they would
for
make a
compensation?
claim. So they
To
would make
Comcare or
no.
to Seacare?
So it would be against the fund, the Seafarers Fund, which is administered by the Seacare Authority. So
Okay.
ultimately, it would be the Seacare Authority that would have that.
All right, and I understand, yes, the Seacare Authority, but if Seacare can no longer get insurance to do its work in general, what's the ongoing status of that authority?
So every time a ship berths that's in our group, they pay an amount of money, so it's a berth fee. That's what is used to top up the fund, and hopefully we don't have any claims, and you'll get to a point where the actuaries are happy with the bundle of money in there, and then that's obviously reviewed very regularly. If some big claim came that we don't expect at the moment, but let's say it did, and
Yeah.
we were going to exhaust the fund, then we'd need to go to the department to work out where from the government that money will come. But it will be to meet the entitlements that the person's entitled to.
Okay, so in the past, has there been a drawdown on the funds of private insurers, or has it all come from the fund itself?
I'd have to take that on notice, Senator. The way it's set up is, as I said, the Act seeks that the fund has a reinsurance policy for amounts claimed over $1 million. So that's in essence a retention fee. So the fund would pay up to the million, and then the reinsurance policy would kick in and pay for any amounts that were over that $1 million in essence. So it would draw down on the fund up to a point, and then it would go to the reinsurance.
Okay,
piece.
and if Comcare were to take that over, again, you've got to work out if it's insurable and whether you're going to charge for that insurance.
So Comcare wouldn't be taking on the insurance.
No, I'm putting it hypothetically. Have you considered, has the government asked you to consider to do that if there's a drawdown on the fund beyond the contingency that's there?
No, Senator, the government hasn't asked that. The government's initiated a review to have a look at a range of issues. We anticipate that review to be available in the second half of 2022. And we'll have a look at it. So the discussions that have been had with Comcare are, as Ms Weston's evidence was, that if there was a claim that exceeded the fund and the reinsurance was unavailable, then they would come to the department and we would approach the government in terms of where the funding came from.
Okay, does the government consider that's a long-term solution? What's being canvassed in the review as possible solutions?
So the review, I'll need to take on notice the terms of reference. I don't have them in front of me that I can see at this point in time, but if I find them, I'll provide them. So the review will look at the arrangements, look at the sustainability of the scheme, make sure that the arrangements are contemporary and fit for purpose, and a key focus is to ensure there are effective and sustainable workers' compensation entitlements and work health and safety protections in place for employees and employers covered by the scheme. The stakeholders, including unions and employer representatives, will have an opportunity to engage with the review.
And will that consider specifically using the Comcare Workers' Compensation Scheme to deliver the Seacare scheme?
It's my recollection is it's not part of the specific terms of reference. What we've asked for them is to look at a sustainable scheme.
It doesn't preclude that? Is there any reason?
I'll need to take notice. I don't recall it precluding it. It's what it looks for is for a sustainable scheme.
Okay. That would be sustainable, I assume.
Well, I mean, that's an open question to actually have someone else's payments which are unrelated to an entity being able to claim. I'm not sure that would be regarded as sustainable.
Okay. No, that makes sense. Some questions around psychological injury. How many workers and employees does Comcare currently cover? What's the breakdown between public and private employers? And how do your death and injury rates compare to other schemes?
Okay, so Senator, you're moving between workplace health and safety and compensation arrangements. So some of those questions relate to compensation and some of them relate to our safety role, workplace health and safety role. So maybe we could just start with perhaps that first lot. I think we have the numbers here of under both schemes. So let's just start with the Safety, Rehabilitation and Compensation Act, which is a compensation part. And you're saying public and private. Well, that's all public, but I'm going to ask my colleague to cover that for you.
So if I start with the Safety Rehabilitation Compensation Act, this is at 28 February 2022. There were 441,689 full-time equivalent employees. Of that was 193,312 from Australian government and 248,377 from what we would call the self-insured licensee sector.
Thanks, that's helpful.
I'll go to the WHS, the Work Health and Safety side now, if you like.
Yeah.
So that's 421,868 full-time employees equivalents. Of those, 194,943 employees from Australian government, approximately 62,000 from the Australian Defence Forces, and 164,925 from roughly 30 self-insured licensees who have WHS coverage as well.
Okay, thank you very much. In terms of your Work Health and Safety Year in Review for last year, you've focused on psychosocial work health and safety risks beyond the pandemic, and you've got a new inspectorate team, including bullying, harassment and sexual harassment. What is that inspectorate team and what will it do, and does it have specific funding?
So Senator, I'll get my colleague up to perhaps if we need some more detail, but we have been pivoting to a big focus on psychosocial injury, both across workers' comp and work health and safety. And one of the things that we have decided to do is to establish a psychosocial inspectorate, which we are funding through our normal funding processes, but that means that we'll share that cost across our jurisdiction. And that inspectorate, we do obviously psychological matters at the moment. We have a number that are in various stages of investigation or inspection. But this will focus quite heavily on, in particular, education. We have, as an organisation, the Boland Review. We can see the recommendations around the new Code of Conduct, and the new regs and changes to things like the notification provisions. So we ourselves are gearing up for that in terms of general education and training. We are obviously still doing that. We look forward to the notification provisions changing so we can get better oversight of the psychological injuries that are out there. We've done the big forum, you might recall, covering sexual harassment, webinars, and we have worked with the Australian Human Rights Commission to develop sexual harassment guidance with them, and that is the basis of the training that we are conducting. We have very good engagement with departments and agencies in our jurisdiction at the moment in that training. We're also have in consultation at the moment a prevention strategy because you've got to get to that front end, Senator, where you're actually stopping some of this happening in the first place.
In terms of your work and the accountabilities in it, does it extend beyond what's currently required by Safe Work Australia's regulatory guidance? Or, because I know they're evolving their in conjunction with ministers currently, where does the benchmarks that you're working to in terms of preventing this harm sit from a regulatory point of view?
So, obviously, as we heard in the previous evidence, Senator from Safe Work Australia, they are working in their jurisdiction, and the department is our representative on Safe Work Australia, but we obviously are working with the department to look at these products. Code of conduct is something that can be referenced in a court, and so of course that will be a standard that I expect that departments and agencies in our jurisdiction and companies will want to meet. And so as those things evolve, we'll absorb those and put them into our education and training, our inspection, and then into the top end of the regulatory activity, you know, the prosecution type space.
Yeah. Okay, so, but I still don't have a sense about whether you're going to be required to do new things or whether what you're doing currently supports the baseline law. I'm happy if you go above and beyond, because you're there to look after people. You're not just here to serve a baseline of prevention. But how do you make a decision about where you sit in a regulatory sense about the conduct within a workplace that you're overseeing?
So we'd be still following the law in the Work Health and Safety Act, which requires employers to keep their workplaces physically and psychologically safe. So what that means is they're expected to identify hazards, of which sexual harassment or bullying and harassment are items. They are expected then to assess the risks of that.
Yeah.
They're expected to put controls in place and discuss them with their staff. They're expected then to implement those controls, and then they're expected to review. So we will be looking at that, as we normally do, but it will be helpful now to have this additional guidance and instruction. That means that there's going to be a greater expectation on the employers to do that. So we will be looking for them to have done that. So we are gearing up ourselves in this space.
Thank you. I'll put most of them on notice because we're due to go to lunch, but can I ask, the report, Work Health Safety Year in Review, that report noted that the rate of accepted claims has been decreasing since 2017 from 11.6 per 1,000 FTEs to 10.3. That's not insubstantial. Why are less claims being accepted?
So I'll ask a colleague, but Senator, we also have a lot of less claims. The claims are reducing as well overall, so that percentage may reflect, at least in part, a reduction in claims, because you're in the workers' compensation space now.
Yeah.
Which is often reflective of good education and prevention.
Good prevention.
I think too there's been a really good focus on safety systems with the pandemic as well, so there could be a lot of reasons. Did you... Just the year in review, is that the answer? Yeah.
Mr. Hughes, just...
It's largely driven by a reduction in claims.
Okay. I'm satisfied with that answer. And I just want to wish you again very well for your retirement. It's been a pleasure interacting with you over many estimates or other committee, from immigration to all sorts of things over the years. So thank you so much, Senator.
Chair, if I just might add, so the terms of reference for the review are publicly available on the department's website. So you should be able to find it there. And I was correct, it doesn't preclude looking at Comcare.
Thank you. That's terrific. Thank you, Chair.
Thank you very much, Senator Pratt, and I too again echo the well wishes, Ms. Weston, all the best, and we'll now release those officials from Comcare, and we're right on time for our lunch break, so we'll break now for lunch and return at 2 p.m. Suspend the committee. We're all ready. I will reconvene after lunch and welcome to the table officials from the Fair Work Commission. Mr. Furlong or others, would you have an opening statement?
No, thank you, Chair.
Okay, all good. We'll go straight to questions. I'm going to start with Senator Rennick.
Hi, guys. I've got a feeling this might be for the Ombudsman, but I'm going to ask you just so that if I get it wrong, I know I've covered all bases. I've got a couple of questions regarding work cover and workers' compensation. Can I ask you, or is it better to ask the Ombudsman?
If it's work cover and workers' compensation, you've probably missed the boat. That would normally be Comcare or Safe Work Australia.
Right, okay. What if it comes to a dispute? What if it gets boiled down to a dispute?
If it's a dispute, it might be why don't you give us the example? We can work our way through.
So effectively, if the government made the employer, made the employee get the vaccine, can the employee claim work cover if they are injured by the vaccine? Because I'm getting a lot of feedback from constituents about they can't get work cover even though they got it for work.
So I think that might be better dealt with by the Fair Work Ombudsman.
Yeah, sure. I did wonder about that.
Yeah.
Now, look, so the only other one I've got, there was a recent Fair Work Commission hearing between Isabella Stevens and the Epworth Foundation. And in paragraph 25 of the judgment, the Deputy President Coleman stated that relevant tests and trials took place prior to the TGA approval of the COVID-19 vaccines. Now, that is factually incorrect. The TGA hasn't approved the vaccines, they've provisionally approved the vaccines. And the President went on to say that he uses the word plural, relevant tests and trials. Now, Pfizer only undertook one trial for COVID-19, and it had a number of results that basically showed in terms of safety that the number of all-cause mortality was higher in the vaccination group, the number of adverse events was higher in the vaccination group for all causes, right? So, given that there are serious safety issues around the vaccine, why is the judge just dismissing those risks in making an assessment in a judgment? And my question is, what training do the commissioners get in terms of understanding the biochemistry and the testing processes around vaccines? Which I would, you've got to know your stuff if you're going to start making rulings on this, and I don't expect every commissioner to understand science, but surely when they're hearing cases that require this much science, they would get proper training so that they can understand all the facts.
Good afternoon, Senator. Murray Furlong, General Manager of the Fair Work Commission. I'll start by saying that the decision of Deputy President Coleman it essentially stands for itself. The members of the tribunal are independent statutory appointees who have powers to make decisions, in essence, very similar to judges. Right. There are appeal mechanisms in place. So if there's an agreed party to that decision, then they can seek to have the matter dealt with on appeal and ultimately through to the federal court if they see fit. Members of the tribunal in dealing with cases can inform themselves as they see fit. And while I haven't read the decision that you're referring to, I imagine that the Deputy President outlined all of the decisions, or all the reasons for his decision.
So who oversees these commissioners? I mean, ultimately someone's got to judge the judges, right? I mean, we can't just have, these commissioners saying things that we know to be factually incorrect.
They're independent statutory appointees, as I said, very similar to judges, or akin to judges. In terms of, so they make decisions in accordance with the Fair Work Act, within the framework of the Fair Work Act. Just to repeat that, the process is that if a party is unhappy with that decision in first instance, then they can have that matter. They can seek to have the matter appealed.
Okay, because I'm a little bit confused because the High Court's just heard a couple of hearings over the last few years in regards to the sanctity of the employment contract. Peter Ridd being one case, whereby he lost his case because in the contract it said he couldn't speak out. And there was another hearing, I can't think of it, but it was effectively around the contract labour laws and changing the terms of condition. Now, I would have thought if you started a job and there was nothing in the contract about getting a vaccine, how is it that employers can now change the terms of a contract without, and this is a public health issue, this is not work and safety, how is it that they're getting away with that? The Minister, Assistant Minister, I'd be very pleased to hear your feedback on that as well.
Sure. Did you want to go first and I'll follow up?
There's over recent months, there's been significant jurisprudence been established in relation to vaccinations in the workplace. We recently published some materials on our website that goes to specific issues around vaccination in workplaces, matters that have been determined by independent members of the Commission. So in relation to that part of the question, there is quite a lot of case law now that has been established around whether or not employers can provide a lawful direction to employees to be vaccinated.
So do you want to elaborate more? Because you still haven't actually answered the question how you can change the terms and conditions of a contract. And, you know, as we said, it's got to be fair and effective, right? So this vaccine, just to qualify that, this vaccine has had more reported adverse events than all other drugs reported to the TGA since 1971. So this is a normal flu vaccine in 2019, 12 million doses, had 139 reported adverse events. We're up to 118,000 and counting adverse events for the COVID vaccine. So this is a factor of by almost 1,000 in danger, right? So there's not all vaccines are created equally, right? We've got airbags, you know, the Takeda one's currently been recalled. You know, doesn't make you an anti-airbagger if you recall the airbag. But if you've got evidence that is, you know, a big safety signal showing that there are significant risks with taking a vaccine, how is it? I mean, so you just can't go, well, we've made a ruling on vaccines, because every vaccine has to be judged individually. We can't just go, all vaccines are the same. So can you tell me how it is, what you've set out that says that we can ignore these risks?
Well, I may not sort of completely agree with the way that you've framed the question. In terms of my role, and I'm sorry if it appears to be ever so slightly unhelpful, but my role as the General Manager is the agency head of the administrative arm of the Fair Work Commission. Members of the Commission are independent statutory appointees. They deal with cases that come before them, and they deal with them on the basis of the merits of those cases.
Okay, fine. I'll tell you what, let's go to the Assistant Minister then, because we need to change the law, I would argue. What I want to know is how, Assistant Minister, how is an employer supposed to be responsible for the transmission of an airborne virus?
So, can I step it back a little bit, because there's a few questions that you've asked to Mr Furlong that I think I might be able to help a little bit with. The first thing to say is that it's the federal government's position that vaccination is highly recommended, but it should be voluntary. Now, I don't cavil with the things that you've put on the record. What we think as a government is that individuals should be able to make their own decision about whether or not vaccination is right for them. That's why measures like, you know, broad brush mandates, like we've had, for instance, in our home state of Queensland, are completely inappropriate. They don't take into account the individual health circumstances or the religious or conscientious concerns, or matters like pregnancy or fertility treatment that all have a degree of uncertainty around them. So that's the position from which we start. Safe Work Australia was probably the body that we probably needed to raise this with, but in short, Safe Work Australia gave guidance about how this should be dealt with in the employment context. To require a vaccine isn't something that would be provided for in just about any employment contract, and I'm sure that fits with your experience of things. That said, it is consistent with the body of jurisprudence that exists in this country that says an employer can give a lawful direction to an employee, and that whether or not something is lawful will depend on whether it's reasonable in all of the circumstances. So it might be reasonable to ask that of somebody who, for instance, works in aged care. It might not be reasonable if you're a desk worker. And the guidance that was given by Safe Work Australia provided that It was only in the very narrow set of circumstances where you were dealing with a high-risk situation where a mandate might be appropriate. Otherwise, they're out of line. Now, that said, there have been a number of employers who have taken a path that does not accord with the advice that was given by Safe Work Australia. And it is, I think, appropriate that a number of those things are being heard before the courts. You asked whether judges get trained or commissioners get trained in how to deal with science. The short answer is they don't. It's up to the parties to a particular case to educate the decision maker to the extent that they're able to make the right call. And if the parties think that the wrong call has been made, that's what the appeal process is for.
Does that cost
I
money?
acknowledge that's it does cost money? Yes, of course it costs money.
And that's the problem. If you're unemployed, it's hard to find that
Oh,
money.
look, I can see those limitations are real. We do provide assistance as a Commonwealth for legal help to be provided to people in different circumstances, and usually someone who's unemployed would qualify for that kind of assistance through, for instance, a community legal centre. But I don't pretend that it's easy. I don't for a moment suggest that, you know, wide-ranging or broad-brush mandates are right. But it is certainly the case that the Commonwealth Government's guidance on this front has been pretty clear, and that's that people should be doing this voluntarily, even though it's recommended. It's a matter for the individual, with employers being given guidance that it's only going to be reasonable in a very narrow set of circumstances.
So can't the federal government introduce legislation, or just forget there's an election in front of us, if we get back in, or whoever that may be, introduce legislation to state that, for example, with Woolworths or Coles, you've got people who can go into Woolworths and Coles unvaccinated, but yet the workers have to be vaccinated. I mean, some of these requirements aren't consistent or lack common sense, number one. And number two, for younger people, and the only risk I got out of Professor Skerritt this morning that people had in regards to COVID was a multi-inflammatory disease of 1 in 3,000 people. We've had 360,000 teenagers, for example, infected with COVID, so which means you might have 120 people with multi-inflammatory disease, whereas we've had the TGA report last December that there's about 347 serious adverse events. Now, that is a clear set of numbers there that indicate the risk from the vaccine for teenagers is higher than the risk of COVID. I mean, the CGA denied that, but I've got the numbers to prove them wrong. It's their own numbers. Now, in that case, how can it possibly be fair and reasonable for young people to be forced to take a vaccine by the employer when the consequences of taking that vaccine go beyond the workplace? So it's not like a mine site where you put your hat on when you're on the mine site and you leave the mine site and it's all done and dusted. You are carrying the risks of that vaccine for the rest of your life.
Look, I don't disagree with you. I think it is a pretty bold thing for an employer to suggest that that's appropriate. And I would say that it is not something that is supported by the advice that was given by the Commonwealth through Safe Work Australia. That is exactly why people who are concerned about this in the Australian community should mark down state governments that have imposed broad brush, illiberal and unfair mandates that have excluded people from work when they are trying simply to make decisions that best take account of the evidence for their personal health decisions, because everyone's circumstances are different.
And I totally agree with that. In terms of state employees, that's where the mandates kick in. But in terms of the private sector, they come under the Fair Work Act. So I believe there is now a role for the government to step in and outlaw these mandates where they are not necessary, because they are imposing, an overburden. The employer is basically controlling the health and well-being of an employee, in a way that I think is not related to the workplace.
Look, I understand what you're saying. I disagree that it's a mechanism that's readily available to the Commonwealth, particularly without legislation.
Well, that's what I'm saying. We need to bring in legislation.
And even legislation, I would suggest, would have dubious constitutionality in circumstances where we're trying to work with a clear state power to deal with public health matters. So that's not to endorse it. it is to acknowledge that this is something that's clearly within the state remit, and
So you're saying it's within the state remit? Sorry.
I was going to have to rotate the call soon.
Yeah, can I just clarify? So you're saying that even for private sector employees, they are doing this because of the state governments?
yes,
And we have no powers federally through the Fair Work Act to override that?
I'd suggest that the people who say it can be done are doing a bit of bush lawyering, and that there's a very clear line of authority that suggests this is something properly dealt with by the states. And that will explain, for instance, why the approach that's been taken by a nationwide company will be a little bit different in Queensland to how it is in New South Wales or how it might be in Victoria.
Couldn't we bring in something through the Corporations Act?
Well, anything you do needs to reconcile powers in relation to a public health response with powers in relation to corporations. That's actually a pretty complex question of constitutional law.
Yeah.
And I would suggest, without sort of going chapter and verse on it now, that is a far from settled position at law.
Sure. Okay, thanks.
Thank you, Senator Rennick. Senator Pratt.
Thank you. Mr Furlong, your budget statement, in particular the resource statement, table 1.1, it looks to me as if the total resourcing for the Commission is being cut. Is that the case, and if so, by how much?
I might ask Mr Lambach to assist the committee with that question, Senator.
Jack Lambach, CFO, Fair Work Commission. The resourcing has actually increased, including the funding we got for the small business unit. But if you take away that funding of that small additional funding of $2.165 million next year, we have a slight reduction in funding.
Okay, how big is the small business unit funding?
In the first year, it's $2.165 million, followed by approximately $1.1 million thereafter for the next 3 years.
So that's 5.6 over 4 years, is that correct?
Yes, Senator.
And what do? I add that if you want to, if the government says total resourcing is about the same, I add that to the 123 million that's there.
On a like-for-like basis, our budget has reduced by $1.456 million compared to the 2021-22 financial year. Our operating revenue.
Yeah, that's how much it's decreasing by. Why is it decreasing?
There's a number of reasons, but the biggest reason is the conclusion of the two-year budget measure to assist us in our response to the COVID-19 pandemic. We received funding in the prior year for 2 years to assist us in meeting the demands of the pandemic. That funding is ending on 30 June.
So how is a cut of assistance?
It was a 2-year measure. We were funded for 2 years for the COVID response package. We received, in 2021-22, we received $1.885 million to assist us with our response to the COVID-19 pandemic in meeting extra caseload and so forth.
Okay. And so that terminates, it was in 21, 22 and 2021, and it was 1.8 million.
It was $5.097 million over 2 years. So it was $3.212 million in 2021 to end the year end 21, and then $1.885 million ending 30 June 2022.
Okay, so what's the impact of the changing budget on the agency's workload, please, Mr Furlong?
In terms of the agency's workload, what I can say is that to this point, or to the end of February, this reporting cycle, so this financial year, we're sitting approximately 5% below our 5-year average. So in essence, in some matter types, so obviously it's sort of they fluctuate in this bargaining cycles, a number of other things that impact on the volume or the quantity of work. But that's essentially what our workload currently looks like. We did receive a significant number of vaccination-related cases in December and through November, December, and into January. But if you were to average it out over the financial year to date, we are sitting that 5% lower. In terms of the resourcing of the Commission, we continue to look for efficiencies. We've consolidated our property holdings. We're looking to use more digital sort of solutions to improve the efficiency of the organisation. But we continue to have a very, very close focus on our budget position for the forward years because it does decline.
You can only consolidate property once and you can't recreate efficiencies. So can you tell us what it means for the workload in terms of the timeliness and the capacity, the need to prioritise, delays, etc.?
Well, as you're aware, and as Mr Lambach just indicated, the funding measure, we're very pleased to receive the additional funding to assist us with the additional workload associated with COVID, but also to assist us with our ICT infrastructure and a number of other areas to improve our sort of service delivery during the pandemic. But as that funding measure concludes and the small business funding measure commences, the like-for-like budget is reasonably similar. So in terms of when the impact on workload, and this is talking the abstract in the out years, it's very difficult to contemplate what that may look like. We continue to have conversations with the Attorney General's Department about our resourcing, and they are regular conversations that we have.
And what can you characterise in terms of the issues you've raised with the Attorney General's Department about how you go about doing that?
Well, in summary, the conversations that I've had are that while the funding position for the Commission is adequate, up to the end of this financial year, we are looking to, we observe there will be challenges in the forward years. I haven't spoken to the department since the small business funding measure in any great detail came down. But in essence, as I just want to repeat that we look very closely at our resources, and we knew that that these issues in terms of challenges in relation to our funding position in our years is coming, and we are working towards trying to achieving balanced budgets in 22, 23 and beyond.
The $5.6 million for 4 years for that dedicated unit, what will it do?
With the
small business?
The first priority, and obviously the funding measure was only announced a couple of weeks ago, and it hasn't commenced until 1 July. But we've already started work on the first deliverable, which would be we've recently released an e-learning platform, and we will be going to market in the next 4 to 6 weeks to procure the consultants to develop an e-learning module to assist parties, including small business, but all parties, to prepare for unfair dismissal and general protection conciliations. We believe that there are significant opportunities to assist parties to prepare before they come into that initial sort of phase of that case management.
Will the module help them? Will it also triage the lodging of documents, or is that a separate thing?
That's a separate thing, yeah.
Would you look at combining them?
Well, it's another element of our digital transformation. We're looking at that as well. We're looking, and we're reasonably well advanced in this. We rolled out a new case management system late last year. One of our next priorities is to develop smart forms, and these smart forms will have logic in them that will assist in ensuring that any applications that are made to the Commission are within jurisdiction and are complete and compliant at the point of lodgement.
Okay, so that $5.6 million, is it just for those modules? What's it actually for? Does it pull out and triage small business cases separately to everything else, or what's the overlap?
As you'd appreciate, the measure was only announced a couple of weeks ago. We'll be consulting with our small business reference group over the next 3 months to determine the services that best meets their needs to ensure that what the services that we develop are absolutely fit for purpose. There will be a number of other elements to it. One that sort of comes to mind is that we have we're very proud of our workplace advice service. Provide over 3,000 free sessions, legal advice, sessions of 1 hour for employers and employees. We know that there is greater opportunity to make those sessions available to small business, so we'll be focusing some of our attention to ensuring that small businesses, medium-sized businesses can take up that opportunity.
So in terms of that 5.6 million, do you imagine that it'll mean other parts of your resourcing will get cordoned off to go into small business? I'm not quite understanding the framework for that 5.6 million. Clearly, you would spend more than 5.6 million overseeing issues that arise within small business.
Yes, I suppose one of the benefits of working in an organisation of our size is that you can rely on the efficiencies of drawing in specialists or expertise from different areas of the organisation to assist with the development and the delivery of these services. We will, with all of our change and our reforms of the Commission, at the centre of it is based on independent user experience research that we commission to determine what the needs are of different users of our services, and that will be used to inform this. So it's hard to talk in the abstract, Senator, about exactly what the services will be outside of the fact that they will involve smart forms, there will be e-learning platforms, there will be additional assistance to our workplace advice service, and as I indicated, we have a small business reference group that's made up of government agencies but also representatives from small and medium-sized businesses, including the Small Business Family Enterprise Ombudsman, employer associations as well, and their peak organisations to assist in determining what those eventual services are.
Okay, so who will tell you what the funding is for if you're still unclear as to what that is?
I know what the funding is. I know what we're using it for. The 5.6 million, as you're aware, the measure was only announced with the budget, so
yes.
It hasn't commenced yet. I understand in the budget papers it's to provide support in developing of a small business unit. And I think the department took some questions on this on Friday.
Can you tell me, was it something the Commission itself identified as a need? Did it come from the small business sector?
Yes, it has been through our research, and I'd be very happy to table this research. It's also available on our website. But over several years, we've initiated independent research to determine the needs of different users of our services, as I indicated. One of our very detailed user experience reports or research goes to the experiences of small businesses with unfair dismissal applications, and that was used as part of the evidence base to inform the decisions around this funding measure, as I understand.
Okay, so did you ask the government to look at this? Did the small business sector propose it, or was it the minister?
I think over several years there's been conversations about how we can better support the needs of small business.
Okay.
It's not one conversation that had occurred that was initiated at a point in time. These are ongoing conversations over several years.
How will the work of the unit differ from the Fair Work Ombudsman, which also plays a role in support and assistance?
The functions of the Fair Work Commission go to providing information on our functions, essentially, and on cooperative workplaces. What our initial focus will be is on that e-learning platform, which will be to inform parties. And we're talking about approximately 20,000 applications per year here for unfair dismissals and general protections, to assist those parties to be better informed, to be ready before they come into those conciliations or those conferences.
Okay, and how's that different to what the Ombudsman does?
the Ombudsman's role is to...
Well, they might settle it, they might look to settle the dispute, but...
The Ombudsman doesn't provide information, education or advice on the functions of the Fair Work Commission in any great detail. Their role is essentially, and Ms Parker's on later this afternoon, but their role is essentially...
But I'm on their website and it says, before hiring a new employee, you should make sure you know your rights and responsibilities, and it outlines...
Yep. That's right.
The same kind of stuff. So whose job is it? Yours or the Fair Work Ombudsman to...
So I think there's a distinction here.
To do that?
So the Fair Work Ombudsman provides the general support, but this measure is intended to provide support in a range of ways. But when we're talking about the unfair dismissal or the general protection matters, that's where there's already been either a dismissal or an adverse action alleged, and this is about trying to find and recognising there's a scoping study to help define this more closely. It's when they're already in dispute rather than actually being...
Okay, but they could be in dispute before the Fair Work Commission.
The Ombudsman doesn't deal...
Or it could be someone's made a complaint to the Ombudsman. How do you triage that between the three?
So the Ombudsman doesn't have the responsibility for ruling on whether there's been a breach of the general protections or unfair dismissal. That's the responsibility of the Fair Work Commission.
Yes, indeed. But other small business issues...
Yep.
How do you know who's the right person to educate people in the right circumstance? Because, you know, they've got best practice guidelines on a whole range of workplace issues as well.
Look, certainly the Fair Work Ombudsman have quite a broad responsibility in terms of their education, and that's appropriate. The Fair Work Commission tends to have a narrower focus to its area of education, and that's about its functions. The Ombudsman looks broadly across the employment arrangement.
I know, but if I put to you, and this is something you'll have to think about, a conscientious employer will go, right, we try to stay on top of what's required of us, we'll work through the Fair Work Ombudsman best practice guides, and I'm quoting, that aim to help small business employees with a range of workplace issues. Could you do all that and not ever see that unfair dismissal resources in the Commission?
If you're a conscientious small business and you follow the rules and if you have to either terminate or reduce someone's pay level or whatever the actions might be, and no dispute is raised, then you wouldn't need to go to the Fair Work Commission. It becomes a matter when a dispute's raised that you end up heading towards the Fair Work Commission.
I know, but people are used to dealing with the Ombudsman often when it comes to various disputes.
Yeah, and the Ombudsman is engaged in parts of this process as well, so they can provide support for people as part of this exercise.
Will the work of the unit differ in what ways to what the Ombudsman does, please?
Essentially, the unit will provide guidance, assistance, support for small businesses and other users of the Commission about their interactions with the Commission. That's what separates that from the Fair Work Ombudsman. Fair Work Ombudsman has got the statutory responsibilities to provide education, advice and compliance for the whole National Workplace Relations System. Where this sits is supporting small businesses, or assisting small businesses with their dealings with the Fair Work Commission.
Okay.
So if a former employee initiates proceedings for an unfair dismissal, that is where these materials, this support, through several different services, will be of assistance to them.
So I'm somewhat concerned that on one hand your budget is being cut, you've got the additional resources for this project, but your website already has a helpful small business resource which includes a workplace advice service which helps with issues relating to issues we've already discussed, such as dismissal, bullying and general protections. How does this fit into the new unit, or is it just repackaging?
It's certainly not repackaging. There are new services that will be provided through this funding measure. As I indicated, as I indicated, the funds don't start flowing until 1 July. We're already moving to procure services of expert consultants in digital education to assist us in developing these new modules. That's a very large piece of work. We'll be then also looking at enterprise agreements as well and seeing what support we can offer small and medium-sized businesses there. But in terms of the workplace advice service, we know that there's an opportunity there to share those resources more broadly. It's one of the areas that we've identified over the last 12 months that we've spoken to our small business reference group about on multiple occasions, because it is an incredible service. This funding will be used to augment the availability of that service.
Okay. Mr Furlong, can I ask how you would characterise the workload of the Commission at the moment? Not just the quantity, but the kind of work. So I'm looking here, please, for categories and an indication of what work is increasing or decreasing. I've got an example.
Would you like me to start, Senator?
Yes,
yeah.
That would be fine.
So at 27 March this year, unfair dismissal and general protection lodgements were 10% and 11% lower, respectively, than the 5-year average for March for this time in the reporting cycle. And essentially, workload, and it's consistent with the evidence that I provided at the last round of estimates. The workload for this financial year is largely consistent with our 5-year average. In fact, lodgements overall about 5% lower, below the 5-year average. And we receive about 30,000 applications, or deal with about 30,000 cases a year. So it's within the margins, but essentially it's very similar to what we've dealt with. The composition of the workload shifts from time to time. So if there's a bargaining cycle for enterprise agreements in the construction industry, you may see a significant spike, or because of the impact of COVID, that may have had an impact on bargaining, and there could be, and we are receiving more enterprise agreement applications this financial year than in previous financial years. So the composition of that 30,000 cases sort of shifts, but essentially that number is pretty consistent year in, year out.
Okay. Can you give us a bit more detail on the change in composition? We've got a tightening labour market. There's lots of public discussion around wage, the need for wage increases to be seen in the economy. How does that influence the work that the Commission does?
We've done, over recent years, we've completed some modelling on the relationship between the strength of the labour market, or the unemployment rate essentially, and the unfair dismissal of general protection applications that we receive. And they're essentially inversely proportional, I think, is the sense that if the labour market's very strong, I know they're proportional, if the labour market's very strong, then we will generally see a decline in those application types. And as I indicated, we're currently sitting for unfair dismissal matters, and this is playing out now, lower, 10% lower for the reporting cycle, and 11% for general protections, which are our two largest case types by volume.
And as for demand for labour tightens, would you also expect to see more activity that leads to wage increases?
We haven't done any research to establish whether or not there is.
Well, you can only do what you can do within the law, and there's certain constraints there as well. Have you got any data in relation to reversion to the award, and which we've discussed in the past.
So, termination of enterprise agreements.
That's
right. Yeah, I have got some updated data for you, Senator. For the financial year to the 28th of February, we've received 223 applications to terminate enterprise agreements. Of that 223, 163, the application made after the nominal expiry date of the enterprise agreement, and 60 were made before the nominal expiry date of the agreement. To put that into context, if you would extrapolate that out to the end of the financial year, to 30 June, and there are limitations to this, but if you extrapolate it out, the volume at 30 June would be approximately 330. In previous years, so 2021, the total volume for the year was 330. For the 2019-20 year, it was 380. For 2018-19, it was 484. 2017-18, 518, and 2016-17, 400. So on that basis, it appears that it's actually declining.
Yeah, I would imagine in a tightening labour market, though, if reversion to the award means a decrease in wages and conditions, which I understand it doesn't automatically mean, but most often does, that if you're trying to keep your workforce on board, that would be a pretty unviable thing to seek to do.
Can't necessarily comment on that,
No.
as you know. But in terms of reverting back to the underlying instrument, that's on the basis that the decision that's ultimately made by a commission, a tribunal member, hasn't provided for the maintenance of those higher rates of pay or whatever those conditions were under the enterprise agreement, or in a lot of cases been replaced by another enterprise agreement.
Can I ask if there's been a change in hearings and conferences conducted by members having decreased, but conciliation of individual claims has increased? Is that the case now?
I might start and ask Ms Carruthers to meet the table to assist. Essentially, with individual rights-based matters, unfair dismissal, general protections, about 80% of those applications are resolved through staff-based conciliations. Only when those matters aren't resolved at that initial point do they flow through to chambers. There are some, if there's jurisdictional issues or a number of other areas that need to be resolved, but I might ask Ms Carruthers to provide some further detail on that.
Thank you, Ms.
Ailsa Carruthers, Executive Director, Client Service Delivery Branch. Is there a particular reason for your question? Because I'm not conscious or aware of that having happened, but I'm not sure if you've perhaps read a report somewhere.
Well,
or something
I had
that
read
suggests
it, and I just wondered if it indeed was seen in your data, which is that individual claims have increased, but hearings and conferences conducted by members had decreased. Is that statement incorrect?
I'm not aware of any data that would support that at all, Senator.
Okay, so how would you characterise over time conciliation of individual claims and separately hearings and conferences conducted by members?
So if I speak at a high level to help you out, Senator, when you look at, say, the body of applications that are lodged over a year, around 20% of matters are dismissed or withdrawn before they get to a conciliation conference. About 60% of matters are resolved at a conciliation conference, and those conferences are conducted by staff. There's a residual 20%. Now, around 15% of those don't end up with an arbitrated decision being handed down because, again, parties can continue to negotiate and so on and may reach their own settlement or the matter may be withdrawn. And there's a residual about 5% of matters where there is an arbitrated decision. Now, that's speaking broadly across a year.
And that's been fairly consistent over time?
That's right.
Okay.
I mean, there might be slight variations one year to the next, but that's a good overview.
Okay, and there's no particular trends attached to that based on the member that's conducting the work?
Senator, I've never looked at it in terms of member allocations, but I don't see why there would be, because, as I said, 80% of matters are resolved by the Commission before even being allocated, and then when a matter needs to be allocated, it goes to one or two regional coordinators, and the regional coordinators will allocate workload as appropriate within those two regions to the members.
Thank you. That's good for me to know that about the Commission's workflow. Speaking of which, could I also ask what the impact of hearings being conducted remotely has been? Is that now going to be permanent? Will it continue? And how does that impact the workload of the agency?
I think approximately 2-3 months ago, we released a discussion paper on our website, and I'll table a copy of this, about the essentially to the future of online hearings at the Commission. We successfully moved to online proceedings at the start of the pandemic, and as a result of that, we're not carrying any backlogs at the as we sort of as I sit here today, essentially. And a great, I think one of the greatest enablers of that and that performance was through the use of online proceedings, online hearings. Our members, our staff, very practiced at using online platforms now. But what's going to happen into the future is that the discussion papers come in. We've collated the findings or the feedback, and it's currently being considered internally, but quite comfortable to say that it will be an ongoing feature of our service delivery. We believe that it provides benefits in terms of access to justice, particularly for parties who don't live or reside close to one of our offices.
Yeah. And so have you taken feedback from stakeholders appearing before the Commission or providing evidence about their preference?
Absolutely, we have, yeah. It's part of this detailed discussion paper that we released and sought feedback on.
Okay, so are the details of that feedback already public in that discussion paper, or that's?
I'm not too sure if the feedback has been published yet. I'll have to take that on notice.
There's no reason that feedback wouldn't be public, is there?
No.
Okay. We've heard comments from certain quarters that the Commission is administering an increased employment system with respect to numbers, and that matters are increasing in both volume and complexity. Is that a true statement? Do you agree with that?
I just repeat what I indicated a number of times, that the workload of the Commission in terms of the quantity is slightly lower than its 5-year average. Largely consistent but slightly lower.
Consistent but lower, which is consistent with having a tighter labour market that people want to hang on to there. So what does that mean? So you would refute the idea that matters are increasing in volume and complexity. Is there any evidence to support claims that there's a backlog of COVID-19 related workplace disputes swamping the Commission that's expected to grow?
I don't agree with those statements. We're very practiced at dealing with spikes, essentially, in workload. There have been a number of them through the COVID-19 pandemic. And while we did receive a significant number between late last year and through to January, and Ms Carruthers may want to provide some additional detail here, that workload is very well progressed and has been dealt with by, largely being dealt with by staff conciliators, the vast proportion of it. Some of it is moving through to chambers and to members, but essentially with all of our unfair dismissal and general protection work, the vast majority of it is dealt with through those staff conciliators.
Okay. What's the average approval time for an EBA, an enterprise agreement at the moment? I recall, I think from 2020, 70% were being determined in 21 days. How is that now?
I will ask Ms Liggett to come to the table. But essentially, I'll start and then head over to Ms Liggett. We're currently approving complete and compliant agreement applications within a median of 12 calendar days, so around 2 weeks from lodgement. And our PBS KPI for agreements of this nature is to be approved in a meeting of 32 days without undertakings. And all agreements were approved within a meeting of 21 calendar days last financial year.
Sorry, all were? Because the last data was 70% within 21 days. You're saying it's improved since then. You've given me good data, but I'm just trying to compare it to what happened before.
I'll ask Ms Leggett to assist.
I think the data you gave was adequate. I just didn't have time to comprehend it.
So currently approving complete and compliant applications. So when the application is made, we, on the basis of the information that's been provided to us, we are approving those applications within a median of 12 calendar days, so just over 2 weeks.
Of 12, yeah.
And all agreements were approved, this is in 2020-21, within a median of 21 calendar days.
Sorry, and is that for agreements that have a dispute or not a dispute? How does... Because my question was around those that required a determination. Is there a difference?
It might be, at the end of February 2022, 99%, so some more information, hopefully this is a little bit more helpful, 99% of agreements have been approved in less than 45 working days. That's...
Okay, so your 21 days, all within 21 days is an average?
Median. That's the median.
The median, okay.
Yeah.
Sorry, it made it sound like there were none that went longer than 21 days, so there are, but what is the percentage of applications determined within 21 days?
50%. 50%.
50% within 21 days?
Of all applications. If the agreement is complete and compliant on application, so the Commission can approve the agreement because it meets all of the statutory tests, in those circumstances, those agreements are being approved within a median of 12 calendar days. That's the separation between the two
Okay,
data
I'm
sets.
trying to compare it with the data that I remember from 2020, which was that 70% of applications are determined within 21 days. What is the percentage currently of applications determined within 21 days? Was that 50%? Was that what you just gave me?
Yes, that's right.
Okay, so it's declined from 70% down to 50%.
But the distribution is very narrow around that median. It's not like there's a very long tail to it.
So it's it is taking, it's 50%, but the median is 12 days.
12 days for complete and compliant application.
Okay, and what was the previous median, do you know?
From previous reporting cycles.
Yeah, only if you've got it.
Senator, Joelle Leggett, Executive Director, Tribunal Support Branch. The previous median for 2020-2021 was 14 days, so we're currently sitting at 12 days.
So you say it's got a short tail. I'm still trying to get my head around the maths, and I know averages and medians are different, but what's happening in the tail now if it's 50% within 50% within 21 days, whereas it was 70% before?
If you'd like to know about the distribution, and I know there's a lot of sort of different stats here, and we're using for medians and percentiles as well, but from 1 July 2021 to 31 December 2021, we were able to approve for agreements that could be approved without any additional work after the application had been made. 93% had been approved in 10 working days. This is in terms of the distribution. You're asking about the tail. So this is 93% approved in 10 working days and 99% in 20 working days. As I was saying, the distribution is narrow. And for complex, which are where there are undertakings or the member is required to do additional work to ensure that the agreement can or it satisfies all the statutory tests. 86% approved in 20 working days and 99% in 45 working days.
And that's the current data.
That's from 1 July 2021 to 31 December 2021.
Okay, thank you. I've now got some questions about cooperative workplaces. It's a program described as a free program offered by the Commission that helps parties build cooperative relationships using interest-based approaches. So can I ask how it works, how long it's been operating, and does it have a fixed life or will it be ongoing?
It is an ongoing program. It gave effect to some of the amendments to the Fair Work Act in 2013. The services include information sessions for parties interested in interest-based approach, training interest-based bargaining, dispute resolution, to the training, facilitation, the assistance in collaborative workplace change, including training for consultative committees, and help with enterprise bargaining and the development of joint processes to implement enterprise agreements. And this is members of the Commission working very closely with parties to assist them with the practice of bargaining.
Okay. It wasn't separately funded like the small business unit, was it? It's an existing part of your functions now?
That's my understanding. I don't think there was a budget measure. It would go back to 2013, but my understanding that there was no budget measure.
Do you have data on who's participated and how many businesses have? And if particular commissioners have specific expertise in order to be involved?
Okay. In terms of the, at 28 February 2022, so this year, there had been 109 cooperative workplace applications. 16 of those are active at the moment. Parties, and this isn't obviously all the parties that have participated in the Cooperative Workplaces program, formerly called New Approaches, ASU, AEU, AMW, CPSU, IEU, MUA, NTEU, Alcoa, Catholic Education Office in Queensland, Macquarie University, MMA, Offshore Vessel Operations, News Corp, and a number of others.
Oh, good. How is it?
I might just, committee's okay for this report to be tabled?
Thank you.
Thank you, tabled.
That's very helpful. Is there any outsourcing here in terms of that training? And has the program been evaluated? Has it been successful?
It was externally evaluated last year. I have to take this on notice, but I can't confirm that that evaluation is completed, and that I've certainly sent a draft report, but I'm not sure if it's been a finalised report. So we have undertaken that an external evaluation of it, and I'll have to take it on notice in terms of whether or not it's been completed.
Okay, and I guess I can ask those unions and some of those other entities for their feedback too. Can I ask, is it seen as a successful program?
I think that we'll have to ask the parties that question.
Okay.
It's impossible for me to...
So in terms of cooperative workplaces, and we've touched on this already, how does the Fair Work Commission regard the unilateral termination of enterprise agreements by employers during the bargaining period?
As you're aware, Senator, employers, depending on, and I'll ask Ms Leggett to assist with this, depending on whether or not the agreement's reached or passed its normal expiry date, the applications can be brought by a party, but if it's prior to that normal expiry date, the application has to be brought by agreement by all the parties involved. My position isn't to comment on whether or not it's a good thing or a bad thing.
No, I understand that, but I guess if you're building, you are running a program to build cooperative working relationships using interest-based approaches. Can I ask you, in a legal and technical sense, therefore, I'm not asking for a comment on the merit of it, is at the termination of an award, of an agreement during bargaining, can it be seen as a cooperative, interest-based approach? It's a conflict-based approach, is it not? You know.
I might, sorry, step in, so I don't think that's something that the Mr. Furlong can really answer. And I might just work through the process a little bit as well. So it isn't actually a unilateral termination. It's an application by one party to terminate.
Yes, the Commissioner has to make a finding that
the Commissioner has to have regard the Commissioner has to have a regard to a number of factors, including whether it's in the public interest.
But it doesn't require the employees to agree, does it?
No, it's an application by one. So I'm just trying to make sure the language is clear. So it's an application by one party only, as opposed to where an EA hasn't yet expired or reached its nominal expiry date, in which case the parties more broadly have to agree. In this case, either an employer or employees can seek to terminate a EA, but they have to go through the Commission itself, and the Commission has to have regard to a number of factors, including whether it's in the public interest or not. So I just want to be clear, there is a process where the Commission actually has to consider a range of factors, including the public interest test. In relation, and I just want to draw a distinction there. So not all parties choose to undertake the cooperative workplaces approach, or in terms of how they negotiate disagreements or enterprise agreements. That's an option that's available to parties, but it's not a requirement that all parties undertake that approach. So trying to draw a correlation between a pathway that's available to people, but only if they choose, versus a pathway which is disconnected from that, where someone can seek to terminate an agreement upon its expiry or it's past its expiry date. They're unrelated. They're not linked at all. So it's just a very difficult question to answer in that sense.
No, I understand. I'm just thinking through and trying to come to understand how we can incentivise, I guess, what is a good thing in terms of a cooperative and working relationship, using interest-based approaches if in the law there is the opportunity to apply to unilaterally cancel it without the agreement of those affected. And I'm just trying to see how the Commission reconciles that.
The only other thing I could possibly add that might be of assistance is that both files are initiated on application of by the parties, and they are separate applications, separate forms, separate streams of work.
Thanks. I've now just got some questions about appointments to the Commission. Mr. Furlong, were you surprised to hear of the new appointment to the Fair Work Commission yesterday?
Appointments happen from time to time, as you're aware, Senator.
Are you expecting any further appointments in the next week or so?
That's a matter for government,
Are you aware of any vacancies at the Commission?
In terms of our funding model, our funding position, there notionally is one vacancy.
And that's the one that's just been filled?
With the Deputy Justice Mancini being appointed to the Federal Circuit Court recently. She was formerly Deputy President at the Commission, and with the appointment of Paul Schneider as a Commissioner yesterday, it was announced yesterday. In terms of our funding position, we're funded for 44 members, and a certain number of President, Vice Presidents, Deputy Presidents. There is one vacancy, notionally, at the Commissioner level.
Okay. So last week we discussed I think,
So-
43 out of the 44.
Yeah, so can I
And
just...
you filled a vacancy. I'm a little bit confused
So-
as to why there is now another vacancy.
Because there's a resignation.
Okay.
So there's been a resignation where a former deputy president of the commission has now been appointed to the federal court.
Yeah.
So she's now resigned. So federal circuit. She's now resigned from the Fair Work Commission.
When did that resignation take place?
Effective as of today, I think is my understanding, or yesterday.
Okay. And so when was that? When did the commission know about that resignation?
When they...
I received a phone call late Friday indicating that the appointment may be made, and it was confirmed on Monday.
Are you expecting the existing vacancy to be filled in coming days?
It's a matter for government.
Of course, I know it's a matter of government. I just want to know if they've given you any information that would indicate that it will be filled in coming days.
I've not received information indicating that it will be filled in the coming days.
Okay. Can you advise on the status, please, of the expert panel members? I understand the legislation provides for 6 members, 3 of which are currently serve and are working on the important annual wage review. What is the status, please, of the other 2 panels to do with superannuation? Do they operate and what is their status?
I might have to take that question on notice, Senator. I'm not, unless Ms Lee could provide some further information on it, I'm not aware of the expert panel for review of superannuation funds. I'm sorry, Senator, I will need to take it on notice.
Okay. No worries. When you were advised about the Commissioner transferring to the Federal Circuit Court, who were you advised by that was happening and when?
I received some information from one of the Minister's advisors, telephone call Friday afternoon, or last Friday. I'll have to confirm the timing.
From the Minister's advisors?
Yes.
On Friday afternoon?
It was on Friday. I have to check the time.
Okay. But you have, because, you know, I could surmise that people were being encouraged to leave the Commission in time for this government to make further appointments, and the government could expedite their reappointment elsewhere. But you've reassured me that you've got no such advice that anything like that's going to happen.
I'm not aware of any additional appointments being made.
Thank you. I think the 6 expert panel members are provided for by legislation. Are the other 2 expert panels also provided for by legislation?
They are. The Fair Work Act establishes those statutory officers, and it also outlines, it's been a while since I've looked at these provisions, mind you, it also outlines the skills and experience that those members, those part-time members or session members are required to have.
Okay. May I ask, do Minister's staff normally call you regarding appointments or departures, or would it be the President that would normally inform you, or how does that work?
I was appointed to this position in late September last year, so in my experience, my limited experience, in some cases I've received telephone calls, other cases the announcements have been made. I've received information from the Attorney General's Department as well, but essentially it's as a general rule, my experience has been before the appointments have been announced.
Okay. Mr Hare, what advice in recent days, what advice has the department given to the Fair Work Commission in relation to appointments or the departure of commissioners?
I'd need to take that on notice. Senator, I haven't personally contacted Mr Furlong, so I'd need to check with my staff.
Okay, thank you. I think we are ready to move on to the Ombudsman, Chair. Thank you, Mr Furlong, and to the staff of the Commission.
Okay, thank you very much, Senator Pratt. Thank officials from the Fair Work Commission. And you are now released, and I will ask representatives of the Fair Work Ombudsman to come to the table.
Sorry, I should have asked what happened. The department.
Senator Pratt, hang
all
on.
right,
So
no worries. I wasn't quick
closed,
enough.
But all right,
That's
okay.
fine.
If you could put on notice, that'd be fantastic.
I wanted to know for on notice what happened in December when they announced the additional appointments. Was it the Minister's office or the department that made that call at the time?
So,
I'd need to take that on notice. I can't recall.
No worries,
so
thank you.
we're going to take that on notice. It's in the records. You'll be able to see that. Thank you, officials, again. Is the Fair Work Ombudsman in the room? Or?
Not yet.
Not yet. Okay, we'll have a short suspension and wait for some rearrangements to occur. And Senator. The hearing and welcome to the table officials from the Fair Work Ombudsman. Thank you for appearing. And Ms Parker, do you have an opening statement?
No, I don't.
Thank you very much. I'll go to Senator Rennick.
Look, what legal recourse do employees have if they're made to get a vaccine, they get injured, and it's more so in the first vaccine, even though I guess there's a boost now. So they get a vaccine, they get injured, and then they can't get a second vaccine or a third vaccine, and some of these people have actually been given medical exemptions, but they've then been terminated anyway because they're not up to date. Is there any legal recourse with the Fair Work Australia when that happens?
Senator Sandra Parker, Fair Work Ombudsman. Look, I think we discussed last time. It depends on the circumstances, and it's I'm not avoiding the question, but we would need to see all the detail of exactly what it is. So there's a number of issues there. The first one was you said got a vaccine and they had a reaction to it. Is that correct?
Yep.
And so that meant they couldn't get a second one, or the employer sacked
Well,
them?
so there's either or scenario. They've got a medical exemption as to why they can't get a second one, or they can't get a medical exemption and they've still got to get a second one. Either way, they don't get the second one and then they lose their job. So I've had people come to me.
If they don't have a medical exemption and there's a public health order in a state that says you need to be vaccinated and the employer can't provide alternative employment, for example, if they're a frontline worker, then technically they can't do their job. So in that scenario, they can be...
But surely if they've been injured...
Injured by the vaccine?
By the vaccine, surely then and that's why I'm asking what legal recourse can they then claim workers' comp?
Yeah, I might hand to Ms Wolski if that's okay.
Yep, sure.
Thank you.
Rachel Volsky, Chief Counsel, Fair Work Ombudsman. So there are a couple of avenues that would be open to an employee in those circumstances. So the Australian government set up the COVID-19 vaccine claims scheme, and that essentially is available to compensate eligible people who've suffered a moderate to significant impact following an adverse reaction to an approved vaccine. So that's one avenue, and then of course there's workers' compensation, which is generally dealt with by the various states and territories, and information on both of those mechanisms is available on our website, including links.
So I have two questions. Can they, what if they believe they should get workers' compensation and the employer says, no, you can't claim? Can then they go to Fair Work to say that they feel like they've been, mistreated?
Yep. So that would be... Sorry.
So that's the first question. And the second question is, as you said, so they're no longer capable of doing their job, but they basically get terminated, but they've been terminated because they followed their employer's instructions to get the vaccine. They're now injured, and now they also lose their job in the process.
So with the first one, obviously, if somebody looks to make a workers' compensation claim, that would be a workplace right that would probably be covered by the general protections provisions of the Fair Work Act. So they certainly would be able to come to the Fair Work Ombudsman.
Okay, thanks. Good.
For that. And then for the second one, sorry, what was the second question?
So the second one is they actually get terminated because they can no longer do their job, but they've actually been terminated because they were doing what they thought their job was to get vaccinated. So I've had people contact me and say, well, I went and got the jab because I was told to, and now I've lost my health, and they've also lost their job. So they originally got the jab because they didn't want to lose their job, and in the end they've lost their health and their job.
So again, there may well be a number of avenues open. I would say probably in those circumstances, if they're covered by the Fair Work Act, it would probably be unfair dismissal that would be most relevant in those circumstances. Sure. Because it may not be a valid reason for dismissal, depending on, while they might not be able to do the inherent requirements, obviously there might be other factors to take into account. So that would probably be the first port of call, but there certainly may be others. Anti-discrimination legislation at both the federal and state level may well provide a remedy as well.
Okay, thanks very much. Cheers. Thanks, Chair.
Thank you very much, Senator Rennick. So I'll pass the call to Senator Pratt.
Thank you. Ms Parker, good afternoon. I'd like to refer to a media article which appeared on the ABC online on the 2nd of April. It was regarding a matter that your office, the Fair Work Ombudsman, investigated and prosecuted, and it was the fertility clinic Pagoda Tree. And I understand the situation here is that there was a Chinese medicine practitioner at the Pagoda Tree Clinic in Albert Park who took parental leave to have her first child in 2018. That's a case you're familiar with?
Yes, it
So
is.
we might just quickly, committee happy for this to be tabled? So tabled.
This one. Discrimination. Just recent one. Yes, we do have it. It's okay, we can do it.
And I'll just continue because I'm fairly sure if you're familiar with the case that others will get up to speed. The mother was owed nearly $13,000 in government-funded paid parental leave payments, but was paid less than half of that.
Yes.
Could you take us through some of the details of that case?
Could I get a copy?
Well,
we have it here. Oh, thank you.
Yeah.
Is a hard copy fit that? Yeah, no, that's fine. Yes, so we just got a decision through the Federal Circuit Family Court, and we sought a penalty, which was received, and the penalty was $58,590, and the sole director, Natalie Pringwoodis, has to pay penalties of $10,962. We did seek higher penalties, but that is what the court awarded. Yep. Did you want me to take you through the facts of the
Yes,
matter?
that would be great. Thank you.
All right. So in the case itself, so the respondents basically, so they admitted to underpaying one employee $10,296 under the Health Professional Support Services Award and annual leave loading under the Fair Work Act, as well as failing to pay the employee $11,509.40 in paid parental payment, out of a total of $12,948.30 owed to her during the paid parental leave period. The respondents also admitted to record-keeping contraventions, and the underpayments totaled $21,805.40. They have been rectified, but so we're happy with the outcome of that, and it was a very serious matter.
I was very distressed to read that particular case, that you've got a government-funded payment that you essentially your employer steals off you and your newborn baby.
Yes, indeed.
So is it true that the payments were transferred to the personal bank account of Ms. Kringudis and used to pay for living expenses, restaurant meals, alcohol, travel? I guess if you've stolen the money, it doesn't really matter what she spent it on, legitimate or illegitimate. How is it possible that those payments can end up in someone's personal bank account other than for the family for whom it's intended?
Oh, so the payments go to the employer and they'll pass it on, of course. So in that passing on, they obviously, and the courts found that they took some of that money for themselves.
So I understand that the employee complained to the employer. Are they supposed to be paid out over time in the same way that you would, so they're a fortnightly payment that the employer through their payroll gives
Paid
out?
parental leave?
Yeah.
I believe so. I think it depends on the payroll pattern. It could be fortnightly, it could be monthly. But they are absolutely required to hand those payments on, because that's what they're intended for.
And does the government pay it in one lump sum to the employer, or?
Senator, I think you'd have to direct that to
I'll ask
department.
the department.
Who administers the payment, who I think is DHS.
Yes. I guess I need to ask them if they paid out in a lump sum to the employer, who then sits on that money, or whether it's passed. I know it's supposed to be there to keep someone who's taking paid parental leave attached to an
That's
employer.
right. Yes, it is.
I can't see why you would want to be attached to an employer that purportedly promotes wellness and well-being for getting pregnant and then withholds your parental leave payments.
Senator, I understand that under that Act, just it might save you asking the question, that it can be paid as either a lump sum or in instalments.
Okay, do you happen to know in this case whether it was paid to the employer as a lump sum?
I understand it was actually in a number of instalments in this matter.
Okay, so did you work out whether the employer was withholding part of each payment?
Senator, I'd probably have to take that on notice, the specific details of that, and get back to you. I haven't got that to hand, unless Ms Dennis, who's our Executive Director of Legal Compliance and Enforcement, is able to answer that question. She should be on video.
Yeah. I guess I'm interested in the idea that in this case, you can clearly see that a large chunk of each payment, nearly half, as well as annual leave entitlements, was withheld. I guess I'm trying to work out, when someone is paid their paid parental leave payments by their employer, how someone goes about reassuring themselves that they're paid all of the money that was transferred to the employer. It's not that there's not money being skimmed off the top.
How do they assure themselves? Yeah, so the DHS provides pretty clear information about what people can expect to receive, and clearly this worker was complaining and asking the question, and we always encourage them to come to us if there's an issue, and in this case this is what happened. So it's a good outcome, and hopefully sends a really strong deterrence message as well for anyone else who might think they can do this.
And Senator, obviously the investigation that the FWO did undertakes that reconciliation to validate and make sure that that full amount is payable. And I think I understand in the course of that investigation as well, we also identified other entitlements that we're also owing as well.
Can you advise, please, of the circumstances of this matter in terms of how it came to your attention?
I understand that it was a referral that came from the Department of Human Services, is my understanding.
Okay, and is that the first and only such referral that you've had on payments like this being withheld?
I think can we take that on notice, Senator? Unless...
Are there any other cases that you're aware of?
Certainly not within my knowledge, Senator.
Was there someone online?
Yes, that's Ms Dennis.
So is anyone else in the Fair Work Ombudsman Office aware of these kinds of paid parental leave payments being withheld by the employer?
I think she doesn't realise she's not on mute.
Okay. So
Senator Pratt, I might just, I know we've only just started, but we are scheduled to have a break now.
Yeah, that's fine.
Just wondering, do you want to take that now when we come back?
Yeah.
Okay. All right. Thank you for that, Senator Pratt. Sorry for the interruption, but we will take the afternoon tea break now and come back at 4:45. Thank you. Suspend. Sorry about that short break, but going back to Fair Work Ombudsman and Senator Pratt.
Thank you very much. So just to round off on the matters in relation to wage theft before that we were dealing with, do we know if the employee of the Pagoda Tree was casual or full-time? Not that that necessarily impacts your... That's a separate question to your status under paid parental leave, as I understand it.
Senator, I think we identified contraventions of annual leave provisions, so I think that would mean she was ongoing.
Or that she was... Yeah, okay, so she would have been ongoing.
We still can't hear. Ms Dennis is on the line as well, but unfortunately she's on mute, I think.
Ms Dennis, can you hear us? Just nod if you can hear us.
Yes, sorry,
okay.
there was no volume for a while. Janine Dennis.
What do you know about this case? I know you've been listening into questions, so if you can just dive into the bits that have been asked that are relevant to your knowledge.
I can assist by letting you know that it's an uncommon request for assistance that the Fair Work Ombudsman receives in terms of failure to pay parental leave. We receive referrals from DHS. At the moment, I'm aware of 3 that's come through, although I can take it on notice as how many questions if it would assist, and 2 of which have resulted in litigation. So you've already discussed the matter of Pagoda. There's a second decision that relates to a failure to pay parental leave. That decision came down in May 2018 and relates to a failure to pay parental leave back in 2014. I'm happy to take you through the facts of that case if it would assist.
Yes, it would.
Great. So that's a case called FWO and Norcrete and another. In that case, there was a chef who was working at a United Petroleum service station. The employee in that case took parental leave but did not receive any paid parental leave. The employer received a lump sum payment of $11,538.90, but the employer failed to pass on that lump sum payment. The employee then complained to the Department of Human Services, who referred the matter to the Fair Work Ombudsman. The Fair Work Ombudsman commenced litigation in May 2016. That litigation, in addition to relating to the failure to pay paid parental leave under Section 72, also related to failure to provide record keeping, failure to provide pay slips, and a failure to false records. Was successful in that litigation, and we received a penalty of $118,440. So there's 2 cases in litigation that we've had relating to failure to pay paid parental leave.
Okay. Is there any concern that this is happening more broadly? I know you've said that you've received 3 or 4 complaints. Have you talked to the department about whether there could be a systemic problem in terms of discussion with the Department of Human Services?
No, we do talk to them regularly, and certainly they know to refer any concerns to the Fair Work Ombudsman. I'm not aware of a systemic issue though, Senator.
Okay, I've been looking at the way of claiming, and you have to register a birth as well as needing the employer needing to do their own things. It would be pretty hard, I think, for someone to apply on behalf of an employee and
Yes,
pocket
that's right.
their funds. What do you have any advice in terms of whether the status quo of how these things are regulated is good enough, or what more we can do to prevent stealing of a parent and child's entitlements?
As I said before, Senator, this case has received a fair bit of coverage. People are shocked, as you are, and that does have a deterrence effect. There's no question that we get. So we'll be monitoring requests for assistance after this. So if we get more inquiries, we always follow such matters with media releases and then other information. We put information on our social media channels and on our website, and we promote the issue. So it's an awareness issue as much as anything. But I do think the DHS has pretty good checks and balances, as you said. The mother registers as well as the business, so there's a way of checking both those things. So this is unusual, which is why we took it really seriously as well to take it to court.
Thank you. I'm going to ask them about some other wage theft. There was also an article in 2018. New South Wales man Kulpreet Singh and his company were fined $118,000 after falsely claiming he paid parental leave to an employee's husband. Is that one of the cases that you were referring to before, or is that a separate matter?
Yes, Senator, that was the case I was just referring to in terms of the facts.
Okay, thank you. What advice do you give parents in terms of how they should go about checking whether what's in their payslip matches up with what their government entitlement is, and how do you examine that in the context of someone also perhaps topping up with an employer-based scheme as well, and they dip in and out at various times?
So mostly through our information channels, and our website has information, but people can also contact us through our info line and seek information themselves. They can do it anonymously. We've got it in multiple languages on our website. So it's about promoting that to them, and also again through DHS when they're providing those payments, they also provide information to the parties, if you like, the pregnant woman and to the employer about their obligations. So we just keep trying to get the information out to people so they understand, at least to understand where they can go for help is a big step forward.
Okay. In terms of what you've seen of this issue, notwithstanding the fact that it's small, or perhaps that is mitigating, should that impact on the onus of the original policy intention behind making these payments from DSS to the employer, then to the employee, in order to keep that attachment to the workplace? Have you come across in the context of this whether that is an objective that's working in these payments?
Look, I think given we've only had these two matters, I'd say that's, given the number of matters we take to court and the number of requests for assistance we get every year, I would say that's a very low number of issues. They're serious matters, of course, very serious. But I think that the low numbers indicate that it is working as intended. If we found a pattern, if we started to see lots of requests for assistance and concerns and complaints being raised, we would pass that back to the relevant policy agency, DSS in that case, and let them know that there were issues, and we'd have discussions about that, and also with our own department, Attorney General's department. So there's regular conversations. So that's the way to raise it, and then government can become aware of it if it wishes to change the policy settings.
Okay, thank you. Do you, in terms of paid parental leave, are there a range of other complaints in relation to people serving the waiting periods to get access to employer-funded paid parental leave? What does the general landscape look like when it comes to paid parental leave and pregnancy-related entitlements or pregnancy discrimination? Are there issues there that you're able to highlight for us?
I think the Department of Human Services would get those sort of complaints.
Yeah, I'm not necessarily talking about the government-funded schemes here anymore. I'm
Just
also
generally.
talking about the provisions that you might have through universities or other big employers where they've now got those provisions.
I think I need to take it on notice. I'm very happy to find out what we have in the system around requests for assistance or complaints or inquiries. That's what you're seeking to see, whether this is a broader issue?
It doesn't necessarily involve a breach of the standards of employment rights, but I understand it would only come across your desk if it did, but it's certainly been put to me by people seeking to have children that they forego moving employers or career progression because they're waiting for the statute that they have to have worked for a certain length of time before they get an entitlement to their paid parental leave, and that has other implications in terms of delaying trying to get pregnant or workplace advancement. I understand that they're not policy issues you can fix because you're only upholding the breaches, but I'm just trying to unpack the interplay between the two.
Senator Pratt, if I could just add, and it was in the context of the Disability Royal Commission that Ms Parker gave evidence before, and so we did have a look at our data at the time, and the number of requests that we get for assistance in relation to discrimination complaints generally is actually quite low, and because and across sort of all of the protected attributes, a lot of it is because of wanting to, I guess, maintain the relationship with the employer, so they're often referred off to conciliation to see if there can be some resolution. And I'm not aware, but I'm very happy to take on notice any recent allegations relating to pregnancy discrimination, etc. We certainly have had investigations in relation to pregnancy discrimination in the past, but not recently that I'm aware of.
Yeah, it's hard you can feel like you've been discriminated against and have that, but it can be hard to convert that into a case. And I think I'm going off previous reports from the Human Rights Commission in that regard.
Yeah, I think you're asking about broader policy questions. Is the intention of the policy actually working, or is it creating other unintended consequences? And it would be a conversation to have probably with the department around, because they, obviously do a fair bit of analysis around how the policy's working in practice. But yes, not a matter so much for us, but it is an interesting question.
Thank you. In terms of the budget papers, I'm now moving on to another topic in terms of your resourcing. I'm reading from your budget papers that aside from the 2.7 million allocated in the 2023 financial year, that your agency's funding and staffing is being reduced next financial year and over the forward estimates. Is that correct?
Senator, I might actually, if Mr Campbell, if you're able to respond, that would be helpful on the budget.
I can see the 249 down to 241.
Yes.
Yeah.
Happy to assist, Ms Parker. Senator Michael Campbell here, Chief Operating Officer. Yes, as part of the 2020 Economic and Fiscal Update, the Fair Work Ombudsman was provided an extra $46.3 million over 3 years as part of the COVID response and COVID support for the community. And it was a expiring measure that comes to an end on 30 June 2022. That said, we have received some additional funding to extend some of those program offerings through till September, at which point those offerings will conclude along with the budget.
Okay, so in terms of the ongoing work that...
So in terms of, sorry.
Yeah. Have you done an analysis of what needs to change in terms of where resources are allocated within the Fair Work Ombudsman as a result of those cuts?
So Senator, the additional funding was provided to do a couple of things. One, to help set up the agency's response to the COVID pandemic, particularly around our role in JobKeeper, but also assisting employees and employers understand how to comply with workplace laws during the pandemic, particularly during potential shutdowns of workplaces and employees' hours changing and the like. So we obviously saw a ramp up in contacts to the Fair Work info line. That's very well documented, and that additional resource assisted us respond to that. And included among that measure was some funding for the Workplace Relations Legal Advice Panel, which was a provision to support employers and employees to gain access to some legal advice to specifically address circumstances in their workplace. So as that peak of work has come off, so too is our expectation of the need to have specific resources available for that customer base. Now, we're not at the end of this journey, obviously, yet. So we've got the appropriation does go through till the end of September. So at that point, we will obviously need to cut our cloth to fit. But our expectation is that's not going to be an overly difficult task to achieve, because so much of what we do in the COVID space is BAU for us now. So we're confident in a sensible transition, I suppose, to that new budget position.
So what are the priorities? How are you resourcing wage underpayments and wage theft? Have you managed to increase the resources that go to that?
Through other measures provided for by government in other appropriations, we have received additional resources for that purpose, and Ms Park will probably take you to that. But what I would say is this measure was about front-end infoline services. So there were additional ASL and additional budget for those people to effectively answer more calls. So that's the workload that we expect to taper off. But that said, we've still got plenty of work to do in the compliance and enforcement space, which we have provided additional funding for, particularly with respect to large corporate sector underpayment.
Yeah.
And yeah.
So in terms, Ms Parker and Mr Campbell, I think it's Campbell.
Yeah, it is.
In terms of how you administer and divide up your funding, which areas of priority, which areas are increasing and which areas are decreasing currently?
Yeah, so we had, Jacinda, we got some additional funding in the 2021-22 MyEFO, and that was two things, assisting on the new agriculture visa, and the second was from the scaling up of the Pacific Workers Program, and we received additional dollars and additional staffing numbers, ASL. And so they're priorities for us. So we have created a unit, an agricultural task force within the Fair Work Ombudsman, and that pulls together all the pieces that horticulture was already a priority for us. So we pulled that together with a focus on the agriculture visa and the Pacific Worker Program, and that covers things like our staff working with all the other agencies that are involved, their whole of government measures, whole of government priorities. And then we also have a program of proactive compliance, so we're following various crops, for example.
And so in terms of proactive compliance across, has the funding profile there changed at all? I would hope that's increasing.
Yeah, so what we've done is we've taken that additional funding that we received. So we received, for the agricultural visa, we received 0.934 million and 6.3 ASL for 21-22. And we got in total 8.7 million over 4 years for that particular measure. And the Pacific Workers, we got 9.4 million over 4 years. So that funding goes directly to that task force. And we're taking on additional inspectors. So the agriculture visa, for example, provides additional inspectors. They will conduct workplace compliance, history checks, on-arrival briefings, assessing allegations of non-compliance, investigations, taking enforcement action. And we also provide through those, we give workplace relations, education and technical advice to the departments involved like DFAT and Home Affairs and immigration, etc. And to employers and employees who are the employers who take on the workers through that visa, and the employees as well. And with the Pacific program, that's also providing additional inspectors, similar things that will be done there. So we absolutely, basically target the dollars and ASL to the areas of policy that the government intended them to be used for.
Okay. When I look at your budget appropriations and resourcing, you're combined with the Fair Work Ombudsman and the ROC are in together.
Yes.
I can't see any changes for the ROC in terms of budget.
They had a bit of extra. They've gone, the ROC's appropriation in 2021-22 was 7.230 and it goes up to 7.365 in 2024-25. They received some additional legal funding, I believe. So theirs has gone up slightly. I mean, I've got figures for our funding from for many years.
Yeah.
It does fluctuate over time. In general terms, I would say that we have had you could argue that we've had an overall increase. The largest was in 2021-22. That slightly comes off, but that reflects some COVID measures, as Mr. Campbell explained. We certainly haven't been cut as such. We just received some temporary measures that were always going to end, and they were, to be targeted to specific things for a particular period of time.
Are there any areas within your agency that you need to reduce activity in order to meet your budget?
No, I don't believe so, Senator. I mean, there's obviously more we could do with more resources. corporate sector underpayments are always a pressure for us, and they're incredibly complex and require significant complex data and analytics, etc. So there's areas that we're definitely under pressure.
Yeah, and what would they be? What areas would they be?
So the one I would single out is probably the corporate sector underpayments. I've talked in estimates previously that that has been you could argue, a relatively new area of work for the Fair Work Ombudsman, and we have received, a lot of self-reports from corporate sector businesses saying they've underpaid, and we've had, referrals from other agencies as well that we've had to investigate, and they're very complex. They can have hundreds of thousands of lines of data on payroll that we need to review. We've had to build capability. We're still a long way from where I'd like to be with that capability. We've had to get external assistance with that through some of the larger accounting firms. I'm sure it won't surprise you to know they're extremely expensive.
It wouldn't surprise
They have
me.
fabulous systems for analysing payroll. We don't yet. So all of that is being developed.
So you are developing those systems?
Yes, we are. But
have you got the money to develop those systems?
I guess we have to start where we are, and what we're doing is gradually building that capability and getting expertise in.
Are you building it gradually because you need to build the expertise gradually, or is it a limitation of resources?
Look, it's probably fair to say that it would be really difficult to try to do it all at once. Given we were an agency that was mostly dealing with small, medium businesses, that's an expertise that people absolutely had. This is new. You can't suddenly move from doing that type of work to suddenly dealing with Woolworths and Coles and Commonwealth Bank and all the big, larger companies that have very sophisticated payroll systems. So I think evolving capability build is appropriate, really. But I would say we are under some pressure there with the volume of those, and we do, those are self-reports. We don't actually do proactive audits.
Okay,
and
what is the current volume of those underpayments in the corporate sector?
Let me just check. So I'll just grab that brief. Now the number of companies. So I'd say we have, looking at the number, I probably could do it just to give you a sense of the scale. There's been self-reported matters have led to over $260 million in wages recovered for more than 111,000 employees in the last few years, and that's this is really since 2018-19. It obviously is a priority for us, and we're doing.
And across how many companies is that likely
sorry, I'll
to
just
be?
see if I can. So in this, I'll give you again, in the 6 months of this financial year, so to 31 December, we inquired into or commenced investigations into 47 large companies and reports, and 10 were large corporates. And last year, 2021 financial year, we commenced inquiries into 100 self-reports. And in those we entered into EUs, and of course we've got some matters in court.
Yes, that's right. Okay. So when you get an individual self-reported, means the companies come to you. Is that what that means?
Yes.
Yeah. Okay. Can I ask, in terms of your funding, if you take away the COVID-specific funding, just as an overall picture, is your agency's budget reducing or increasing?
Well, so our peak was, if we take away the COVID money. Okay, that's Mr Campbell, do you want to have a go at that?
Sure, Sandra. Senator, I suppose, as I've sort of flagged, there's been some ons and offs during that same period. So year on year, our budget the adjustment will be 12.3 million as compared to the current financial year. So while the budget...
12.3 this year or last year?
So next financial year's budget, so 22-23, will be $2.3 million lower than the current budget, and you'll note that that's less than the total appropriation we received, because we have received additional funding for the different measures, particularly around corporate sector task force and some of the visa matters that Ms Parker's already referred to.
Okay, so if you exclude the other separate measures as well, by how much is your funding? I know there are special measures that come in and out of every budget.
Some of it's ongoing, Senator, so we can't really unpack.
Well, if it's ongoing, then it's ongoing. I'm happy for you to include it. I'm trying to come to terms with your baseline funding and what that looks like. It sounds to me, even if we just include other special measures that are temporary but exclude COVID, that you have had a real reduction of some 12.3 million.
It's real in the sense that they're the numbers. But what I would say is that it is proportionately matched to the workload that drove that increased budget changing. So it's not that we are going to need to decrease the way we service the customer base needing our assistance in the compliance and enforcement space. It is simply the makeup of those people that are contacting us and the basis on which they're contacting us is changing. And as I said, while it was very new for everyone that we're talking about pandemic and the consequences for workplaces, particularly in February of 2020, it then evolved very quickly, and so too did our service offering. So as that's coming down, so too does the nature of our customer base.
Okay, so in that context, Ms Parker, with borders having been closed, but I'm assuming with them reopening, there will be an incoming of migrant workers. Are you expecting, has enough work been done to prevent exploitation so a complaint doesn't need to come to you, or are you expecting an increase in cases referred to you as the borders change?
It's a good question. Yes, I would assume that as more visa holders arrive, the logic would assume that we'll get more requests for assistance. Visa holders are a priority for us. Migrant workers are a priority for us. They really are overrepresented in our work. And they obviously are vulnerable, limited knowledge of our laws, cultural barriers, all the things that you're aware of.
Yeah.
I guess we would say, I mean, what our experience is they make up less than 4% of the workforce, but they account for 25% of our litigations, 65% of penalties and 18% of anonymous reports. So they're a overrepresented group in terms of requests for assistance and I guess exploitation, yes.
Are you aware of many cases where people have left the country sometimes because of COVID, sometimes because of visa constraints, where their complaint has not been resolved? We can pursue those matters after they've left Australia. But I might, if Mr Ronson able to answer or not, do you have any detail of that? Thank you. Thanks, Steve.
So Senator Stephen Ronson, the Executive Director of Enforcement, your question is relating to whether it's employees who've departed the country in the last 2 years.
Well, look, I've heard plenty of cases where I've spoken to unions where they've been supporting someone who's made a complaint, they get shipped off overseas. The complaint nevertheless continues through the work of your office, but it can become harder to substantiate things because people have left the country. That kind of
That's
example.
right, that's right. So our investigations continue, even if the worker departs from the country. And we've got, I think, an impressive track record on pursuing those investigations, and up until and including legal proceedings, where we have brought workers back from overseas to appear as witnesses before the court. Sometimes those witnesses are required in person. Other times the court may agree to a virtual a hearing, but we're, if you like, geographic agnostic. We don't mind if people have leave. We'll continue the case. So the obligation under the Fair Work Act is for the employer to comply with the law, and that's the way we approach the question.
Okay, that makes sense. Just a couple more quick ones. A national labour hire licensing scheme, would that help reduce wage underpayments?
Senator, I suppose we treat a labour hire operator like any other employer.
Yeah.
So we would say, they need to comply with the law. And so if someone comes and complains to us and says, and they don't always tell us if they're working for a labour hire company, by the way, they'll say, I have an employer and we'll pursue the matter. So I'd say a labour hire sector, though, where we do identify it, it was 2.5% of disputes for us last year. And so it's not a high, it's quite labour hire as a sector is quite a small sector, so it's probably commensurate with the size of it, the number of disputes we do. But certainly what we're seeing is, for example, some of the Queensland labour hire scheme, there's some good information coming from there. They appear to me getting their information out, and it's anything that helps from our perspective like that is good.
Yeah.
So whether a national one would make a difference, it's unclear at this stage.
Yeah, and it depends whether it's kind of wage theft in terms of people not being paid against what, or whether it's a kind of diversion of an EBA in order to operate under a different EBA in a workplace.
Yeah, in order if it's deliberately trying to undercut, if that's what you mean. But yes, it's certainly we treat them the same. So we would look at what are they supposed to be getting paid against the award or agreement, and that's what we apply. Yes.
And my last question, and thank you for your patience in letting us bounce around lots of different issues. In terms of migrant workers or people who come here on, say, a business conference or training visa, so they're still being paid from overseas. You might come into another country to do training or to do a conference, but if you were to come into into Australia on one of those visas and, say, work on in an automotive shop or on a shipbuilder, or how do we, but you're still being paid according to the wages and conditions from the jurisdiction that you've left, how do you approach whether someone's being paid correctly under those circumstances? I've heard examples of quite long conferences and training programs that really become not an exercise in training but an exercise in subverting the visa and wage laws here.
Yeah, and these are people you talk about who are working...
Well, they could be welding.
Working in Australia.
Yeah.
They're not just
welding. Say, for example, you're a welder and you come in to do a bit of a top-up course on training as a welder. You're being paid your welding payments from a country like the Philippines.
Yep. I understand.
How do you know? Thank you.
Senator Pratt, that comes down to the coverage of the Fair Work Act and, essentially those provisions in working out who's an Australian-based employee and who's an Australian employer. So from our perspective, we would make that assessment and determine whether or not the particular employee in question satisfies that definition, and then, look at, and obviously if they do satisfy that definition, then they have to be paid, in accordance with and as provided by the Fair Work Act and the various instruments that apply.
Have you come across contraventions of that kind?
I would have to, Mr Ronson might be able to answer.
Yes. I don't need to know these. I can think of a specific employer. I don't need to name them, but I'm looking for as much detail about what kind of arrangements that might look like that an employer has made in order to do that has then been found to be in contravention of the Fair Work Act.
Yeah, Senator, without naming that employing entity, I think we understand that's one that you've raised with us in the past.
Yes.
So I think, as Chief Counsel was trying to about to explain, the test we apply, if you like, for want of a better phrase, is there a substantial connection? And for example, you were talking about someone might come on a conference visa or a training visa.
Yeah.
Well, it would all depend on how long they were here, but there comes a point where the authorities, the legal authorities, have determined there is a connection and that they are covered by the Fair Work Act. Now, I'm simplifying that, and our legal Chief Counsel will probably be able to improve that definition. But we've got, over many, many years, we've looked at this issue and we've taken several of these matters to court, and there is now a jurisdiction or a jurisprudence around these particular matters.
Okay, so do you think that jurisprudence means it will stop happening?
Well, we've put those companies that try to, as you say, circumvent the visa class, they're on notice that we don't muck around and that it's inappropriate and it's unlawful.
And for people, have you made, what's the value of payments, and you might need to take this on notice, that have been made back to those workers?
I'd have to take it on notice.
Reached them all?
Yeah, I'd have to take it on notice because there'd be several matters of significance in the last decade at least that we could point to.
Okay. If you can take on notice the details of those matters in terms of the countries that they've come from and whether all of the money that is owed to the worker has made it back into their pocket, that would be terrific.
So to clarify the question, it would be those matters where workers were being paid in accordance with their host nation's payment structure, whereas they should have been paid under the Fair Work Act.
Correct.
Okay.
Thank you. And as much the profile of that underneath that would be terrific. And what is the length of time that you can work in Australia on the employment standards of the country that you've come from rather than the Fair Work Act?
I'm going to give you that famous legal response. It will depend. It's case by case.
And what if it was something like welding?
It would depend, but
Still depend.
It pretty much, once you get to several months, you're pushing the limits.
Yeah, and it would depend whether the country you're coming from is a higher or lower standard than in Australia too, I would guess.
I don't think
it's nothing to stop you from being paid more.
I don't think it's necessarily a test. I see what you mean. If there's an underpayment, yes. But the question as to whether they're a national system employee would be the nation they're from would be immaterial. Oh, sorry, Chief.
I have an act here for you, Senator.
Yes. Chief Counsel has just pointed to my attention that under the Act, the primary place of work is in Australia. So that's a key factor.
Okay.
Yeah, I should get.
Thank you, Mr Ronson, and thank you to the Office of the Fair Work Ombudsman. Thank you, Chair.
Thank you, Senator Pratt. Look, thank you very much, officials. Release yourselves. We might take a short break here while we rearrange to a different portfolio. I think we'll have a new minister. So we'll come back at 22, so everyone can just have a deadline to do that. Thank you. Thank you, everyone. Thank you. Thank you, Minister. Okay, we'll resume. And I welcome to the table Minister the Honourable Linda Reynolds. Thank you for being here. And also, of course, officials from the Australian Institute for Teaching and School Leadership. Minister, did you have an opening statement?
Thank you, Chair, but no.
No problems. And would any officials from the from AITSL have an opening statement?
Thank you, Chair, but no.
Okay. Well, I'll go straight to questions, and Senator Pratt.
The review of quality in issue of teacher education, the POR report, has now reported. Will AITSL have a role in implementing the recommendations of the QITE review?
Thanks for the question, Senator. We note that to date, Minister Robert has come back in response to one of those recommendations, which does not involve AITSL. But we also note that he's indicated that he'd be coming back in the next couple of weeks with further responses to the remaining recommendations and findings. And the majority of those certainly cut across traditional space that AITSL has led with initial teacher education providers and the school sector.
Okay. Has the department or the minister asked AITSL for advice on implementation of any of the recommendations?
Yes, the Minister's office has asked the AITSL board through its chair, Emeritus Laureate Professor John Hattie, for advice throughout the entire QITE review, including since its public launch for implementation and other feedback.
Okay, and what issues are those in terms of that feedback?
It's very consistent with the AITSL board submission to the QITE inquiry, which happy to share that. It's in the public domain, but happy to share that.
Fine. I was just trying to work out the extent to which that's consistent with the advice AITSL's given on recommendations. What work will AITSL be doing on going forward on the implementation of the report?
Well, as I indicated earlier, we await further announcements from Minister Robert, but we did note the department's response to, I think, Senator Lyons' question on Friday evening regarding some of the lines of expenditure that have been put aside for the QITE review's implementation. And of that, I think it was just over 100 million that Dr Baxter referred to in that piece on Friday evening. It relates in part to some of the recommendations that would see AITSL play a role between states, territories and the Australian government. That would be my expectation, Senator.
So $100 million, was that?
Could I just, yes,
Yeah.
absolutely, if I could follow up on Mr Grant's comments. So we were asked questions about the school education
Yes, that's
support
right.
measure last week.
Yes.
And we indicated there was some of the 228-ish million that was not published. And we indicated that part of that money was earmarked to progress recommendations of the reforms, but that because it would involve negotiations with states and territories, we would not normally publish that, as that might prejudice those discussions and negotiations with states and territories. So we didn't go into exactly how much of that unpublished amount related to that.
Thank you. So moving on to highly accomplished and lead teachers, are you able to update, please, on the implementation of the highly accomplished and lead teachers initiative?
Yes, Senator, and Mr Misson will just check the number for me, but I think teacher regulatory authorities reported at the end of December last year there were 1,025 teachers that were highly accomplished or lead in their certification status. Mr Misson, if you just confirm that at the end of this, that'd be good. And in terms of the penetration of that across the 3 schooling sectors in Australia's 8 states and territories, additional sectors come on board every year. The Victorian independent sector, for instance, came on board last year. So it's usually a timing issue about when the employing authority and their relevant teacher consultations see time to set up the relevant processes to enable teachers to submit and be recognised for their excellence. And that number is 1,025, Senator.
Thank you. Are all jurisdictions participating, and which ones are not, and why not?
Mr Misson has led this work, and I'll let him answer. I'm pretty sure the answer is they're all participating, but not all three sectors within the jurisdiction. But Mr Misson, can you be accurate?
Yeah, that's exactly right, Mr Grant. So full implementation in five of the 8 jurisdictions. In Tasmania, there's a pilot from last year, which involves all 3 sectors. In Victoria, the Catholic and independent sectors have been implementing since last year. And in Western Australia, it's the independent sector only.
Which states don't have the government sector in yet?
So in terms of the government sector, that would be Victoria and Western Australia.
Okay. And in the case of independents?
Independents would be all states and territories now, Senator, noting that the Tasmanian pilot is still officially a pilot.
And the Catholic sector?
The Catholics, again with that caveat about Tasmania, all but Western Australia.
Okay. How many teachers have highly accomplished or lead teacher status? I think you said, was it 1,025?
1,025. Yep.
What's the number of teachers with HALT status for each year since the initiative was implemented?
I'm not sure that I have that in the brief here. Senator, we could certainly provide it on notice.
Okay. How are those teachers spread across states and territories?
I can tell you that, Senator. So I'm just adding up Western Australia, noting it's really only the independent sector, and there was, just for completeness, there was 1 year when it was offered in the government sector, 24. Northern Territory, 131. New South Wales, 280. ACT, 106. Queensland, I'm just going to have to add up 2 numbers here. Yes. 264. No, apologies. 267. South Australia, 195, and Victoria, 22. I hope that adds up to 1,025, Senator.
Do you also have a breakdown of HALT teachers in rural and regional areas versus... If you don't, you could take that on notice.
No, I think we can provide that on notice based on a survey, so it won't be comprehensive, but will give a sense of where the distribution is.
Thank you. Has AITSL done any work with the department on modelling and analysis of teacher supply and demand?
Senator, the department and AITSL share sort of a left and a right hand here. The department has taken the lead over the last probably 6 or so months, collecting and liaising with states and territories demand data, projected demand data, and we collect on behalf of all Australia's education ministers the ATWD, the Australian Teacher Workforce Data Set, which picks up effectively the supply data. And between the two of us, we work together on that. The supply data is obviously more mature in that it's been around as a project for a few years, and some reports come out that give a picture to the teacher workforce, whereas Dr. Baxter would, I think, say that the data is in its very early stages of coming through to the department on the demand side.
Okay, so we were told last October that you were sharing the work with the department, and that was the department that said that. So can I ask, do you have a sense of how long it will take to model that?
I'd probably need Dr. Baxter to give an update to the work being done with the jurisdictions on the demand side, and then the two pieces can come together to do some modelling. So if Dr. Baxter has some updates, it'd be wise if she could share them.
Okay. Can I ask, in terms of supply and demand, how is demand growing?
It's very difficult for AITSL to give a sense of demand data from jurisdictions in the department is working and collecting it. It'd be best to see if Dr. Baxter has anything to add.
Okay. Sorry, I didn't look up at the appropriate time. Clearly you didn't. Can I ask?
Oh, no, I do.
Okay,
I
good.
just wasn't sure if you wanted me to.
Yes, I do.
So I think the thing about supply and demand that Mr Grant has just outlined is that really the AITSL has largely dealt with the supply issue. So, you know, where are the teachers and what are their characteristics? And that's through that ATWD project. So questions about supply, Mr Grant would have that modelling with him. He would be able to provide it. On the demand side, this is really a factor of what's going on in states and territories.
Yeah.
And so through education ministers, it was Minister Tudge at the time who undertook for the department to lead a little bit of modelling on this. As we've mentioned previously here, we have undertaken some high-level modelling of teacher supply and demand, and we've mentioned the top-line number here, and we've also provided some bits and pieces on notice about what fed into that data. The key thing, though, is we haven't been able to publish that data yet, as it is the data of states and territories, and we need for that, the report of that modelling to go through education ministers and be approved by them. So we have tested it with them and done some work with them, but it's not yet approved.
Is there any evidence that states and territories are telling universities and others what to bring through in their supply chain, or what are the implications of that delay in the availability of that data as far as pulling timely levers in the supply of teachers goes?
Well, we certainly do know, Senator, that the government's package that looked to increase the availability of teachers and some other areas as well through its Job Ready Graduates package does seem to have, you know, looks at this stage as though the data is suggesting it's had some early success. So
it wasn't so much about that growth, it was, was the Job Ready, was the pulling more places into those, into teaching at universities based on modelling, or was it a gut feeling? Where did the data for that come from if it wasn't through the states and territories?
So we have been working on this data with states and territories for some time. Okay. The report that I'm referring to, that's not yet published, is a piece of work in progress. Because it is their data, we wouldn't publish it until it does go through education ministers. So yes, the department has done modelling. The high level I reported last time was that there is expected to be a shortage over the next 4 years for secondary schools, but that supply and demand look to be fairly well balanced in terms of primary schools, and that of course there are also some supply and demand issues in regional areas and also in some particularly specialist areas of teaching like STEM, for example. So that was the high level that we reported last time, and that was very much where Job Ready Graduates was pointed towards that supply of teachers. And as I said, The 2021 headcount does look really promising. I've got some updated data from last time if you would be interested in those
you've
increases.
touched on it already. I'm keen to understand what the modelling is showing in terms of where there is still likely to be a shortage and in what areas, including the year of schooling and the subjects.
Thank you, Senator. So it's really the same line that I provided last time, which is approximately 4,000. We think that the demand for secondary teachers will exceed the supply of new graduate teachers by approximately 4,000 over the period to 2025. But I would note this is Commonwealth modelling. We don't run schools or employ teachers, so we are reliant on education ministers to confirm that data. We have done some testing with them. And I would also emphasise that is a point-in-time estimate, and it does rely on a set of explicit assumptions. You might recall last time we went through some of those, and on notice we've provided more detail about what those assumptions are that are packed into that, but I can certainly canvass them again if that would be useful.
Are the teacher shortages likely to be across all states and territories? Where, of that 4,000 shortage, where is the proportion of the greatest need or the greatest shortfall?
Senator, I don't have with me. I'll see if I can get it to you.
Yeah, that would be great
during the
if you're able to
session.
get it.
I can certainly take it on notice what our modelling suggested, but again, it needs to be confirmed by the relevant jurisdictions.
And what subject areas are that shortfall?
Again, I'll come back to you with specifics, but I do recall that it was both geographic areas and also some subject areas, and STEM is the one that I recall coming up most regularly.
So we've heard from a number of universities that their ITE enrolments have dropped in 2022. Do you have any of your own data on that?
Yes, I do, and I started to allude to it when I was talking before.
I think you were alluding that it was increasing.
So we've got some early data that's a head count of undergraduate Commonwealth supported places, and we have actually seen increased commencements in all education fields compared to 2020. So early childhood teacher education has increased by 18.7%, primary teacher education by 6.9%, secondary teacher education by 5.4%, and other education by 20.3%.
So if we've heard anecdotally from unis that their enrolments have dropped this year, do you think we're hearing that because they're outliers and they've dropped where others have gone up, or how would we explain that?
Senator, I don't know. It doesn't accord with the data that we have. I would say that the final 2021 data set won't be available till mid-2022 at the earliest, but certainly for us the early signs are encouraging. Now that's not to say they're across the board increases. It may be that some schools are experiencing difficulty. We know there's been lots of issues relating to student choice, especially students who are leaving during this COVID period, making different sorts of choices about where they study and what they study. So it may be that there's issues for particular institutions or particular geographic areas where institutions are located, but I don't have that with me, I'm sorry.
Okay. May I ask if AITSL's heard any feedback from universities or seen it in your early data, or is it the same as what Dr Baxter would be referring to?
We certainly don't have any data, Senator. The most recent data set that we published was 2018, and we'll publish 2019 in June and 2020 in December. We don't have any more recent data.
Okay, so when will we be able to compare this year to last year and the year before?
So 2021 data would be mid-2022, Senator. And then at that point, you'll be able to compare 2021 to previous years. So it's a bit of a 6-month lag in getting the data. I'll also let you know I undertook to see if I could get that data disaggregated for you to region and subject. We don't have that in this data set, so I won't take it on notice. We don't disaggregate our model down to that level. I've just checked while we're in session.
Okay, and when will we hit the peak of these shortages if there's 4,000 over the next 4 or 5 years, I think?
That's out to 2025.
So how many thousand secondary teachers, what's the proportion of that that's secondary teachers?
That's secondary teachers, the
okay,
4,000
and
secondary
how many
teachers.
what percentage of the overall teaching We must have, lots of secondary teachers, but 4,000 still seems like a lot to
We
me.
do. I'll let you know. I mean, actually, that's probably a question Mr. Grant will have at his fingertips, but I've got some data here as well about where our teachers are at the moment.
How many
That
secondary
one-
teachers are there?
Mr. Misson might be able to find the breakdown. I know it's approximately 330,000 in total, but Mr. Misson, are you able to finger on the secondary component?
I'm just looking through this report, Mr. Grant, and I'm finding percentages so far, but let me find the numbers. I'm sure they're here.
I do have some data here.
It's
found
1 point
from the-
something percent.
It's about 51% in primary schools and 49% in secondary schools.
Have a shortage?
No, that's where the teachers are located. You asked where the
that's
teachers
fine.
are located.
Yeah, thank you.
No, the shortage that I mentioned, the mismatch for
Yeah.
our high-level modelling between supply and demand, that 4,000-ish, it's about 4,100, that is a secondary school number.
Okay, so if there's 330,000 teachers,
I think 346,000 is the last total we've got. That's teachers in Australian schools.
Of those, this is based on a sample, 29% would be in secondary schools. There are another 23 in combined primary and secondary. So, I guess if half the ones in combined schools are secondary, you are looking at about 40% of that workforce.
okay. And what's the existing shortage if we're 4,000 short in the future?
So that 4,000 is a cumulative total over the 4 years to 2025. I've mentioned I can get you the numbers that underpin it by state and the years on notice. I don't actually have that here with me, but we can get it.
It's a cumulative total
that we're
for
adding
each
up.
year.
Yeah, we're adding up what there was in a particular year to the next year.
Okay, so what's the overall shortage in each year over those 4 or 5 years?
I have seen a little table, Senator, but I'm sorry I don't have that here with me, but I can give it to you on notice.
Okay, I would appreciate being able to see that. Can I ask? I think you compared 2022 with 2020 instead of 2021. Is that because we don't have data for either 2022 or 2021, only 2020?
No, we have provisional 2021 data. So the figures I was giving you of increases were a comparison between 2021 and 2020. But I did just let you know that those 2021 figures are early figures and the final 2021 figures will be available in mid-2022.
Okay. And what's the forecast of when we begin to get back into a period of time when we don't have any shortages?
So I would again emphasise, Senator, that this is just high-level modelling that the Commonwealth has done. One of the issues we have had in trying to get this modelling has been to get actual data from the states, and it is an issue that Commonwealth education ministers have raised on a couple of occasions now with the states, the difficulty in getting this information. So we have it for the period to 2025. It's yet to be tested and confirmed from those states. So I think the kind of when will we reach a point where we're not in shortage, I think that is beyond the scope of our high-level modelling at this stage.
Okay, I think that's it for AITSL this evening. I think we're able to move on to TEXA, I would hope.
Thank you very much for that.
Thank you
for
to AITSL.
Officials from AITSL. You are released. And so we will now move to the Tertiary Education Quality and Standards Agency. Are they in person? They're in person? Doesn't look like they're in the room though, so we'll have a short suspension while they make their way. resume, and welcome to the table officials from the Tertiary Education Quality and Standards Agency. Welcome, Professor Coldrake. Do you have an opening statement?
No, I don't. Thanks,
Thank
Mr.
you very
Chair.
much. I'll go straight to questions to Senator Pratt.
Thank you. The National Student Safety Survey and its results. Let's dive right in there. In light of the findings of the National Student Safety Survey released in March, does TEXA believe that universities are doing enough to address sexual assault and sexual harassment on campus?
Thanks very much, Senator. I don't think that any of us can assume that we're doing enough, given that the results are really not shifted between surveys. We're talking here about a ghastly sort of problem that besets society at large and all organisations within it, universities in particular, not just the universities, who of course dominate higher education enrolments, but the other providers as well. So your question is that the survey just reminds us that we need to redouble our efforts and accept that the progress has been very slow.
So in that context, TEXA assessed in January of 2019, in their report to the Minister, universities were by and large actively responding to the issue of sexual assault and sexual harassment. Why is it that we haven't improved? Can I ask what regulatory activities TEXA undertook to locate and assess evidence since 2019? At the time, we were told TEXA will look for evidence to confirm that all higher education providers are taking action to prevent and reduce the incidence of sexual assault and sexual harassment and support the victims of assault and harassment appropriately and in a timely manner. Are universities doing enough?
Senator, I might start, and Alistair McLean might continue on. I think we can be fairly sure that all universities have been attentive to the rising nature and the serious nature of the issues. And from the work that we've done with agencies, particularly around re-registration time, the responses they've made to what we call SASH have been part of that assessment process. But it's fair to say that given the results haven't shifted, that the actions have not been sufficient. So there's no denying there. At the end of the day, or perhaps at the beginning and at the end of the day, this issue actually is very much about it's about education and prevention. It's about ensuring that the issues are embraced by the very top of institutions, that is to say, the chancellors and the vice-chancellors and the governing boards, that the messages are consistently conveyed through the institutions and that students are aware of the matters. One of the things that did particularly concern us was, in the recent survey results, was that a lot of students are still not aware of the mechanism. So there's a lot of work to be done there. So I'm not resisting in any sense your question or the burden of it, but saying that I can rattle you off a number of things we've done, but it's fair to say we also need to review what we're doing.
Okay, and in the context of reviewing what we're doing and what TEXA is doing, in 2019, when TEXA did say universities were already largely actively responding to the issue, it's my understanding on that basis the Minister at the time decided not to set up a university sexual assault task force, as was called for at the time. So we didn't have a task force on the basis that 2019 effort was adequate. Would you say effort is adequate now?
you understand?
Oh, in 2019, Senator, the work that had been done by TEXA between 2017 and 19 was principally assessing providers for their frameworks, policies, procedures for dealing with sexual assault and sexual harassment in line with re-registration of providers. So,
well, that's not really how it was framed at the time. It was framed at the time as us not needing a task force because there's already a proactive approach in place, whereas you're really just reflecting on business as usual. Here's the accountability under the compliance framework.
Not just that, Senator.
Yeah.
So there was the assessment work that was done as part of re-reg of providers, and that work demonstrated that improvements were being made by many providers, but that there remained work to be done, further improvements to be made. At the same time, we developed what we call a good practice note or a guide, which is part of our outreach to the sector and providing, in particular, best practice examples across the sector in relation to differing aspects of sexual assault and sexual harassment and how they're responded to by providers. So there was some progress being made at the time, but we acknowledged in 2019 and since that further improvements needed to be made by the sector.
Can I ask what regulatory activities TEXA undertook to locate and assess the evidence? And by evidence, I'm referring to your commitment back in 2019 in your report that you would confirm that all providers are taking action to prevent and reduce sexual assault and sexual harassment and to support victims.
Well, there's 4 components to our activity over the last 4.5 years. The first was those assessments of some 60 providers between 2019 and 2021, which I've just referred to. The second was our engagement of the sector around things like the guidance note, the good practice guide, and other forms of outreach through participation in forums, etc. The third area, which you've touched upon in your earlier remarks, goes to the receipt of complaints and the generation of our own concerns about specific instances of, or alleged instances of the mishandling of sexual assault and sexual harassment matters by providers. We've considered a total of 31 such concerns over that period for this year, in the last year. 6 of those are now subject to monitoring with those providers, and 3 are still open for ongoing assessment by TEXA. And then the fourth component of our activity is a more recent one where we're working with peak bodies to develop communities of practice around frameworks, policies and procedures for dealing with sexual assault and sexual harassment incidents, allegations, concerns, etc. One is with the Higher Education Private Providers Quality Network and about 20 providers, and another one is with the Independent Higher Education Association and about 28 providers in the private provider space. Those communities of practice have really delivered some
regulatory
benefits.
activity look like?
Beg your pardon?
Does it include, how do you must be reviewing reports and following up with those that have been subject to sexual harassment to find out how they were responded to. A guidance note wouldn't tell you what actually happened to a victim on campus.
No, it's one component. And our compliance assessments are the component of our work which really give us a feel for how providers are responding and implementing the kinds of measures and policies and procedures, etc., that we recommend for our good guide, best practice examples. So that's where we seek to address and measure and monitor the sector's performance against the standards and against our advice to the sector.
It's fair to say, Senator, that as a regulator, it's one thing to talk about sending in flying squads or to do, to do radical things, but really the hearts and minds have got to shift on this. And as with the issues around industrial scale cheating, and as with issues of underpayments for staff, we've actually worked with providers, not just universities, but all providers, to make sure that from top to bottom, there's an awareness of the issues and that people are taking action. The so-called regulatory action that you refer to, of a more distinct kind, is something that might follow. But I'm not sure that. I think persuasion is the best way to go in the first sense, but also ownership. It's not. It's ownership of the issue and recognition of the seriousness of it. The workplace in Australia, whatever your organisation, suffers this set of issues. Universities, I'm sure in particular, would like to be making progress more quickly than others. And it's frustrating that it's been so slow.
It is. Can I ask in that context, what did you find in those activities in terms of the prevalence of sexual assault and harassment based on the regulatory approach and the reporting of universities compared to what the National Student Safety Survey actually said?
Can you repeat the question?
Was the scale of the National Student Safety Survey revealed a very high prevalence of sexual harassment and assault, with 1 in 20 students having been sexually assaulted since starting at uni, and 1 in 100 in the last 12 months. Was that a surprise to you, or could you see it in your regulatory activities since 2019?
And I don't think we saw it, and like for a lot of other things, we were understandably probably a bit confounded by COVID, because COVID had a great effect on those operations of providers which are campus-based. What was probably harder to understand was the shifts that were occurring in the online part of the world. But we certainly, if we'd been guessing, we would have probably assumed there would have been some modest improvement between the last survey and this, and that wasn't the case.
I think it's fair to say, Senator, that the extent of the survey results with respect to the student experience of sexual assault or sexual harassment, and then also the other important part of the survey outcome was the extent to which students are not aware of grievance or complaint mechanisms presented by providers or that should be made available to students and that they should be aware of. So that was striking for us, and that's cause for thought about what more we can and should be doing to, work with providers to ensure that students have a strong awareness of grievance procedures for dealing with complaints, allegations or incidences of SASH.
Okay.
And it starts with very simple things, Senator, such as websites.
So how do your findings compare with the Australian Human Rights Commission in terms of if you are one of the 1 in 20 students that has been sexually assaulted since starting university, in terms of accessing timely support easily accessing timely support?
Well, we haven't made findings as such, Senator, because we haven't conducted surveys of our own. To the extent that we have findings or are reaching conclusions, they would be based on the shared work that we do with providers, and secondly on the concerns and complaints that we deal with. So, as I said earlier, the extent to which the UA survey showed that students are not sufficiently aware of grievance mechanisms, etc., is a basis for us to consider what more we should be doing.
Were you surprised about that mismatch? I wasn't.
You were not.
No. Not particularly not in the context of all of that, we've had a lot of discussion about sexual harassment reporting across many since 2019, which is about when the Respect at Work report was tabled, and I wouldn't really expect universities, I would have expected universities to be even a more difficult environment than a typical workplace.
They might be. They're also highly variable because campus-based institutions, non-campus-based, but also the involvement of international students, there are a lot of complexities.
That's exactly my point.
Exactly.
Which is why I certainly wasn't surprised.
And there are also different, Senator, there are different cultural responses to those issues too. So that makes it, there's no excuse for any of it. It's just, it's a very complex tableau.
But it's essentially the same issue, the issue apart from technology. I certainly had friends that were sexually assaulted at uni back in the 1990s. It's always been an issue on campus that women's groups and student groups have sought to be active on. Do you think that there was somewhat of a complacency, that it was assumed that this was just a kind of student activist cause as opposed to actually having a depth of experience behind it?
I think in most institutions that there has been an awareness that it's a serious issue. The recent results are a jolt that progress has not been made, and we should actually use that jolt to empower ourselves and to encourage institutions to take the matters seriously from the very top. And one of the things I suspect we'll spend more time on in the next year or so is engaging with the governing bodies of providers to ensure that they're aware of the issues and dealing with managements and through their systems. I'm afraid to say that this issue is not going to be one that we know is not going to be one that's dealt with via other than small steps. But we've got to make sure that those steps are being taken, and we've got to ensure that there's just an awareness and a concord around that.
So in terms of small steps, would ensuring that information is accessible at least on the provider's website be adequate?
No, but it would be, it is one.
Okay, and I understand that Minister Texa, in response to the 2019 report, said as part of the registration process, you'd ensure that information is accessible at least on the provider's website. However, in answers to question on notice, we were advised that no registration-related SASH assessments were conducted this financial year, as Texa has focused on working with peak bodies to enhance the capacities of providers to prevent and respond to sexual assault and sexual harassment. Can I ask, how has Texa complied with this and other January 2019 commitments to the Minister?
Senator, the fact that we changed our approach last year to no longer to be assessing providers in line with re-registration doesn't remove an ongoing expectation that as part of registration, a provider will make information available on grievances, etc., on its website.
Yeah.
So that's the first point, I think. And secondly, our work, particularly with peak bodies around communities of practice includes and extends beyond awareness, training and availability and access to that information for students.
Do all of your regulated tertiary higher ed entities have that information on their website?
I'd have to take that on notice, Senator. Do all of them have information available on their websites?
What proportion of entities that you regulate have that information accessible on their website? And I would assume that you'd be able to gather that answer given TEQSA undertook back in 2019 that it would be part of the registration process for renewal.
Senator, I would take that on notice. I don't have the information in front of me or with me today, but I'm confident that a majority of providers would have that information on their websites and available, partly because of the numbers of re-registration that we've undertaken over the last 4.5 to 5 years. But we would have to respond to you on notice.
Okay. The National Student Survey also found more than half of all students know very little or nothing about how or where to formally report incidents of assault, sexual assault to their university. Can I ask how that accords with TEQSA's findings, commitment back in 2019 to ensure that the information is accessible to students?
I'm not sure that, Senator, I'm not sure that we've got much to add to what we've already said. I think the result is patchy.
Okay, can I ask also, other than the university, there are a lot of linked entities that might have a higher need to respond, for example, student halls and accommodation. How have you worked through those regulatory issues with providers other than universities?
Well, as Senator, as part of the process of registration and re-registration, all providers are expected to acquit certain responsibilities. All are required to have grievance mechanisms, all are required to have corporate governance.
So for example, if you're regulating a university, what requirements do you put on them to regulate the associated university halls that might have students from that university and others?
You're talking about university residential halls?
Yes.
Well, that's a thicket of its own.
I understand that, hence I'm asking the
because
question.
of the legal separateness that they enjoy. But it's fair to say that parent universities have, I think, for a long time engaged and are undoubtedly engaging now with university halls, recognising their independence and respecting that independence, but ensuring that there's a common mission here to be pursued.
Okay. What urgent action has TEQSA taken since the launch of the report in March this year? What action have you taken? You know, it's only a month old. What have you done in the last few weeks on this issue?
Do you want to go first?
Yeah, Senator, one of the early things we did was coordinate with the department on a correspondence from the Minister to Vice-Chancellors of universities. So that was one of the actions that we took. The second one was to release a statement of our own, reminding providers of their responsibilities and obligations, particularly pertaining to the relevant standards around the issue of SASH. The Commission itself has considered our own work at the moment. I convened an internal meeting about, okay, what should our response be? Where are our settings appropriate at the moment? Is there a call for us to reconsider our settings on SASH in the light of the survey outcomes? So that's a process that's has commenced internally, and we'll be advising the Commission in that respect shortly. So that's the extent of the activity to date.
And there's just one other, please, if I could add, Mr. Senator. We're actually we have been we regularly do, but in the last month. We've actually been meeting with all the peak bodies across the sector, both universities and other institutions. And in every one of those discussions, I recall, because both of us, I think, have been at them all, the SASH issue has been front and centre, as has been a couple of other issues, including the actions being taken around industrial scale cheating and wages.
Okay. Well, there's a cohort of students on campus today who've been sexually assaulted, who've never reported it. That might be, starting to scale up prevention, or, have you taken any action, and do you have capacity to take any action in terms of addressing and actually coming to grips with stuff that's come out in the student survey, that there's a whole lot of detail there, institution by institution, that demonstrates a significant problem that could still be faced by students today, be still affecting their capacity to study, etc. We've actually got to turn this around to some on-the-ground action, university by university, course by course, student by student, to ensure not only there's regulatory action in the future, but as you said, Professor Coldrake, this is a significant issue that requires changing hearts and minds. Where are the hearts and minds in this response? And where are the hearts and minds in terms of the impact on students who've already been assaulted?
Well, I'll perhaps provide a general response and just say that all hands are required here. We have a role in terms of administering the higher education standards. We have a role in terms of ventilating issues and encouraging best practice. We work complementarily to the institutions, and in the case you've been referring mainly to the universities, which predominate higher education enrolments overall. But let me just say to you, I don't want the impression to be left, Senator, that people have just been idle. I think there have been a lot of institutions that have been working really hard from top to bottom. And there may be some that have actually have been less active, but a lot of institutions have worked very, very hard, and perhaps the effectiveness of that work can be reasonably questioned. But I don't think you'll find much defensiveness about that. I think people are very troubled by this, as they are with these issues in society.
Senator Dunford, Deputy Secretary of Higher Education, Research International. I think when the report actually came out several weeks ago, many universities publicly put out that they were disappointed in the data and disappointed in the results, and they needed to do better. And many universities listed the range of initiatives that they're currently putting in place and new ones that they'll be putting in place as a result of that data. So that's public information. ANU, for example, announced a $3 million initiative looking at sexual harassment and sexual assault and doing better. I know Sydney University put some things out as well. La Trobe University put out some detail. Everything from mandatory training of staff as well as of students, residential advisors and tutors. So there was a long list of things that were actually being listed, which is important. But as I think I might have mentioned in our hearing last week, in our weekly compact mission discussions that the department has with universities, we also have a conversation around student wellbeing. And so one of the areas that we'll continue to focus on as a result of the survey is particularly highlighting about their actions around sexual assault and sexual harassment as well.
Thank you. Can I ask, Texa, you had said in relation to your approach to addressing sexual assault and harassment, I think it's in SQ22 number 76, You referred to your approach being working with peak bodies through communities of practice to enhance the capacities of providers to prevent and respond to sexual harassment and sexual assault. Given the findings of the National Student Survey, which highlighted the lack of confidence of students, has TEXA considered or whether that existing approach or this new approach is the right way to approach this issue? Is it appropriate?
I think that's a question that we should be asking ourselves, Senator, and that's a process that we've commenced since the UA survey results were released last month. As I stated earlier, we've convened an internal process to consider our settings, and part of that would be whether or not our focus on communities of practice through peak bodies for private providers is adequate or sufficient, and where that focus should be adjusted in the light of the survey results.
You could survey students directly, couldn't you? TEXA could. You could do anything as a regulator, really.
Well, we could, but we've got to think about the effectiveness, Senator, of that which we do. Students primarily will relate to their institutions. They want to have confidence in the systems. We will hope that they will have confidence in the systems of their institutions, but that will be their reference point. If we can work with institutions, as Alistair has said, the developing of the communities of practice, which didn't start in March, they predated. They started last year or the year before, certainly last year. I don't know if I've got anything to add to that, but
yeah. Part of this, Senator, I think reflects where we should have our regulatory settings in terms of our regulated entities. And our focus has been on the frameworks, policies and procedures that providers have in place. I think our intent and the Commission's intent would be that's where our focus should remain, rather than stepping onto a campus and dealing separately with entities on campus without the providers' cooperation and say-so, if you like. But
sometimes you need to elevate the voice of the victim within something in order to
and
really
an
get some
engagement with
accountability,
students and student representatives and
here.
student unions is part of our approach. But that's the sort of thing that we're going to have to calibrate, consider, and make some recommendations to the Commission on.
Yeah. Can I ask, beyond the group of 8, what interaction TEXA's had with other Australian unis in relation to its community of practice approach? And are you engaging with Universities Australia or other university sector peaks on that approach?
Well, we've discussed we had one of the meetings I referred to earlier was with Universities Australia. I think the communities of practice as an initiative is now well known. As Alistair has said, there's only 3 of them.
And covers 48 providers.
Covers 48 providers. There are 3 now. I suspect that in the months ahead there'll be a range of others, probably coordinated through their peak bodies. That's the appropriate thing. Got to start somewhere. It's good to have 3. It's good to have the private providers actively involved. It's good to have the GO8. UA's very aware of the issue. I think UA's concern was pretty strongly expressed a few weeks ago in respect to the survey. So I don't think there'll be. I don't think that it will be difficult to mobilise the action. The challenge is always be to sustain it. You've got to sustain it. So it is a relentless activity, as it were.
Okay. You've provided information on a number of registration-related sexual assault and sexual harassment assessments that you've undertaken. Can you please provide an update on how many registration-related assessments TEXA has undertaken in relation to universities specifically in each financial year since 2017?
May I take that on notice, Senator? I don't have that information specifically to hand.
Do you have an overview of the information that you could give us now? I appreciate you might need to correct it, or, but I'm just interested in whether you regularly assess sexual assault and harassment as often as, for example, other parameters that you assess a university for.
Well, a simple mathematical approach, I suppose, on one level is that of the 188 providers who get re-registered on average, well, the requirement is at least every 7 years, but the average is probably more like 5. So we would be re-registering approximately 30 providers each year, that tends to fluctuate somewhat because of the cycle. In re-registering providers, we would be looking at around 30 a year, Peter.
Yep.
Standards 2.3, 2.4 and standard 6 in relation to student wellbeing, grievance procedures and governance cover off in each of those re-reg processes the issue of SASH. So that gives a rough indication, but I would like to take that on notice and give you a more complete and accurate response as well.
Okay. Professor Coldrake, you said small steps. You did speak about the need for changing hearts and minds, but then also small steps. Why does it only have to be small steps? How do we take the momentum from this report and not make it about small steps? Use the momentum of these many distressing stories to create change on campus.
I don't think small steps reflected in any sense a lack of ambition. I think it was a realistic assessment of how intractable the SASH problem is in workplaces everywhere, including in universities and our other higher education institutions. If we make steady progress, we should be comfortable about that. But it's not a question, we also know that you can have bold action and short-term improvement and things slip back. You actually want to lift the performance and keep it there and sustain the gains. I think small steps is a realistic statement. They might be big steps, but the progress will be gradual and might look like small.
Okay, and thank you for going through those issues with us today. I was certainly very distressed at that report. Just finally, on another topic, could I ask please for an update on your work on wage theft at universities and higher ed providers?
Sure. We might both have a go at this.
Sure.
No.
If it's required.
So, Senator, we wrote, I haven't got the dates in my head, but we have written in the last 2 years on at least 2 occasions to providers, including fairly recently. We've actually had webinar activity. It's been a subject of major discussion. You're aware that a number of institutions were identified, and the response was, I would just say, was uneven initially.
Yeah.
But also there was some exemplary behaviour by some institutions which had not been identified as having an issue, and which voluntarily who through their own good management and governance, identified that they had an issue and dealt with them.
So what does wage theft look like in the university sector? Is it unpaid hours? Is it the nature of casual and sessional work, meaning you're paid for a tutorial but not all the attached hours? It's characterised in different ways. What have you found that it looks like?
Well, it's arisen in a couple of ways historically. I'm relying on my knowledge as a Vice-Chancellor. It typically arose when enterprise bargain arrangements changed. It might have arisen through poor record keeping or inconsistency between systems, and it usually involved professional staff, and casual staff were a particular target, and a particular target of the Fair Work Fair Work Ombudsman's role, and we've been supporting the Fair Work Ombudsman and have done joint work with providers on the issue. So I think that the awareness level and the engagement with it is now strong. A number of institutions that pushed back initially have actually come forward and have actually returned significant amounts of money.
Are there any institutions still resisting the definition or the finding of wage theft?
Perhaps a question should go to the Fair Work Ombudsman for a more authoritative answer than what we could give, but I think that the unevenness of response initially is no longer the case. I would be very, very confident, mainly because a few weeks ago we exhorted them in strong terms. I'd be very confident that every governing body of every university would be aware, and I would hope the governing arms of other providers as well. But the big numbers are on the universities, so that's where the biggest area of problem has been.
Okay, and do you have any idea what the what kind of quantum of money people are owed?
Well, there have been figures for individual institutions of 8 million, 9 million and lower from large institutions. So I don't have a reliable accumulation of what that is, but they're significant sums of money, and institutions have come forward, and they know perfectly well that the matter's being dealt with by the Fair Work Ombudsman. We've been working in harness with them, but they're the lead agency.
Sandra, I met
Thank
with
you.
the Fair Work Ombudsman on this point as well, who's indicated that universities are taking the matter very seriously and working closely with them on the issues.
Well, they are now. Yes, thank you. We're now happy to move on to ACARA, and I want to thank TEXA for appearing today.
Thank you very much.
Thank you.
So you are all released. And we are now going to move to ACARA, who I believe are here. They look like they're in the room, so... Okay. Well, let's that'd be great. I'm not going to hold you up, please.
Well, maybe a little bit after.
All right.
Let's not go too much. I'll try and be quick.
Okay. Sounds like a plan. Okay, if we're all ready, I welcome officials from ACARA to the table. Mr. Di Carvello or others, do you have an opening statement?
No, Chair.
Thank you. I'll go straight to Senator Pratt.
Given the delays getting the Australian curriculum reviewed, can you please talk me through the process of implementing it from here and when you expect it will be fully implemented in the classroom?
So we expect that from the time that the curriculum is fully published in the manner in which it is meant to be seen on the new Australian curriculum website, it will be at that point that schools will really start familiarising themselves with the new curriculum. Many jurisdictions and systems are gearing up for a range of preparatory activities. We would expect that some jurisdictions may be keen to begin implementing from the start of next year. Other jurisdictions may wish to take a little bit longer in terms of their familiarisation. Our hope would be that by the start of 2024, all jurisdictions would be adopting and adapting the Australian curriculum to suit their circumstances. But the time frame for implementation is a matter for jurisdictions, Senator.
How does that compare to the original timeline?
Sorry, I'm not quite sure. Do you mean with the original Australian curriculum or...?
Well, I've got the content review. By the end of 2020, it was progress report to the Ed Council. 2021, refresh existing work samples to align with revised curriculum. Start of 2022, the curriculum goes live. Where are we up to compared to that?
Yeah, so we're approximately one school term behind on that, Senator.
Okay. Is any support being provided to schools, all school systems, to assist with the rollout of the curriculum? It's a time-intensive task for teachers.
So school systems are responsible for implementation, and as I said in my initial answer, many of those systems are already gearing up to prepare their teachers for this. We have a much more limited role in terms of implementation. As you've quoted there before, Senator, you made reference to the development of work samples and illustrations of practice and other support materials. However, most of those things, for example, work samples, which are examples of student work which are either at the standard, the achievement standard, or above it or below it, we can't actually develop those until the curriculum is in the field, so to speak, and students are submitting assessment tasks in relation to that curriculum. But we are going to be moving ahead with development of some support materials, particularly in relation to further work on consent, and I might ask Ms Foster to provide some further details.
We will be developing support materials for deep time history, which was introduced in Year 7, which is new content. We will also be working with the department on developing up support materials for respectful education and consent, which is also new into the curriculum.
Okay. On April 1, the Minister press release said that ministers were going to consider continuous updates to curriculum so that a more iterative improvements can be made in the future. How will that process work?
Well, that will be the subject of board consideration in the next few months, Senator. What we are going to be doing, and it's not unrelated to the additional work that we're going to be doing in mental health. We'll undertake a process in close collaboration with the Mental Health Commissioner to look at how we might be able to highlight further aspects of mental health in the curriculum, of course, without overcrowding the curriculum again. We think that through that process there'll be some learnings around a slightly different approach to iterative amendments to the curriculum going forward, as opposed to once every 6 years big bang approach that was undertaken this time around. There will be a number of options that we'll look at, that we'll discuss with the board and probably bring back to ministers towards the end of the year in terms of further options for looking at more iterative approaches.
How will you ensure a process of updating the curriculum in that iterative sense remains arm's length from political interference?
Well, I'm not quite sure what you're referring to in relation to political
let me put it
interference.
this way. If there's a group of people who don't like something in the curriculum, what's to prevent them continuously campaigning to change the curriculum?
So we can look at the process that we've actually just gone through. I think we can safely say that there have been and will continue to be a range of stakeholders who won't be completely satisfied with the final iteration.
Well, but is this an iterative process, therefore a green light for them to saying, well, we didn't get what we want, but we're going to ask every...
Again, Senator, it's a bit too early to speculate on that because the board hasn't yet considered the fine detail of what a process might look like, what the parameters around that might look like. So those are matters that will be obviously front of mind when the board comes to consider these options.
Okay, so they would have to consider things like, has it recently been considered, or is it new or emerging, for example, rather than as a way of saying, well, no, we've already addressed those, come to a decision in relation to those issues in the curriculum recently. Is there thinking that started around that already?
Yeah, so one of the things that will be key to a key input into the considerations for whatever process is eventually decided will be the monitoring that is undertaken by ACARA around the implementation. When you have a new curriculum, obviously it has to go into the field. We will be getting feedback, no doubt, from jurisdictions, systems, individual schools, but particularly teachers, because this is a tool, professional tool for teachers, and it will be their reflections and their experience on how it's implemented that will be very informative for us. So we need to take into account those feedback loops in deciding what might need to be amended. So it's that constant process of put the product out there into the field, get it implemented, hear feedback on how it's going. Are there any gaps? Are there any areas on reflection now that it's in the field, in schools, that teachers feel might need some refinement?
Okay, but it won't be a way of automatically revisiting something that was contentious.
Sorry, Senator.
It won't be a way of revisiting something that was contentious and because it's
Well,
a
again,
refinement and not a revisiting.
Again, Senator, it would be inappropriate for me to speculate on the process until the board has had a chance to consider the learnings of the work that we're doing on mental health and the learnings of teachers and systems in implementing the process.
So you've highlighted the fact that there'll be further revisions to mental health content. Can I ask specifically what revisions are being made to the health and physical education curriculum?
No, because they haven't been decided yet, Senator. That's the
Okay,
process
well,
that we're about to embark on.
What areas in the draft are still under contention?
So there was, the feedback that we got from ministers was very high level. There was a general concern from all ministers, particularly off the back of COVID and the student experience of mental health during the last 2 years, that they felt that a higher focus or a more tighter focus on mental health was appropriate. We have no stronger further guidance from them on that, so they have asked us to consult with further experts to zero in on where there might be opportunities for further refinement.
Can I ask if it's true that widely reported changes to consent education have not been finalised?
There is no intention to change the finalised content in consent.
Very good. Will the respectful relationships, and that won't be revised then either, I take those together?
So respectful relationships, I'm not quite sure what you're referring to. You might be referring to some support materials that have been developed by the department as opposed to the content.
They have been revised. What's being further revised in relation? So consent education's not being changed, but is the content attached to that being further revised? I know there's a previous iteration that was withdrawn. Where is that up to now?
Well, I might have to defer to Dr Baxter unless Ms Foster has some further information.
I'm happy to certainly provide what Education Ministers agreed in relation to that at the relevant meeting. So at the meeting prior to this most recent meeting, where Education Ministers agreed that components of the math and HASS curriculum would be further looked at, there was unanimous support for the consent aspects of the HPE curriculum. And when this last endorsement happened on 1 April, ministers were very clear that that shouldn't hold up the curriculum. So the HPE curriculum as it stands, with that consent components that have been widely endorsed as being very positive, were in fact received accolades, and I think mentioned in the media release as well.
Okay. In terms of the mental health content, Can you be more specific about what the issues are and what's the process for finalising those revisions?
So, Senator, I'll just, I guess, reiterate the statement that I said before. We will be embarking on a consultation process with key stakeholders, including the Mental Health Commissioner, with a view to determining the parameters and the areas to focus on. That hasn't been formally decided at this point.
Okay, when will the revisions be implemented in the classroom?
Well, that will depend on when they're finalised.
Is there a timeline?
Well, we would hope to be able to work through that during the course of this year. Again, depending on the extent of them, they may be able to be implemented relatively quickly. But again, before we actually know for certain what they look like, it would be improper to speculate on timeframes.
Okay. I'm going to move on to some questions now about NAPLAN for my last bracket, about a dozen or so questions. At the last estimates, it was indicated that you're close to finalising analysis of the gaps that had widened up in NAPLAN results. What have you found?
So that analysis is still ongoing. I think we reported to the committee at the last estimates that we would be taking initial drafts of that work back to our board at its next meeting. And at that meeting, the board considered the work that had been done and asked for some further refinements. And we will be consulting further with our jurisdictional colleagues and our measurement experts before finalising that material. But it's progressing, Senator. Yeah.
If a gap is a gap, why does it need refining? Why can't you just give us that information?
Well, it's the nature
it's not a political filter, is it?
Yeah, it's the nature of the analysis itself and what you can interpret from the analysis that we're particularly keen to ensure that the analysis is accurate. And there are different ways of cutting the data. I might ask Mr Titmanis to go into a little bit more detail.
Surely we should be able to cut the data in lots of different ways so that we can debate those issues rather than so it is an accurate response?
Well, precisely, Senator. There are a number of different ways in which the data can be cut, but they have to be able to be valid and accurate, and that's the work that we're doing.
Okay. So you're not in a position to tell us, to give us some advice, some information about those gaps and what they are?
Well, other than the ones that we highlighted when the NAPLAN National Report was released in December last year, where there were clearly some growing gaps, particularly between, say, boys and girls in relation to literacy and numeracy. There were some concerning gaps in relation to the performance of students in urban areas as opposed to those in regional and remote areas. And of course, again, concerning gaps which appear to be particularly stubborn in terms of the performance of Indigenous as opposed to non-Indigenous students. But we are having a much closer look, as we indicated, at whether there has been a COVID effect, for example, between the performance of students from communities at schools which serve high socio-educational communities as opposed to schools which serve lower socio-educational communities. And there are a number of aspects to that. The index that we use to assess socio-educational advantage, known as the ICSEA, has 4 components: parent employment, parent education, the proportion of students at the school who are of Indigenous background, as well as geolocation. Cutting the data according to each of those is not a straightforward process, and ensuring that you don't draw incorrect conclusions from that data is a process that needs to be undertaken carefully.
When will it be completed and when will it be made public?
Again, Senator, these are matters that we will need to conclude with our board. We are close to refining the next iteration to address the matters that the board has asked us to, and then it will go back to the board at its next meeting.
Okay, so do we expect it in the first half of this year?
Without over-promising, I would say yes, we would expect it in the first half of this year. There is a question as to whether, the data from this year's NAPLAN results may be incorporated into that research as well, which may change the timeframes.
Why would we do that? Why wouldn't we have a look at the 2021 data now?
Well, as I said, we're looking at particularly at the issue of the COVID effect. The 2021 data in particular looks at the impact of the COVID impact in 2020. We've now had a second year of that, and there may be value in incorporating that as well. But,
okay, but Western Australia didn't shut down many schools. There might be a little blip there. There might be some impact, but I don't see any reason why we can't compare data from previous years in a state like WA. Why would we want to sit on the data?
Well, we won't be sitting on the data, Minister. We'll be, Senator. We'll be ensuring that the data as presented is accurate, reliable, and valid.
Okay, I would be concerned if we have to wait for 2022 tests to be taken, data to be assessed before we get and combined with 2021.
No, obviously, Senator, that, as I said, that's not the plan at the moment, but it may be an issue that arises.
Okay. In your national report media release, you refer to the gap between high and low socio-economic groups. What data is that based on? Is it parental education that you highlighted before?
I'll defer to Mr Titmanis to go into the detail.
Senator, we use both parent education and occupation to calculate that information.
My son hasn't done any NAPLAN tests yet, but does that mean that parents are individually surveyed at the same time their child does a test, or is it approximated?
No, what typically happens is when parents enrol students at school for the first time, there's a range of information that the school collects, which includes information about their education and occupation.
Okay. Can you please tell us all subjects and year levels where the gap in performance has widened for the socio-economic groups?
So a key question there, Senator, would be over what time period? So when we released the national report in December, we were having a look, I think, back at not just back to 2019, I'm just looking at Peter, but also looking further back to 2016.
Okay, so
that's a key question as to over which time frame you're
looking at. On what
basis
did you make the statement in the media release?
That would have been on the basis of looking back at 2016. Most of those because the
2021 results compared to 2016 results.
2021 compared to 2016.
Okay.
The difficulty with just looking back at 2019 to 2021.
I understand that. Right. Could you please list all subjects and year levels where the gap has widened between 2016 and 2021? Do you have any of that information?
Look, other than what's in the media release at the time, I haven't got that, but we can take that on notice. Senator, unless Peter's got it in front of him.
We can't hear.
Are you on mute, Peter?
I'm saying there's quite a bit of data. There's year 3, 5, 7 and 9. There's reading, numeracy, writing. So it'd be easy to do on notice that we...
Well, I'd like, if you're able, please, to characterise those gaps. So there's 3 for each year that the test is taken. Or can you give us an outline of what has widened and for what subjects and year levels? Just some examples, please.
Look, off the top of my head, I don't have that level of detail. So I'd have to just go back into the data to be absolutely certain that I'm not misrepresenting the situation.
But if you give me a minute, Senator, we can find the media release from 2020 from last year that does highlight some of those issues.
Okay. And what can you tell us now about the difference between 2019 and 2021?
So at the aggregate level at which we report the results nationally and at the state and territory level, there was no statistically significant change in the data between at that level. And it's precisely because of that the board has asked us to go a little bit deeper and attempt to disaggregate by a socio-educational community status to see if there is, within that averaging, whether there are any patterns over time. So obviously when you're averaging at the national or state and territory level, you might miss some unders and overs, with some groups increasing, others decreasing, but overall the average comes out the same.
Okay, so in that context, answer to question, I think it was 82, SQ2282, it was reported in that answer, the percentage of Year 9 students who were meeting the national minimum standard dropped by 0.3% over the course of the pandemic for students with university educated parents or carers, but by 4.9% for students whose parents or carers didn't finish secondary school. That's a 16-fold difference. You have, on the other hand, said that 2019 and 21, there's not much of a difference. Do gaps like that occur across other strands, domains or year levels of the data?
So could I just ask again, Senator, what report are you citing that from?
Not a report, it's an answer to a question on notice.
Oh, sorry.
SQ2282. I can try and get you the answer.
I know, I have it here, thank you.
Thank you. I'll give you a moment to read that.
So, just for Peter's benefit, in relation to the percentage of Year 9 students achieving at or above national minimum standard in numeracy, the percentage of students with university educated parents, carers was 98.7% in 2019 and 98.4% in 2021, a drop of 0.3 percentage points. For students whose parents and carers did not complete secondary school, the percentage was 87.8% in 2019 and 82.9%, a drop of 4.9 percentage points. So there are a couple of things here, Minister, and again I might ask Peter to talk to them. One is the issue of statistical significance in these percentage changes, but the other issue is the value, I guess, comparing mean scores as a measure. What we're talking about here is the proportion of students meeting the national minimum standard, and there are some measurement issues with that, which I might ask Peter to talk to.
Thanks. Senator, the national minimum standard is located at the end of a normal distribution, if you like, and at the end of the normal distribution, whether it's looking at the very high performers or the least able students, the size of the measurement error is very large. And because the national minimum standard sits quite close to the end of the continuum, it's probably not the best measure to be looking at when comparing year on year. So sure, that's what the data actually does say, but when we look over time, those figures do bump around, whether it's 19 to 21 or whether it's previous years. So it's probably not the most insightful measure.
Okay, can I ask though if gaps like that occur across other strands, domains or year levels of the data?
I'd have to go back and have a look at the data. I don't have it at hand, so if I could actually take that on notice.
Surely though, as the data manager for these results, you should be able to tell us a little bit about what you've seen between 19 and 21?
There are some 300 pages of the report, so it's not something that I can commit to memory.
And I think the other thing, Senator, is as Mr Timonis has said, we tend to focus for the purposes of analysis and our focus in terms of promoting in the public domain the movement in our plan of results. It's the movement in mean scores which is probably the better measure because of those measurement issues that Peter has identified in relation to the national minimum standard.
Can I ask in that context though, are you aware that in terms of the national minimum standard on that socio-economic gap is, you can see very clearly in that answer that there's a lower drop for higher socio-economic and a larger one for lower. If that is consistent across other strands, domains or year levels, then that would not indicate that there's just some kind of statistical deviation that can be accounted for in the data, would it not?
Again, Senator, I think we would need to look across all those domains. I mean, this specific question was in relation to Year 9 students in numeracy. If we were to see something similar across other domains and other year levels, that would be particularly interesting. But again, without having the full set of tables in front of us, it would be improper to speculate.
Is that one of your gaps that you're analysing that you're still waiting to have permission to report on and tidy up?
The gap between students, parental education, yes, definitely.
Yes. And what are the others?
We're looking at parental employment, we're looking at Indigenous status, we're looking at geographic status, which are the 4 components of the Index of Community Social Educational Advantage.
Yeah. Well, having done only a tiny bit of homeschooling compared to other parents across Australia, I can only say that it's not surprising that some student results would go down. It just reinforced my admiration for Australia's teachers, and I just want to put that on record this evening in that context. I think I'm done now with Akara, thank you.
Okay, we'll release officials from Akara. Thank you very much for your evidence this evening. And we'll move to the Australian Research Council. Are they in the room?
Yes.
Looks like they are, so we'll just keep going while they find a place. And just a note to people, we are, I believe, on track to push through here and seek to finish. We'll just defer the dinner break, if that's okay with Hansard. I'm hoping there'll only be a 30-minute at most deferral. But if we're all ready, Ms Zielke, welcome to this hearing. And I welcome other officials from the Australian Research Council. Do you, Ms Zielke, or anyone else have an opening statement?
No, thank you.
Okay, no worries. I'll hand over to Senator Pratt.
Thank you. Senator Reynolds, government senators recommended in response to the Australian Research Council Amendment Ensuring Integrity Bill, government senators recommend that the government commission an independent review of the ARC in light of broader concerns raised by stakeholders about the ARC and its governance and research funding process. Will the government be doing this?
Senator Pratt, I just might need to, if I can just take a minute and seek that advice.
Unless you want to ask Senator Canavan.
I will actually defer to Mr Zelke. Actually, I've got the answer for you. Thank you.
Thank you. Senator Pratt, can I just check you were talking about the outcomes of the ARC amendment ensuring a research independence bill? Did I hear you correctly?
Yes.
Thank you. Then, yes, the outcomes of the report from the inquiry have come out, but the hasn't gone back into, the bill hasn't gone back into the House or to the Senate as yet.
Okay, so the government is still deliberating on whether it will respond positively to that recommendation from government senators. Can I ask you, Minister, do you share the concerns of colleagues that elements of the Australian Research Council Act may no longer be fit for purpose?
Senator Pratt, this is not an area of my particular expertise. Give me a minute and I'll get back to you.
Okay. A number of stakeholders raised significant concerns about the ARC's governance and research funding during the inquiry. The Deputy Chief Executive of the Group of Eight said issues have come to light over the past few years and has been quite serious, revealing issues around governance and transparency, and called for an overhaul, with similar concerns being raised by the Australian Catholic University, Innovative Research Universities and the University of Melbourne. Can I ask what the ARC is doing to restore the sector's confidence?
Senator, and I should have said earlier, Judy Zelke, Acting Chief Executive Officer of the ARC. The ARC has a work program for it at the moment of reform in relation to the agency. It is also in response to the statement of expectations from Minister Robert in December last year. The statement of intent in response to that is up on our website and it lists that work program. But the key activities that we're looking at in relation to this particular issue are largely around areas such as reviewing the intent of the national interest test statement, as it's known, which is the statement that applicants provide to show national benefit resulting from their proposed research, and also working with the sector in relation to clarity around the actual process. So there are three elements to the assessment process. One is the peer review process, which is about ensuring the research excellence of the projects that are being submitted. Then there are two other elements. One is assessment of the national interest test, which is undertaken by the CEO. And the third element is the due diligence area, which also looks at foreign interference activities as well. The CEO puts those three things together and presents them to the minister. The veto is only, ministers have only not approved applications on the grounds of security or in relation to national interest, never in relation to the peer review process. So we undertook at those inquiries to make sure that we worked with the sector to provide clarity in those areas.
And Senator Pratt, I'd just make the point that the government is considering the report and it will respond in the normal way.
Submitters expressed concerns about the timeframes for ARC grant funding decisions and announcements. I note there's a lag of up to 3 months, and that was certainly borne out in the evidence. That's in terms of the time a recommendation is made by the College of Experts to the time outcomes are announced, and that particularly affects early career researchers and those on fixed-term contracts. They could be dependent on salaried roles that are supported by ARC-funded grants, What action are you taking to ensure more timely announcement of grant outcomes?
Thank you, Senator. In that same statement of intent, we also noted that we were undertaking a process review or root and branch review of our processes, and that will specifically look at improving our timelines and ensuring that where we can do activities in parallel to shorten the period of time applications are under consideration is as efficient as we can possibly make it.
So what's been happening in the time between the recommendation from the College of Experts and the announcement? Is that the point in time that it's handed over to the government for those other, for the veto or for national security or for other things?
So, Senator, the process that we have been utilising is where there is actually a group of assessors who undertake the peer review process. That then goes to a selection advisory committee that then provides a final view in relation to the excellence of the research. In addition to that, and some aspects of this are done in tandem, eligibility checks of the applications are also being undertaken, and then subsequently dealing with the national interest test and also the foreign interference type activities in that regard as well.
Okay.
Some of those things are undertaken at the moment in a linear fashion, and we're looking to undertake those in parallel.
Okay, so they would be parallel. So is it possible to start having more timely announcements in terms of when is this going to be fixed? Does it require a review? Are you going to be able to fix it quickly?
So we've got a number of measures underway at the moment. For example, we have just recently opened rounds in relation to discovery projects, linkage and LEAF, as it is known. And in conjunction with those, we are moving to consider those in parallel, so different aspects in parallel. And we're hoping, therefore, that that will make an improvement in our timing. In addition to that, though, we've also undertaken to work with the sector on continuing to improve the process, and that's the process review. So we're doing what we can as quickly as we can, but also very conscious of the fact that we'll need to continue to seek to improve that arrangement or potentially come up with new processes to replace them with.
Should there be a standard for reasonable timeframes for decision making on application rounds, recognising that careers, livelihoods and research outcomes depend on timeliness and reliability of the funding process?
Senator, good question in that regard. I will note that over the last 2 years, though, COVID has had a significant impact in relation to the timeliness of our activities. Assessors are, so researchers are submitting applications, other researchers are assessing those applications. So you end up with a cycle in relation to where we are reliant on universities and their staff to assist throughout the whole process. So it doesn't just impact at one level, it impacts at both.
Okay, so the ARC's open to the idea that there should be a standard set. Will you set that for yourself, or will you ask?
We actually come out with a period of time in relation to our programs that says what we think the expectation would be in relation to it. But as was raised over the last year, we've gone beyond those timeframes. So that's why we're reassessing them and trying to bring them, reduce them where we can.
Okay. The ARC Act hasn't been reviewed for some 20 years. Does the ARC think it would be timely now to review the Act?
We're going through a number of processes at the moment to actually look at our strategy as well as those processes, and there may therefore be opportunity to consider other aspects at that stage.
Okay, so what issues that you're looking at the moment would bring into play the need for a review of the Act? What kind of issues might have a bearing on that?
Senator, For example, the legislation at the moment, and noting that this would of course be something for government but came up as part of the inquiry, the Act at the moment requires us to come back to Parliament every year to seek agreement to our funding. Obviously, that's something that takes quite a bit of time, uses up a lot of resources. It shows the age of the legislation in that regard. So it's administrative aspects like that that I think would be what it is that we would be looking at.
Okay, well, it seems like a good reason to review the Act. There's no need to be burdened by out-of-date legislation, surely. Will the government commit to being transparent about the use of ministerial discretion and provide detailed reasons as to why government ministers veto individual grants?
Senator Pratt, that's an interesting point you raise, and my understanding of the circumstance is that certainly ministerial discretion is not unusual, and my understanding is the report.
It's been a pattern of behaviour established by
Senator Pratt, do you want me to answer the question,
well, my
or do you want to answer it for me?
Will the government commit to be transparent around the use of ministerial discretion and provide detailed reasons as to why
Senator Pratt, that's an incredibly politically loaded way you've asked that question. Let's get the facts on the record. This is not unusual, and in fact my understanding of the committee's report is that the committee didn't recommend that ministerial discretion in this case be removed. In fact, that was a position I understand that Labor senators supported.
Indeed, but
no, you can't have it both ways, Senator Pratt. You are absolutely making imputations about the minister. So let's get the facts, as I understand them on the record, is in the committee report, which the government is considering in detail, which, as you've just heard, there are some very significant issues that were in fact raised in the report that were agreed with on a bipartisan basis. That is under review at the moment. But one of the issues that was not raised was the issue of ministerial discretion, and which is not at all unusual, and the committee itself didn't recommend for that to change. So I think that's pretty conclusive.
Can I ask, what's the difference between the government's position on ministerial discretion and the right of veto and the Labor Party's position?
Well, Senator Pratt, I'll leave that in terms of what your own policy is and your own position as you're on the committee.
You were presuming that our positions were the same.
No, Senator Pratt, you were making some very clear
I'm not.
imputations about the minister. And you were actually also, I think, coming very close to misrepresenting what the committee report actually said.
What was the imputation?
The committee report did not deal with the issue of changing ministerial discretion, and that was agreed on bipartisan. Well, it just wasn't mentioned. So, you know, it's pretty clear. So I'm not quite sure what you're asking, Senator Pratt. Perhaps you want to re-ask the question?
Let's be clear. Labor senators supported a recommendation that the minister should be required to table in Parliament a clear and detailed reason for the decision to use a right of veto.
But Senator Pratt,
that is my question.
Okay, now thank you, but you can't again have it both ways. If the committee itself did not make a recommendation that ministerial discretion should be changed, Minister Robert is very clear and transparent about his decisions.
I require...
Sorry, Senator Pratt, if you've got a point of order, you can raise it with me, but otherwise Minister Reynolds had the call.
So now you're trying to add some new requirement when the committee report itself didn't make those recommendations.
No, okay. Senator Reynolds.
Yep.
Is it true that Labor senators supported a recommendation that asking the government to commit to be transparent about use of ministerial discretion and to provide detailed reasons as to why a minister may veto individual grants? Did coalition senators support that recommendation?
Senator Pratt, I think you'll have to unpack that a bit further. So are you talking about the Greens Are you talking about a Greens piece of legislation? Or
Yes, but that's not actually what this is about. It's about the
what is it about, Senator
recommendation in the report that said in response to that legislation, but frankly, in response to many debates that have taken place before this committee now over many years, even before that bill. Can I simply ask, when the government uses its right of veto and ministerial discretion in relation to an ARC grant, why does it not provide detailed reasons as to why a grant was vetoed?
Pardon? We do. Well, that's why I'm confused. The minister does.
Well,
So-
they're not
so- but
particularly,
again,
they're short
you're making-
statements, they're not detailed in terms of...
Well, Senator Pratt, you just made an assertion that the minister wasn't transparent and didn't do that, and we've now confirmed that the minister does. So it's really not very clear what you're asking.
Does the government consider that the information it provides when it vetoes a decision of the ARC's processes, does the government consider that the level of information provided to justify its veto power on an individual grant is reasonable and adequate?
Yes.
Okay. And that is enough to cover up and avoid accountability for political interference in the research system based on...
Thank you.
That was highly inappropriate. It was an allegation based on absolutely zero fact. I don't think even in the evidence that the committee heard, anyone was implying that it was anything more than ministerial discretion. It wasn't based on any political or partisan politics.
Well, look, that's a debating point.
That's
it's not
very
a point
much
of
a
order, but
debating
it would be
point.
helpful, Senator
But
Reynolds,
can I
at this
just
hour.
ask-
Sorry, Senator Pratt, at this hour, if we could return to questions rather than commentary.
Okay.
Minister,
Can-
Minister, sorry, the Minister. Did you
Look,
want to-
thank you very much, Chair. And could I ask Senator Pratt to withdraw that last statement, because it was highly inappropriate in terms of what the allegations she was making about the minister's conduct. And as Senator Davey has pointed out, it was completely without foundation.
Well, I'll ask Senator Pratt, would you like to withdraw for the helpful of harmony here in the committee?
I think I said, I'll just withdraw it. Clearly...
Okay. All right, we'll move
No.
on. And so you have the call, Senator Pratt.
Okay.
Thank you.
So numerous submitters criticised the level of transparency and detail provided by the minister and called for a detailed statement to be made to the Parliament. Is that not correct? I'll ask the ARC. You would understand the evidence that was provided.
So yes, Senator, the recommendation from Labor was to seek that the minister table within 15 days reasons, evidence and advice received when discretion is exercised.
Okay. Can I ask, Minister, is a statement that something is not in the national interest a detailed statement without providing reasons for that being the case?
Senator Pratt, I've been very clear that the minister is entitled to exercise discretion. The committee has not recommended that situation change. He does provide reasons, and very clear reasons, and that is entirely appropriate.
Okay. If you've got an ARC grant on arts in China and an ARC grant on climate change, and they're both vetoed on the basis of national interest, how is that a clear and detailed description that's relevant to the grant if the answer simply says national interest?
Senator Canavan, Chair, I think that is a complete hypothetical.
It's not hypothetical, that's pretty close to the kinds of topics that were
Well, pretty
vetoed in
close
the
is,
last
but no,
round.
so pretty close again doesn't cut it, and
No
it is a
further
hypothetical.
questions.
Okay, all right, thank you. We might just not rule on that then. We'll leave that as a commentary. So that's Senator Pratt. That's no more questions. Any senators for the Australian Research Council? Well, I thank you very much, Senator Pratt. Thank witnesses from the Australian Research Council. Thank all of the departments and officials that have appeared today. We are adjourning the committee this evening, and we'll return tomorrow morning with the Department of Education, Skills and Employment. Thank you very much.
Thank you very much, Chair and committee members.
Thank you.